Okay, thank you. Welcome to the second hearing of the inquiry into the Aboriginal Cultural Heritage Culture is Identity Bill 2022. Before I commence, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past, present and emerging and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the land and waters of New South Wales. I also acknowledge and pay my respects to Aboriginal and Torres Strait Islander people joining us today. The Parliament has asked this committee to do an inquiry into a private member's bill called the Aboriginal Cultural Heritage Culture is Identity Bill 2022. This bill is separate from the cultural heritage reforms that the government has been working on over a period of time. I acknowledge the short amount of time the committee has had to examine this bill and get the community's views on it. I acknowledge that this is not desirable. The Parliament has told the committee that it must publish its report by the 8th of November 2022. The reason for this deadline is the New South Wales Parliament will meet for the last time in mid-November before the state election in early 2023. Today, we will be hearing from a range of stakeholders. First up, we will hear from government representatives. We will then hear from representatives of various organisations with different perspectives, namely farming, mining and environmental protection. We will also hear from individual community members, including the Darawal elders from the Walgett area and community members from the Armidale area. The day concludes with a public forum. The committee is grateful to all the individuals and organisations who have made themselves available to appear at today's hearing on short notice. We thank everyone for making the time to give evidence to this very important inquiry. While we have many witnesses with us in person, some will be appearing via video conference today. And I ask for everyone's patience through any technical difficulties that we may encounter today. If participants do lose their internet connection or are disconnected from the hearing, please rejoin the hearing by using the same link as provided by the committee secretariat. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The proceedings are also being recorded and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have the right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Due to the short time frame for this inquiry, we ask that written answers to questions taken on notice are provided within 7 days. Finally, for those participating in today's hearing via video conference, can I please ask everyone to state their name when they begin speaking, to speak directly into the microphone and to mute their microphones when they are not speaking. In terms of the audibility of the hearing today, I remind both committee members and witnesses, please speak into the microphone. And finally, could everyone please turn their mobile phones to silent for the duration of the hearing. I now welcome our first witness. Could you please state your name and position title and swear either an oath or affirmation?
Thank you, Chair. Mr. Jeffrey Winters, I'm the CEO of Just Reinvest New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And would you like to start by making a short opening statement?
Thank you. Thanks for inviting Just Reinvest to speak. I also acknowledge traditional owners and pay respect. Our involvement as an organisation or interest in this bill comes merely in two forms. One, to see great and excellent public policy made by this place, which we think this bill is. And secondly, because of the nature of what we do, having a framework whereby Aboriginal cultural authority can be enshrined is deeply in our interest. Just Reinvest works with Aboriginal communities across New South Wales to identify ways that interactions with the criminal justice system by those communities can be reduced. And then we work with the government, primarily Treasury, to figure out how the savings made by those reductions of interactions with the criminal justice system might be returned to community hands and put into programs that they think continue to make that community stronger and safer. In places like Burke, where most people tend to know the work of Justice Reinvestment, that involves the identification of a community elders group or a tribal council, as it is there. In a community like Burke, where native title is not a settled issue, where the existing land council may have limited capacity or interest in providing cultural authority, we are deeply interested in seeing how state legislation might support a tribal council like that to step into the cultural authority that they clearly have. In other places, like Moree, where we're also working, where there is probably in the next few years likely to be native title determined, where there is a highly functioning land council, we as a group get to enjoy those two structures and see how they might interact together. Obviously, that's leading me to the point that our greatest interest in the bill is how the balancing act between existing legal interests, such as native title or land rights, might sit alongside each other neatly, consistently, but I suspect very differently and divergently across the state, to support a uniform blanket protection of cultural heritage. I should flag before we go further, I've practiced as a land rights lawyer and native title lawyer for about 7 years. I did previously advise the department in 2018 on its last draft bill when I was a solicitor at Chalk and Berrend. So my knowledge of the last bill compared to this is somewhat notable, but please don't go to too many detailed questions. But on that, I'll leave it to the committee to ask some questions.
Thank you. Are people happy for me to go first?
Yeah,
we didn't talk about it. Thank you very much, Mr. Winters. Can I just ask, I think you've touched initially on the very thing that we've, had evidence brought to us around how perhaps the balance does work or doesn't work, or how the bill is trying to strike that balance. So far, we've had quite a degree of input about the native title claimants, applicants, holders and recognised native title applicants, the land councils and Aboriginal owners. In your experience, is there how do we make sure that no voices of cultural authority are left behind?
The task that you've set out to undertake is, I think, probably the most complicated legal question in this state. It's a question that doesn't exist in any other state because of the Land Rights Act here in New South Wales, which obviously the Reverend was heavily involved in passing back in '83. Because of the rights and interests it created, it does put Aboriginal communities in a very complicated position. There were times where, in my previous role, we would be acting for a land council group whose interest is to have the court determine that native title doesn't exist over a piece of land so that they could assert their proprietary rights over that piece of land. I can think of a particular parcel of land on the North Coast where the same people who were the land council board were also the registered native title holders. So for them to access the rights and interests they're provided for under the Land Rights Act, they actually have to go to court and have the court tell them their native title rights don't exist over that piece of land. That just shows you the peculiarity of this situation. In '94 and then in '97, the federal parliament was trying to deal with this issue, and they took what is considered a pretty backdoor, get out of jail, leave it to New South Wales to deal with approach, which was saying all land rights in New South Wales will be subject to native title. And really the federal court and the High Court haven't ever figured out what exactly that means, but it's pretty generally accepted that the rigour and the nature of a right in native title that is created is the primary right of cultural authority. So where there is native title, it can be determined by the court. That is the greatest and most clear claim to cultural authority over the land. The lesser known Aboriginal owner scheme under the Land Rights Act sits, I think, alongside, but perhaps slightly below that, in the sense that the rigour, although I must say the department's getting very good at this, and if you look at the cheme botany process being undertaken, it shows the rigour, but it probably sits as the next tier of rights that can be identified in any clear way. What you're then left with is, what about a situation where there's no native title, there's no Aboriginal owners, you've got a land council? I've always asserted at that point that is a clear legal structure. While it's, I think, less culturally sound than native title, it's probably as good as you can get in that situation. Where you don't have a land council, it's a whole different question, and I don't think we need to get into that. Balancing those three voices is really difficult and really complicated. But you've probably had other organisations say, well, land councils must always be in the conversation. And other groups, native title groups, say, well, land councils don't have a right to sit at the table automatically. And that's really the tough question. I think where native title exists, they have to be the cultural authority. There can't be a question about that. That's what native title is. It determines that there's an ongoing connection of a rigour that can't be challenged under any other legal structure. Where that's absent, which will be pretty prolific in New South Wales because of how successful the colonial project was, we do have a land council structure there as a safety net. And the reason it works and the reason it's such a unique scheme is that it recognises that lots of families, communities were moved off country and just don't have that connection anymore. And will never, therefore, be able to assert a native title right. But they're captured in a way that recognises their connection to the state generally by being able to join a land council. And so I think while it's an imperfect way of getting a connection or developing a cultural authority framework, it's certainly one that works, and it's certainly worked for a long time, and is a great safety net where native title doesn't exist. Getting them to play nicely together is a near impossible task. I don't think the first time we put a bill through, you'll get it right. I think the provision that deals with priority will be amended many, many times over the years any cultural or heritage legislation is in power. So I actually think the task for the Parliament at the moment is to get that first framework, that first bill in and passed in as good a form as you can, and then go on the journey with community of figuring out how do you make sure those two interests are balanced appropriately.
Thank you.
Can I just follow on from that?
Of course you can.
You talked about, so there's different ownership or claims on different areas. Is it clear what the structure is in those different areas?
Yeah, so it is. If there's a native title claim that succeeds, it triggers a whole set of provisions that organise what we call prescribed bodies corporate, and they're very clear structures. The native title process is both expensive and lengthy because you go parcel by parcel by parcel, and you identify what the right and interest is over every single parcel, and where it's excluded and so on. So schedules behind native title determinations are these huge sets of maps. They're the most boring sets of documents you'll ever turn your eyes to. So it's really clear what the right and interest is. How the land rights, so the state land right then sits alongside that, is clear because of what is excluded and what isn't. And then if you've got just under the state system, land rights at large, it's a private property right. So identifying where a land council boundary is and what parcels of land they have control over within that, it's just like identifying what land you own. It's very straightforward. There's got reasonably strong, rigorous board and governance structures around the organisation, the local Aboriginal Land Council. You've got an office of the registrar, and I believe Shane Hamilton's speaking later today. So that sits within that department, and there's a lot of rigour and support provided to ensuring the land councils, are functioning and are safe and good corporate citizens, if you will. And then where you've got nothing, that's where the greyness is. That would occur in very limited places around the state, I would think. And where that does occur, I actually think it is just an opportunity to lean in to those few instances and try and figure out what the appropriate structure should be. I mean, I think in the current draft, by having the state level body appoint the local authority, that will be where that exercise takes place. But otherwise, I think if you've got it clear that native title holders are the cultural authority where they've got that, otherwise Aboriginal owners, otherwise the land council, and or perhaps a combination, because there will be, you draft legislation envisaging the worst case scenario, right? There are going to be many, many instances across the state where the native title holders are the same people as the land council and are very happy to draw up a framework of governance around that.
So, sorry, just put in my words, you could very clearly point to a location and see who the highest authority was in that ranking that you mentioned there before.
Just on that, if you don't mind, Chair, some of the evidence that we received at our previous hearing, was consistent with that broadly, but there was this particular issue where there was no native title holder. And so we are talking about the cultural authority of land councils. Yep. And there was, quite a bit of evidence we received from different parts of the state that there were local groups who certainly saw themselves as cultural authority holders who did have particular, I'm trying to use the right word, pushback concerns with land councils. And so I think, and that's actually potentially quite a large category here, because as you say, native title holders recognised by the court, quite a limited number. These areas where there are land councils in operation, but potentially also local groups who don't necessarily accept the authority of land councils. We did receive quite a bit of evidence, and some of it quite passionate on that point. So I guess I just wanted, your reflections on how we, as, to be honest, white people who want to be respectful of privileging First Nations voices, but there is clearly a conflict there, might respond to that.
It's difficult, Take Burke, where we do a lot of work. There is a land council. It's got a clear membership, a clear leadership, but there is another group, the Burke Tribal Council, that would probably assert itself as being the genuinely reflective cultural authority group, and we back that as an organisation. That's probably a more straightforward example than, say, somewhere where you've got small groups of family members asserting cultural authority, and it's these are often very senior Aboriginal people with extremely complicated circumstances, and it's not always straightforward and easy to understand exactly what the right or authorities they are asserting. In those instances, I think you've got to be really careful to become the arbiter of what is going on in community. I think with legislation like this, you're only going to get it so right, and I think it's really high risk but high impact legislation. And I guess it's up to the Parliament and yourselves to figure out what's your risk appetite with this one. There's a reason it hasn't been done yet. In 2018, when the government was trying to get it through, it basically came down to this exact question again. And I think what occurred there was there wasn't an appetite to basically say, okay, we'll accept this as good enough. There was an expectation that community would go away and get complete consensus. I remember sitting in a consultation for that bill and some elder very cleverly leaning across to the then minister saying, well, you don't have to get consensus in the upper house to pass a law, so why should we have to get consensus to get a law that protects us? And there's something in that. So I think you've got to grapple with what's the risk appetite in terms of getting a big and important piece of legislation done. You can only create a framework, and then it's up to community to sort it out. And as I said earlier, Chair, I think whatever legislation first lands and goes through Parliament, whether it's this bill or perhaps one down the track, it will go through many iterations, the provisions that deal with how do you identify who's there.
Thank you. Ms. Sharp.
Yes.
Oh, sorry.
Thank you.
Reverend, and then Ms. Sharp.
Yes.
Thank you.
Can I ask my question?
Yes, please.
Okay. Thank you very much for appearing before our inquiry, Mr. Winters. My question is very simple. Could you outline the core differences between Culture is Identity bill, my bill, and the government's Aboriginal Cultural Heritage 2012 draft bill?
Thank you, Reverend. For me, there are three key differences. The first is the protection of how you deal with state significant development, and this has always been a big issue. Not surprisingly, and I'm not in any way criticising the government, because I suspect a bill brought forward by the opposition probably has the same provision in it. Government bills over the years, as they've been proposed, don't tend to protect state significant development, because I suspect the planning department writes a very nicely worded letter to them when they put up their first draft and say, make sure that's not in there. And that wasn't in there in 2018, it is in your bill. I think if you're actually serious about protecting Aboriginal cultural heritage, you say it's not destroyed, harmed, or impacted without the community's consent, no matter what the project is. And that's what your bill does. Like I said earlier, the reason this bill is a great opportunity for the Parliament is that it's really hard and really messy work, and it's often the only work that can be done by an independent or a crossbench member, bringing it into the Parliament and the major parties sort of letting it happen. The current government has tried and not got a bill through. No doubt the Labor Party, if they were to form government, would try as well. It's really hard work, I think, when you're the majority party to do it. And so a provision like that, I think it's Section 11 of the new Act, of your proposed bill, sorry, Reverend, is a great example of why this is a perfect piece of work to be done from the crossbench. The others are very straightforward and, again, probably linked to the nature of who's proposing the bill, the role of the minister. The new bill proposes a very limited role for the minister in the appointment of decision makers and various office holders, and the removal of office holders, I should say, whereas it was quite the opposite in the previous bill, quite a heavy hand for the minister in appointing people and being able to remove them. And then I think the last point is this idea that, well, there's a couple of bits on the membership and composition, giving that autonomy to the authority to appoint local services. The identification of a gender balance is one of those weird little novel ones that I think shows a little bit more nuance and thoughtfulness about this bill. But for me, it's just those couple of elements pulled together, the reduced role of the minister, the protection of cultural heritage, even where it's state significant development, and the autonomy of the authority.
Thank you.
Ms Sharp.
Thank you. Thank you very much for coming today. You've touched on some of the issues that I was going to explore with you, which was really why you think 2018 process has fallen over. So, you know, I mean,
I'll try my best without traversing into...
Well, I know you've been quite involved with it, so I'm
Yeah.
interested in your sort of reflections about that.
So the piece of work the firm I was with at the time was asked to do in 2018 was to take the bill and put it into a plain language format to take it to community. And when you do that, you start to very quickly see how things actually operate, or will at least be perceived to operate. And when you put a provision like, where a project is deemed to be state significant development, no cultural protection is afforded, into plain language, community get a little bit shitty about that. And you've lost them, I think, at that point. When you start talking about ministerial power to appoint and remove members, community starts to perceive it as being a bill that's for the government, not for community. And I think it is really hard work to do this type of reform, and I don't envy a government minister or an opposition minister having to consider this. But it's probably the right thing, you know, ethically, and if we're really committed to the purpose of the legislation, for this not to be ministerially heavy, for it to have more autonomy, and for all projects to be subject to its protections. And for me, they're the three big differences. I completely understand why government of the day might not want to see those three elements in a bill, but I think objectively, when you step back, it's clear, you know, as a person who lives on Gadigal country or wherever you might live, who knows that, you know, what has gone is horrific and dispossession is writ large in New South Wales, that those three things probably don't belong in cultural heritage protection law, that it should be autonomous, the authority, as much as it can be. It should not have the minister appointing and removing members, and it should mean that every bridge, tunnel, hospital, school also must go through the same process of being, you know, surveyed, any, you know, heritage identified, and any destruction authorised by the relevant person. But like I said, Penny, it's really hard legislation. I don't envy the exercise, but I think the fact that the committee's going through this process shows that there seems to be a very genuine commitment to exploring whether this is the right vehicle, the right bill for the state. My encouragement would be to do it. I think I said to one of your colleagues in a meeting, why wouldn't you let this bill go through? Because you probably don't want it on your list of legislation to get to if you form government after March. I mean, it's really complicated.
And in terms of the state significant development, which seems to me to be a massive hurdle, not from Aboriginal people, but from government and basically the development industry. How do other states deal with that matter? Do they have, are there other things we can point to that work better?
So there are. I'll try my best to answer this and not go to taking it on notice. But there are national guidelines that have been developed by the federal entity. I think it's the Australian Heritage Council developed some national guidelines. I believe Rachel Perkins in particular did a lot of work on that type of provision in the guidelines. I'll point to a bad example. If you look at WA, who initially did produce some pretty rigorous cultural heritage legislation, after the catastrophe over there, the new bill that they brought in actually handed more power back to the state, particularly in the guise of state significant development. And that was seen as a huge step backwards in a state that to that point had positioned itself as a leader of this sort of reform.
Sorry, are people okay if I ask another question?
Yep.
Could I offer just one more comment on that point? I guess also the sector, when I say the sector, the development industry and construction sector, doesn't need to think of cultural heritage protection as a blanket no on where it exists. This provides a framework whereby damage and destruction can occur to culturally significant spaces, but it's done and managed with the authority, the Aboriginal Community Authority, working with them in partnership. So I think it should be viewed as an opportunity to do development well.
One of the things that has been suggested to me is that the cost of the 2018 arrangements, because of their complexity, was also a problem. Do you see that as being an issue?
It certainly was in 2018. I can't recall precisely how it was dealt with, but when the standalone entity, so there was a state entity that was proposed originally, was put up, there was a figure, and I'll forget it, but it was towards $100 million effectively to get this all up and going. And multiple departments, I recall, sounded alarms at that, if not at least the Finance and Treasury Department. I don't know what the costing is for this legislation, but I don't think you can put a price on cultural heritage.
Thank you. Can I just ask? Oh, thank you. Are you done, Ms. Sharp, for now? Yep. Can I just also ask, there's been some suggestion, and you touched on it briefly then, about the idea of harm protection impact being ultimately a negotiation, a discussion, and something that First Nations people have control or say. At the moment, there's a suggestion that where native title exists under the Iluas, that is already an arrangement that's taking place, and on some voices, including non-Aboriginal voices, there's been a question of this law shouldn't seek to interfere with that. What's your view around that?
So the Constitution deals with this straight up. I'll go from the principle to the specific. Obviously, a state law cannot be inconsistent with a federal law where it covers the field. And I think the Native Title Act and the provision for Iluas, I think it's in like Schedule 3 or 4, probably would be viewed as covering the field. I suspect the High Court's already said that. And therefore, wherever the state law purported to kind of go into that realm, it wouldn't be allowed to. So that won't occur. I saw in some evidence given a suggestion by native title holders and groups that this legislation tries to water down some of their rights and interests. In principle, that just can't occur. This legislation cannot be inconsistent with those rights and interests, and it certainly can't negatively impact them. If anything, where they were considered to sit alongside each other, you would think that it strengthens their rights and interests and gives them another, weapon in the armoury, if it were. Say you've got a determined native title claim, you've got an ILUA, you've got your prescribed body corporate, you would be entitled to the relevant compensation for any damage and destruction under the federal laws, and then whatever framework was established under this law would also be a further protection. So I don't think that argument really has legs, and I'm not quite sure where it's come from.
And so with that, I mean, the Iluas are apply to those once Crown lands that are recognised and have been determined as native title, you know, the grant of native title over those lands. So I suppose this regime sits side by side on those particular areas of land, including private lands, where there's no such agreements in place. So is that your understanding of how this would work together as well?
Yes, I think so, because remember, under the Ilua arrangement, and I mean, it depends on the rights and interests of the particular native title group, but speaking in generality, the right is to compensation for various acts that were or are to be done on the parcels of land, and that's monetary compensation. The framework here doesn't go to monetary compensation for destruction, although there's obviously a way in which, you know, the local authority is a forfeit user pay sort of scheme. That this scheme is to designing the management of proposed destruction. The Ilua compensation is around protections and compensation for actual destruction. So there's sort of a proactive and a reactive scheme that you would see sit alongside each other, is how I think it works in my brain.
I suppose one of the differences that's been raised is that, you know, the Ilua process generally isn't seen to have a sort of right of veto, whereas the interpretation of these laws are that it could be seen that there's a right of veto.
Yeah, it would be seen that there were. So where my reading of the last draft I saw is that where there is the identification of a culturally significant landscape or place or space or whatever it might be, and it triggers the provisions, you have the local authority determining, you know, what is considered to be the appropriate either slight destruction or damage, if any, or to say no, actually, the veto power can be exercised. That you don't have that right under an Ilua. Also, while there are lots of Iluas across New South Wales, they generally relate to very small parcels of land that are not necessarily the types of parcels that I think this bill would go to protecting. And that's what I mean. I've sat in Ilua negotiations where you're talking about what you call a paper town. So it's a paddock that has, you know, lots and DPs, but they obviously don't exist. And you go plot by plot by plot, and you'll have 20 Iluas on a paddock outside of Cara. But I very much doubt anytime soon, apart from perhaps mining, but then again, there's other ways in which that's dealt with already anyway. These really aren't the parcels that I think the bulk of this legislation's purpose is directed towards.
Can I,
Yeah,
might
of
I
course.
jump in,
Ms. Jackson.
Chair?
Thank you.
I just wanted to ask, this is perhaps a kind of bit specific question, we're getting into the weeds a little bit here with this question, I accept, but I thought I'd just, as it has been raised by the witnesses, I thought I'd just sort of seek your feedback. One of the things that has been suggested is that there is no provision in the bill, either in the advisory council or in terms of, you know, giving a role as someone who has cultural authority to native title claimants. And, you know, particularly the representatives of the native title holders who appeared suggested that, as you say, it's extremely difficult to actually have a court-determined native title ownership, but that there were perhaps quite a large group of claimants who were in the process, the lengthy legal process of trying to establish their native title rights, and that perhaps there may be a way to include those voices in this process as well. I just wondered if you had any feedback on that.
No, that's a really excellent question and suggestion. So I think what the proposal would be is that you draw the line at saying the first priority is a native title holder group, prescribed body corporate, where you've got a registered claimant group, which is, you know, just to register a claim in the federal court is a very lengthy process, and it's where anthropology and all of these kind of identification of family groups goes on. That's just to start the native title claim. It could be many years later before it's determined, that you'd let that group fall into the order of priority. I don't think there's necessarily anything wrong with that whatsoever. It certainly would suggest that that group have a more justifiable cultural authority over a space than, say, to be crude, any old member of a land council.
Yep. Ms. McDonald.
You may have answered it. Good morning. Sorry, and apologies for being late. In this bill, does the meaning of Aboriginal cultural heritage, does it satisfactorily cover what you would define as being Aboriginal cultural heritage, or would you expand it? Or?
It's a very good question. And I understand you're from Moree, is that right?
I was in Moree on the weekend.
Yes, you spoke to one of my staff members.
Yeah,
She said,
yeah.
it's lovely to meet you.
Yeah.
This is another difference between the 2018 bill and the bill that you've got before you. The way it talks about cultural landscapes, which are, if you go and look at native title law and the way it's developed, obviously the earlier cases are very, old-fashioned ways of considering anthropology in connection to country. And I think in the years since '93, we've really developed a body of understanding Aboriginal cultural heritage and how it interacts with the physical and the intangible. This bill incorporates landscapes and intangible cultural heritage, which I think that would be high watermark, best practice cultural heritage legislation in the country.
Okay, all right. And then can I ask another question, just in terms of the, I guess, the establishment of the council? Do you see the representation as being broad enough, or
This is one of those hard bits because, 10 years down say the mechanisms in the bill for identifying the council go through. 10 years from now, you've got a self-perpetuating group of leaders that are establishing a body of practice in New South Wales and the system's running, right? How you stand up the first council is always going to be difficult, and you kind of just got to choose the best possible way to get it done. The mechanism in here, I think, it's fine. It's satisfactory. It's a tough task, and it does a good job of it. The composition, so then when we're thinking about native title holders versus land council members versus other people, I think it does get the balance right.
Yep. Okay. And one, I forgot what it was. Oh, the consultation period for this bill. Do you think it's been? You mentioned before about consensus, and you actually can't talk to everybody. But do you think has there been enough consultation?
I think there has been enough consultation on Aboriginal cultural heritage in New South Wales to absolutely exhaust both the sector and the community. I don't think any evidence given before this committee has been surprising. I don't think NTS Corp's come in here and said something that you couldn't have expected them to say, or that the New South Wales Local Aboriginal Land Council came in and said something you didn't expect them to say. We kind of know what people's views are, and I think that the conflict is easily identified. In fact, the drafting of the bill tries to preempt and satisfy a lot of that conflict up front. So has this specific bill been consulted widely? Probably not as widely as the 2018 bill, but because of the iterations of attempts at this, we've got a pretty clear sense of where the lines are. And so I think it's one of those moments where it's now time for the Parliament to just,
do something.
Yeah.
Can I just ask, when you refer to the composition being okay in its current form, are you suggesting, consistent with your evidence earlier, as providing it kind of does more to recognise native title voices, both and registered body corporates and holders, applicants, registered applicants, etc.?
I think the order of priority could be made more clear and concrete.
Yep.
And I've certainly said in many meetings it should say where there's a registered native title group, you're a clear number one. Perhaps the suggestion of the claimant group could be 1B, Aboriginal owners, number 2, land councils, number 3, and the 4th is, heaven help us, where none of those exist at determining what it looks like. But yeah, that's how it should be.
And so is that,
I would tidy up that provision in the current draft. I think it could be more express.
and that it does need that extra body, class, cohort, that are none of those, whether it's a traditional custodian, an elders group, whatever.
Exactly right.
Thank you. Can I just ask as well, with your in two areas of your expertise, when you refer to starting this and that it is likely something that would need reform, do you think a sort of presumption or a rebuttable presumption in terms of that would be a mechanism to engage in the actual bill?
Yes, that could certainly work. I think you've got to look at other similar legislation to get a sense of how you might do it. So in the Land Rights Act, the 1983 legislation, there is a 5-yearly statutory review, and it's a really rigorous review. The Department of AA certainly takes it very seriously and resources it very thoroughly. And there's now a well-established process of community consultation and stakeholder engagement and all of that. I think that sort of mechanism is extremely ideal for legislation like this. You'd probably put a shorter one in
Shorter, yeah.
because I think it's going to be reformed quite a bit in the first decade, and you want to set those. I think you want to have a 2-year review and then a 5-year review.
And just finally, given your role with Justice Reinvest, and I think you may have said it in your opening, but perhaps not so direct, is this inextricably linked with criminal justice and what's happening in communities?
I think cultural authority in community is something that is missing and often creates a lot of the gaps through which problems develop. You certainly seem to see in communities where leadership and authority is clearly identifiable and that cultural authority is obvious, that there is respect and commitment to the community is in a different way. I think Aboriginal society is a very traditional and conservative society that has very clear boundaries and roles and rights and responsibilities. If this legislation in part helps to reinvigorate that in communities where we do see massive overrepresentation of Aboriginal people interacting with the criminal justice system, it would follow that you will see it have an impact. From a more structural point of view, like from Just Reinvest's point of view, in Burke, the establishment of the Burke Tribal Council, a community group, self-identifying community authority group, coming together, has been the framework within which Marinuka, and back in the day Just Reinvest, was able to come along and figure out how can we attack these drivers into the criminal justice system. Another example would be, and this is a Moree specific one, recently addressing the Moree Plains Shire Council, new mayor, bunch of new councillors really want to reset the relationship with their Aboriginal community there. The question is, who do we talk to? So if this bill can provide some structure that in places at a local government level, they know who to speak to so they can get a culturally authoritative voice, I think you'll see a lot of progress happen in places.
And I think may I just ask?
Yeah.
We're about to run out of time, but presumably, essential to achieving some of those goals that you've outlined is the recognition of intangible cultural heritage. So that understanding that it's more than just, sort of
Not just rock
That's
art.
right, rock art. It is a much broader understanding of cultural heritage, so that you are able to establish cultural leadership in that broad sense and address some of those intangible cultural heritage, but also those sort of intangible social, economic issues that groups like Just Reinvest are trying to address.
Yeah, I think it provides the opportunity for us to see a network of clear and responsible Aboriginal leadership across the state. And I think that's something that all of us benefit from.
I think that's everything from us. Is there anything you would like to say in conclusion?
No, I just thank you guys for having me in today.
Thank you very much, Mr. Winters. Thank you.
Thank you.
Thank you. That's what we've got. Yeah. Okay, we'll recommence. Thank you, everybody. Welcome, Mr. Shane Hamilton. If you could please state your name and position, title, and swear either an oath or an affirmation.
Sure. Shane Hamilton, I'm the Deputy Director General of Aboriginal Affairs. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And would you like to start by making a short opening statement?
Sure, thank you.
Thank you.
Firstly, I'd like to begin by acknowledging the traditional custodians of the land in which we meet and to pay my respects to the Gadigal people and extend those respects to elders, both past and present, and to any other Aboriginal and Torres Strait Islander people that are with us today. While I appreciate Reverend Niles' intentions in producing this private members bill, there are a number of areas that I'm concerned that we haven't really taken the time to thoroughly consider the complexities of this important issue. The importance of culturally safe and appropriate management and protection of Aboriginal cultural heritage is paramount and cannot be understated. Not only are there cultural sensitivities that need to be respected, there is also a high degree of technical knowledge needed to line up with the planning and heritage system. The legislative protection and management of Aboriginal cultural heritage needs to balance continued connection to country and celebration of culture with the systems and operational demands of planning and development. And that needs to happen at the front end, not at the back end. The private members' bill does not strike the right balance between these competing priorities, and this balance can only be reached through consultation with Aboriginal communities, government agencies and the planning industry. Self-determination must be at the heart of reforming the current approach to Aboriginal cultural heritage management, and Aboriginal leadership is at the forefront of the government's reform priorities. The private members' bill has not been developed through the extensive consultation processes needed, and it does not reflect the expectations of Aboriginal people in New South Wales beyond a handful of organisations.
Thank you very much. So we'll just have a series of questions. Reverend Nile, would you like to go first?
Thank you. My question is directed to Mr. Hamilton. Submission 12 outlines the government's process in developing standalone Aboriginal cultural heritage legislation, which began in 2011. Can you tell us why it's taken so long to develop such legislation?
I think it goes to the heart of, and what I was touching on before about the complexities of Aboriginal cultural heritage and the legislation. We've done extensive consultations, and through up until from 2018 onwards. I think it highlights the fact that this is really complex, that it requires broad consultation. We've had, I guess, COVID in between that, and there's been a lot of issues around being able to consult widely and extensively. But I think, for me, it goes to the heart of making sure that we get this right and how it interacts with the current system, because it is complex. So,
when do you expect your legislation, will be tabled?
I'm not able to give you a clear sort of answer to that, unfortunately. We're still undergoing consultation, as I say, and working with key stakeholders. But
when do you plan to, or you anticipate the government's legislation will be presented to the New South Wales Parliament?
I don't have I'm not able to give you a date on when that's likely to happen.
And will it be, when it is submitted to the Parliament, will it be similar to the 2018 government bill?
Again, I'm not able to give you details on what that's going to look like. As I say, we've done extensive consultations. There's a whole lot more to be done. So I'm not in a position to be able to answer that question fully.
So does the new legislation have any outstanding characteristics? What would be the main features of the new government legislation when it is presented, and if it will be presented?
Sorry, point of order, Chair. I appreciate where you're going with this, Reverend, but these are probably questions best directed to the last couple of questions as well, probably best directed to the Minister rather than the Department. The questions about the timing of the bill, what's going to be in the bill, they're decisions of the Minister that would have to then go through Cabinet rather than something that Mr Hamilton can answer himself.
Well, Madam Chair, it's a question based on the assumption that the Department is intimately involved in the development of the legislation. That's their role.
Well, I think, I think the witness has answered that he isn't really certain at this point in time and doesn't, is not at liberty to say any more. Are you satisfied with those answers for now, Reverend? There's not a lot more he can provide by the sounds of it.
Well, does he wish to add any comment then?
Yeah.
Yeah, look, without giving specific content, I think the fundamental principles around, self-determination, Aboriginal people being at the centre, at the front end of decision making, rather than at the back end, has benefit not only for Aboriginal communities but also for the system itself. So, we're currently we have a cultural and heritage that sits under the National Parks and Wildlife Act of 1974. I mean, that goes to the heart of the issue.
Just one final question. If the Department hasn't any answers to the questions, it should raise in the minds of the Aboriginal community in New South Wales that there will never be a bill.
Yeah.
Would that be a correct assumption?
I don't think so, but if people may have that view, but that's not necessarily a view that I share. Yeah.
Thank you. Ms Jackson and then Ms Sharp.
I might ask a question and then go to Ms Sharp, and then we can see how we go from there. I just wanted to ask Mr Hamilton, obviously appreciate the comments that you've made, and it's certainly true to say that what you've suggested in your opening statement in the government submission is consistent with some of the other evidence we've received in relation to this bill. You would be aware, though, that, evidence including from, Mr Winters and others, it has sort of suggested that, look, we can't let the sort of perfect be the enemy of the good here, and that process of trying to ensure that everyone is brought along is going to take a really long time. And that perhaps, it is better, this is other evidence that we've received, to legislate, accept that that's imperfect, and then try and use reviews or amendments down the track to, I suppose, work through the obvious issues that there are going to be and that you've sort of drawn attention to. I suppose I just wanted, to have any reflections from you about that as a legislative process, passing a piece of legislation that we know isn't perfect, that we know has serious objections to it, but sort of saying to ourselves, oh, well, we'll figure that out later as we go down the track with reviews and amendments. I just sort of wanted your reflections on that as a legislative process.
Yeah, look, I think that's all fine if it happens, but I think history would say that may have been views historically, not just in this legislation but in others, that for Aboriginal people hasn't actually happened. So we run the risk of not engaging extensively outside of those organisations that are in this space on a regular basis. And I think when it comes to things like who can talk for country, that's very complex, and it in many ways sits directly outside of those two organisations. And if we don't take those views into consideration, I think at this particular point in time, and again, I'd emphasise the sort of front end of the development of it is far better than trying to do it at a later stage. Yeah.
Thank you. Ms Sharp.
Thanks very much. And thank you for appearing today. You are in the hot seat when we probably need the Minister to ask some of these questions, I suspect. I'm not going to ask you things for him, though. I am really interested, though, in the submission you talk about the process since 2018. Obviously, the Parliament hasn't seen any of the evidence of that. So while I think internally within government there's a lot of discussion about this, I am concerned that since 2018 there's been nothing that we've been able to see in terms of progress. And I'm just wondering, and look, you know, we're faced with this kind of awkward situation, which is that the very groups that that the department says they've been consulting with are the people who are actually backing this bill. So I'm just wondering if you can tell us what progress has been made since 2018, and in particular, you talk about amendments to the draft bill. Like, where can we see that?
Well, I'll just emphasise I can't give you the detail of that, but I can say that the opening remarks and what's in our submission is the process or the progress that we've made so far, and we continue to engage with those key organisations. And I think the biggest challenge for us has been having that extensive consultation through that period, because of a whole range of reasons, like things like COVID and other priorities. So yeah, I mean, I think my opening remarks and our submission talks to how we've progressed it so far and where we're currently at. And again, I'm sorry, but I can't give you when that's likely to be.
No, that's okay. If the answer is the government hasn't let you release it yet, that's fine, in a much more diplomatic way. But yeah, that's fine. That's part of my question is that, we keep being told that there's progress, but from the Parliament side of things, as opposed to the government side of things, we don't see that. And we're puzzled by the fact that the very same organisations that have been primarily involved in your consultation are now backing a different bill.
Mm-hmm.
Yeah, I guess I would just say that it's not to say that they don't necessarily disagree with some of the discussions that we've had with them. So, we're, and that's that's for them, their decision to back another bill. But yeah, we can say that we have engaged with them extensively and had ongoing discussions, and will continue to do that. Yeah.
One of the things that we haven't received, and again, this isn't really one from you, but your submission points to this, is the issue of the alignment of our planning legislation with heritage. How is that being dealt with in government?
Well, again, I think heritage are an important stakeholder in our deliberations, and so we're in close communication with them. We engage with them on a regular basis. If there's anything specific, I'd need to provide that outside of today's hearing.
Yeah, I mean, the point that I'd make is that heritage is the key driver here, but it fundamentally is welded into the way in which we actually do. We basically approve development in the state. So I am interested that we haven't gotten anything from the planning department, for example. This is not your fault, Mr. Hamilton, in relation to this matter, because I'm sure they have strong views, and my limited understanding of the internal discussion in government has been partly because of those strong views is why the bill hasn't come forward. I don't expect you to comment on that. That was more of a comment from me. Can I just ask you about, where the state government is at in relation to government's arrangements? I mean, the fundamental question I think that everyone's trying to grapple with, and you've alluded to this in your evidence today, is who speaks for country and how does government recognise that process? Where is Aboriginal Affairs up to with resolving that very difficult and complex question?
Well, I think if you look at the Land Rights Act and that process, it allows for that to happen. So there's a process that organisations, individuals, communities can go through to ensure that there is the right people speaking for country, and there's organisations that are, have those applications and undergoing those processes. But it goes to the heart of what I was saying before. I think that's what makes this so complex, is that it's not always clear, and you have to take the time, and there is a process to allow you to do that now, but it enables us to get that right, I guess, in terms of who does speak for country. So.
Thank you.
Go on.
Okay.
Sorry, you go, Sue.
Okay, thanks.
I was just going to ask, sorry, so touching on, I guess, the approach that Ms Jackson was talking about before, is that let's just set something up and then fix it later if it's got some spiders on it still. We heard this morning that maybe we don't need consensus, let's just get something up. Earlier evidence was, let us sort it out. Two parts of the question then. What is the importance of getting consensus or close to consensus amongst community on this? And is there precedent for that sort of approach that we touched on earlier?
Well, again, I mean, we're in a... I think across the country, we're in a very different mindset after Juck and Gorge, and thinking about things in a completely different way than we may have thought about it historically. And again, that's why I would emphasise that, you need that upfront consultation, getting that agreement right, even once you have the legislation in place, when it comes to developments across the state. Again, I would emphasise Aboriginal people need to be at the front end of that, and historically, and even now, we're not at the front end. We're the last thought rather than the first thought when it comes to development or changes that impact on Aboriginal cultural heritage. So I would say we would be far better off spending that time, and notwithstanding that, you're not always going to get agreement across the board. I mean, we're a diverse community, so you're going to get those, as long as you can get those diversity of opinions and ideas that help shape the legislation. I think that's the best way to go.
And I guess acknowledging points raised by Reverend Nile and Ms Sharp, it has been a long time coming.
Yeah.
I don't think there's much, or certainly not in this room, any resistance to the idea of protecting Aboriginal cultural heritage. What needs to happen to speed up this process? Well,
extensive consultation, to the extent that we're satisfied that everybody that needs to be consulted and has a say has had a say in that, and has been part of the developing that, and making sure that that's as wide and extensive as we possibly can, and no one gets left behind or left out. I think that's the fundamental practice that we need to engage in. Again, emphasising that when you look at where there has been issues with damage to sites and other things, it's because Aboriginal people haven't been consulted up front. Yeah.
Thank you.
Thank you. Perhaps you could outline the key differences between this bill and the 2018 exposure bill?
Look, I would just say that what you have in our submission and my opening remarks go to the heart of what we've been talking about, and that highlights the differences, I think, between this bill and what we've been talking to stakeholders about and in the process of developing. But if there's something specific that you wanted me to touch on.
I mean, look, your submission absolutely goes well to the overarching principles that legislation good standalone cultural heritage laws should include, which from all witnesses that we have had present to us say that is in this current bill, those, and that absolutely you identify consultation, but as you're aware, we are limited by the process of consultation that we can engage in as a committee looking into a bill, but the entire bill has been premised and introduced on the fact that, and as other witnesses have sworn, that consultation has now been going on. And let's be real, it's not the 2018 bill, it's the 2012 bill, the 2014 bill, and it goes back, and it goes a long way back. We know what good cultural heritage laws should look like, and people have been telling us from all across New South Wales, from Aboriginal communities and Aboriginal organisations and voices. So is there anything that you think is in this bill or is not in this bill that should be or shouldn't be?
Yeah, sure. I think the bill proposes that its Aboriginal Cultural Heritage Council has independence from government, and we believe that's undeliverable, and it proposes an independent body corporate that's not subject to the minister in areas that are legally unworkable. The bill proposes that nominees for the Aboriginal Cultural Heritage Council can only be put forward by New South Wales Aboriginal Land Council or native title holders, and this approach is out of step with best practice community engagement because it ignores a range of other interested parties, including traditional owners. It's also prescriptive about the composition of local Aboriginal cultural heritage services. So it sets up a hierarchy which prioritises local Aboriginal land councils over traditional owners who have the authority to speak for country. And that has the potential to be a licence to destroy Aboriginal cultural heritage. The Aboriginal Cultural Heritage Reform must recognise that who has the authority to speak for country, as I said before, is a complex issue. The composition of local services should be determined by Aboriginal people and not dictated by government. And the reform also needs to build on existing legislation such as the Aboriginal Land Rights Act and the Native Title Act. The diversity between and within Aboriginal communities calls for a more flexible approach to local services that balances recognition of native title with the flexibility to incorporate the diversity of knowledge holders within Aboriginal communities. Based on some previous consultation and feedback on New South Wales Aboriginal cultural heritage reforms, the complexity and dynamic nature of cultural heritage and speakers of the country has been acknowledged and factored into the role of the Aboriginal Cultural Heritage Council to determine the boundaries and composition of panel areas in a culturally appropriate way. In its current form, the Private Members Bill composition of local services is not reflective of this and has the potential to create conflict.
And so do you think that these things, I mean, I hear those things, and based on the evidence that we've had so far, which some of those matters have been raised, they would just literally be the subject of some amendments to actually fix those issues or to accommodate processes to deal with those matters. and I suppose, the question then would be, well, I think consistent with Ms. Jackson, why would we not do that now? Because as you started, we currently have cultural heritage laws embedded in the National Parks and Wildlife Act, and wouldn't standalone cultural heritage laws right now be a priority of all of us? I mean, is that, if those things were amended, do you think that from your position and the department that would be satisfactory?
Well, it's one area I think that, as I've outlined, would need to be looked at, because the current bill doesn't cover that. But there are probably a whole range of other areas as well in terms of how it lines up with the current planning system. There's other areas around.
So can I just elaborate on one point that you raised? So you object to the fact that the bill suggests that we would have a proper standalone that is administered by Aboriginal people, and that it wouldn't be as connected to government. That's an objection that you have. Is you're suggesting that we should maintain a government-controlled cultural heritage system?
No, I'm not saying that. I'm saying that if you have a standalone, so you have the Aboriginal Cultural Heritage Act that deals with cultural and heritage, it needs to work within the current system.
And so just on that point, I'm struggling with that one. How would this not work within the current system?
Well, for the reasons I've just outlined before. So I'll just go back to my notes. So if I can just go to an issue around the bill that it'll give an independent body, I guess, for example, within the bill, it's is currently mirroring categorisation of the Heritage Act, and it uses definitions of state significance and World Heritage definitions of outstanding significance. And with those high-level categorisations, set a high bar for what can be declared as Aboriginal cultural heritage. And this dismisses large quantities of cultural heritage that's significant to Aboriginal communities, but not of a scale for world heritage. And there is ongoing destruction of Aboriginal cultural heritage as it sets out an ill-suited measurement that does not reflect those Aboriginal perspectives of cultural value.
Thank you. And so these are things that so your concern would be that it doesn't protect cultural heritage enough, but they're clearly things that could be amended or modified. And I think what you're referring to is just making sure that the classifications and the terminology is consistent with the existing heritage framework, from what I can gather?
Yeah, so in terms of protected areas, the bill doesn't require the landholder consent to declare a place as a protected area. So that's what I mean in terms of alignment with the current system. I think that would most likely be opposed by industry groups like mining and agriculture.
Well, and we certainly have got some submissions that are not wholly supportive of their bill as it's drafted. They're certainly supportive of the idea of standalone cultural heritage laws. Is it not, though, our primary objective here to be putting forward a bill that seeks to protect cultural heritage, and that does work within the system, but perhaps prioritises the protection of cultural heritage at this point as the focus of standalone cultural heritage laws? Do you see that as an objective that we should be trying to achieve with this sort of standalone law?
Absolutely, yeah. I think that should be. But again, I would argue that Aboriginal people need to be at the forefront of that, right at the beginning of that process.
And you don't see this law would be doing that? This would be putting Aboriginal people at the forefront, in control, through the Aboriginal Cultural Heritage Council, an independent body of government and a body that gets to determine local land services and how cultural heritage is protected on the ground ultimately.
No, I'm saying that's how it should be. I'm just saying that there are aspects of the bill that don't allow for that necessarily to happen now, and it certainly doesn't happen right now with the current legislation. So,
thank you. I think I'm just struggling a little bit to understand precisely the bits that you're saying this bill doesn't actually do that. But I think, I can grasp from, what you've put forward. And Mrs. McDonald has some questions.
Thank you, Mr. Hamilton.
Thank you.
I just wanted to, I guess, and you might have to take this on notice, with the comments that you had, that the bill has extensive inconsistencies with the proposed processes and unclear policy positions, and you did outline some of them. I was just wondering if you can expand on that, or is that something that you would take on notice?
Probably better to take on notice, to be honest.
Okay. And the other question you had to do with your aims. How does this bill not, I guess with aim 1, better recognition of Aboriginal cultural heritage values, does this bill not fulfil that aim?
Yeah, look, to an extent it does, but there are aspects that I've outlined, I think, that don't quite meet it. I mean, notwithstanding there were questions around, could we proceed and then we make amendments later, which wouldn't be my recommendation.
Not unscrambling the egg.
Yeah.
Yeah. Okay.
Chair?
Yeah, thank you.
A couple of questions. I just wanted to, again, from your submission, you talked about, the submission talked about how the bill does not sort of adequately align with the federal Indigenous cultural heritage reform process, which is described as currently progressing. And I just wondered if you might, provide any detail that you had about the misalignment between this bill and that process, but also perhaps just give us an update on where that process is up to, if you had any information about where the federal cultural heritage reform process was up to, and the state and the New South Wales government's engagement with that.
Yeah, look, I'd probably need to take that on notice so I can give a full answer, if that's okay. Yeah.
No problem, thank you.
That's fine. And just one more, which also you may have to take on notice. It's drawn from the submission, but you've talked a little bit about some of the inconsistencies with the government's previous legislative efforts, and some of the outcomes of the consultation that you've done that aren't reflected in the bill that we're currently considering. The submission also suggests that the bill does not adequately align with the findings and recommendations of the Duke and Gorge report that the Joint Standing Committee on Northern Australia did, which is obviously that's a federal committee inquiry, so I accept that. But I'd be interested in some detail again about that misalignment. What were the things that report called A Way Forward found that are not aligned or are inconsistent with the bill that we're considering?
Yeah, I'm sorry, I don't have specifics on that. I can take that on notice and respond, but I don't have the specifics in front of me on detail on that.
That's fine. Thank you.
Thank you. Mr. Hamilton, do you think from all of the work that you have done, I'll come to you. Sorry, Ms. Sharp, I only just saw your hand. Do you think that best practice standalone cultural heritage laws should have the right of veto and should be able to have a particular role in relation to the protection of cultural heritage in relation to state significant development and state significant infrastructure?
Well, I think that's the point I was making before. It has to work within the system that we currently have, and notwithstanding that, yes, I do agree that we should have standalone legislation for Aboriginal cultural heritage, but it has to work within the system that we have.
So on that, I think I'm asking, the current system basically just provides that the existing cultural heritage protections are set aside when it comes to state significant development and infrastructure, and a process of the facilitation of harm takes place from the outset. Are you suggesting that that is the status quo and that's what standalone cultural heritage laws should include?
No, I'm saying that we should try and find a way where that doesn't happen, where Aboriginal cultural heritage is put aside, however that might occur, but it's important that it's at the, as I say, it's at the forefront. If we have standalone legislation, and again, Aboriginal people at the table, self-determination driven, then we should find a way how it stays within or works within the current system.
Okay, thank you. Ms. Sharp.
Thank you. I've got sort of two more questions. One is, in the consideration of 2018 and really just through this entire process, is there a need for us to be very upfront about basically there's a presumption of actually against destruction or harm, and how is that picked up?
How is it picked up in the current bill, do you say?
Yes.
Well, there's, to an extent, I don't think it does. That's one of the areas that we've been sort of focusing on, ensuring that Aboriginal people are are considered at the front end of any sort of discussional process.
Yes, I suppose my question though is specifically within any bill, do we need to just have that clearly? The objective of the bill is to stop. The presumption is that you don't harm it, and then there's the cascading decision in consultation with Aboriginal people about the way in which that may occur and under what circumstances. Mm-hmm. So it sort of sets up that process. But is there anywhere that you can point to that's got good presumption laws across Australia?
I'd have to take that on notice, but I think the principles of what you're talking about are exactly what we should have. In terms of pointing to an example, I would have to provide that information.
Yep, that's okay. And look, my final question for you today, and thank you for your evidence, is you've sort of indicated to this, but we have to, sorry, I'm getting some feedback, so I apologise if I'm stopping and starting a little bit. I've got bad sound. The issue of the risks of just proceeding in the bill in its current form without a sort of adequate process, particularly to look at amendments, because we had some really good evidence through this inquiry with good suggestions. I mean, what do you see the major risks being of just, I suppose, letting it go and hoping we can fix it later?
I think there's a number of, we talked a bit about the planning system, protected areas. I think there's just a number of areas that would need to be worked through and widely consulted before you would consider any further consider the bill in any format. And I touched on a couple of these today. As I said before, I'm happy to provide supplementary information. So I just wanted to go to one of my notes. One of the areas I think around ancestral remains, and it's probably fair to say that no jurisdiction in Australia has been able to transfer ownership to Aboriginal people during the process, or where ancestral remains are in possession of a cultural institution. So, a key priority for Aboriginal communities is the unconditional repatriation of ancestral remains. So the bill also exempts certain organisations such as museums from requirements of the bill. So given that museums and cultural institutions have a large number of ancestral remains and sacred objects, the intention of repatriation is not underpinned by the necessary commitment to deliver tangible outcomes. So that's one in particular that I think would really need to be considered and looked at.
Sorry, thank you. Is there any others though that I just realised our time's about to run out, so if there's anything others that we have missed in terms of things that you'd like to tell the committee?
I don't think so, apart from those questions that we've taken on notice.
Tom, is there any other questions from anyone? Can I just ask before we finish, just in terms of the consultation that you are currently undertaking with in follow-up on the 2018 bill. So those, according to your submissions, those consultations are ongoing, but you do refer specifically to those main organisations. Do you intend to be consulting any further outside of those organisations?
Yeah, I think we recognise that there needs to be further extensive consultations outside of the two key organisations.
Okay. And so, and just finally, we've heard quite a bit of evidence that we are quite that determining cultural authority and the voice of cultural authority can be complex in some areas, in other areas not complex, as complex, but that there are processes that they have been happening, and that is something that ultimately can be designed to be facilitated. Is that something that your bill will intend to? Sorry, in the final drafting of your bill, will you be determining an order of hierarchy or priority or those particular voices, or will you be outlining a process in your bill?
Sorry, Chair, that's probably again, and I should have remiss of me for not getting involved earlier. That's probably another question for the minister rather than the official. I think we've spent a lot of time asking.
I hear what you're saying, but I think
official.
this. I mean, I think I'm just literally asking about a process that's resulted from the consultation so far, and the submission goes to that. Is that something you're comfortable to answer?
Well, I can't talk specifically about the bill, but the system allows, under the Land Rights Act now, allows a process to determine who can speak for country. That already exists.
But however, that you're suggesting, though, that you recognise the native title system works alongside that now, or perhaps even overrides that in certain circumstances?
I don't know that it necessarily... I'm not sure it overrides it, but the Land Rights Act allows you for that issue to be considered and determined.
So how do you think? What's your view based on what you're exposed to? If somebody sits before you and says that when it comes to cultural authority, a native title holder is the gold standard?
I'm not sure you're.
In terms of cultural authority, does that resonate with all of the evidence that and consultation that you've achieved or obtained?
Well, that's one part, but I mean, there's also the Aboriginal Land Rights Act, which also deals with that as well. So, I'm not to sort of say what's better than one or the other. I'm just saying that the process to determine that already exists.
I see. And sorry, I don't think that what the evidence we obtained was that one is better than the other. It's just that one has achieved a satisfaction of cultural authority more so than the other. And I suppose is that not something the department has heard or the department does consider?
No, I don't think we have a view on one or the other. We just know that there's a process for that to be determined. Yeah.
Thank you. Okay, I think is there anything you would like to say in conclusion?
No, only,
Thank you.
Only that, yeah. Well,
Mr. Hamilton, we're so grateful that you have come, thank you for attending. The committee's resolved that answers to questions taken on notice be returned within 7 days. We're a bit short on time. And the Secretariat will be in contact with you in relation to those.
no problem.
And thank you very much.
Thank you.
welcome back to everybody. I now welcome our next witness, and who is joining us by WebEx. Thank you very much, Mr. Abbey. If I could please get you to state your name and position title and swear either an oath or an affirmation.
Yes, my name is Andrew Abbey. I'm a Policy Director with the New South Wales Minerals Council. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. And Mr. Abbey, would you like to start by making a brief opening statement?
Yep, thank you. So firstly, would like to thank the committee for inviting the New South Wales Minerals Council to assist in its consideration on this issue. I'd also like to acknowledge the traditional owners of the land on which I'm meeting with you, which is the Willayakali, who are an Australian Aboriginal tribal group of the Darling River Basin in far west New South Wales. And I might pay my respects to elders past, present and emerging, and I'm hoping I got the pronunciation of that correct. I don't have much further to add to the submission lodged by the New South Wales Minerals Council, other than to mention to emphasise the following points. The New South Wales mining industry strongly supports the modernisation of the Aboriginal cultural heritage regulatory framework in New South Wales, and particularly the establishment of standalone legislation. In that respect, we broadly agree with the view that the current situation is offensive to First Nations people and it should be rectified. In terms of the cultural heritage protection regime being absorbed in the National Parks Wildlife Act. This reform is long overdue. However, whilst we agree the reforms need to occur, our industry has some questions about the approach being taken in the Culture is Identity Bill. Firstly, there has been no consultation on the substance of the bill that we're aware of, or that at least that the New South Wales Minerals Council is aware of. I did note in the previous day's hearing that various parties were involved in the development of the bill, but as I understand it, there's been no broader consultation. Given the comprehensive nature of this reform and the range of stakeholders likely to be impacted, particularly Indigenous communities, at a minimum there should be comprehensive engagement before a bill is finalised, including culturally sensitive engagement with Indigenous communities. Secondly, the legislation proposes a fairly expansive regulatory and administrative framework consisting of the Aboriginal Cultural Heritage Council as well as multiple local Aboriginal cultural heritage services across the state. Whilst we acknowledge this is a private member's bill, there's no clear plan on how it would be implemented, how much it would cost, how it would be paid for, how it works with the government, how it works with other stakeholders, etc., and a range of other practical implementation issues. The importance of resolving these details from the outset, in our view, can't be emphasised enough if we want these reforms to actually succeed. Thirdly, the legislation defers very significant powers to subordinate legislation, regulations and guidelines, none of which have been made available for consideration. Our view for such wide-ranging reforms, at a minimum, draft regs and guidelines should be made available for discussion with all stakeholders, just so there's a clear understanding of what's involved, how the power lies, how the power is distributed and the costs and benefits are distributed amongst stakeholders. Fourthly, there are a number of parts of the bill itself that we have questions around. And I guess primarily, and I know the word veto was discussed at the previous day's hearing and is used and bandied around, but how this Culture Identity Bill is integrated, or in our view, the lack of integration with the existing planning and development assessment framework. Our understanding of the bill, it includes a yes or no gateway decision for certain types of developments in New South Wales based on a single issue, and the objectives of that, the objectives of standalone cultural heritage or the cultural heritage identity or cultural heritage protection measures is not disputed in any way, shape or form. In fact, that's exactly what it should be doing. But our questions around, well, how does that process or whatever's entailed in that fit or sit, if it, indeed it may or may not, within the development assessment framework. And so the introduction of a yes or no gateway decision for certain development in New South Wales based on a single issue, and particularly without the ability to consider all aspects of a project and without any ability to review decisions. By a proponent, if there are some review mechanisms, but I'm sure we can get to those or clarify those. From a principal perspective, our industry supports integrated decision-making processes that assess all elements of a project, after which a decision is made balancing all of the considerations, including all the costs and benefits of a project. Importantly, an integrated assessment approach, in our view, can incorporate updated and strengthened cultural heritage protection and management requirements, including culturally appropriate consultation engagements. Our view for projects, the primary objective should always be to reach an agreement, particularly on cultural heritage impacts. But reality is this may not be possible in all cases. Where any party does not support a project for any reason, this should be able to be freely expressed and transparently addressed as part of the decision-making process, which takes into account all aspects of a project. As noted earlier, the New South Wales mining industry strongly supports the modernisation of Aboriginal cultural heritage protection in New South Wales, and particularly the establishment of standalone legislation. Genuinely, this is an important reform. Our view, hopefully it's done properly so we get it right. In this regard, and despite the delays that have occurred to date, our view is the government is best placed to actually deliver these important reforms, largely because they've got the hand on the levers in terms of costs, how it would be implemented, etc. And we would urge the New South Wales government to complete these important reforms and make sure there's proper consultation and engagement, particularly with Indigenous communities and other affected stakeholders and industries. And importantly, a clear plan, including a commitment to funding on how the reforms would be delivered. And the last thing I'd say is we genuinely want to be hopefully a constructive participant in the discussions going forward so we get it right and reach the best solution for all stakeholders. That's all I've got to say. Thank you, and I'm happy to take any questions.
Thank you, Mr. Abbey. Reverend, do you have some questions for Mr. Abbey, and you'd like to start?
Yes.
Thank
good,
you.
Thank you. You've indicated you've got some strong views that have not been canvassed in the preparation of my bill, and I'd like to make it clear we're very happy to meet with the Mineral Council and to discuss any concerns that they have. I'm sorry that that hasn't happened to your satisfaction, and we'll certainly take steps to make sure it happens in the future. I was wondering what your reaction is to the initiative or innovation of having an Aboriginal Land Council for New South Wales. That's one of the main recommendations in the Fred Noel bill. Do you have any objections to that, or you see some value in that? Thank you.
So just to clarify, I'm assuming you mean an Aboriginal Cultural Heritage Council, not the Aboriginal Land Council?
No, it's a new body.
Yeah, the Reverend's referring to
Yes,
the Aboriginal Cultural Heritage
Yes.
Council.
Look, that was, yes, so on that point, I want to clarify on the same point. There's no objection to that in any way, shape, or form. In fact, we supported the government's reforms, where my understanding, and from recollection, it was back in 2018, that proposed similar bodies. So in principle, there's no opposition to that in any way, shape, or form. Once again, going back to the body's not necessarily, it's how it works, how it's funded. You know, what's the structures, what are the government's arrangements, how, if at all, it does fit with government, how it's paid for, particularly the Aboriginal party. So in principle, Reverend, no, there's no opposition. And sorry, can I just add to that? I think if you do create standalone legislation, which we do support, then it makes sense to actually have an administrative body administering it.
Well, that's the body, the Aboriginal Land Council.
Yes.
It's a new body.
Yes.
So you don't have any objections to that?
No, for the reasons I outlined. I guess, as I said, it's qualified. Would love to be part of the discussions about if that's up to us or for us to be part of some of those discussions, but would love to make sure that there's a clear plan of how it's going to work. So if it is introduced, it actually works. And that's why our view and respecting this is your bill, Reverend. But our view is the government needs to get on and actually deliver this in whatever guise, deliver it, because I think from a practical perspective, they'll have the best means of actually making it able to work, because they'll work out how to fund it. What are the budgets for it? How do people get paid? Simple stuff like that. But so in principle, that's a lot of words. No, yes. In principle, if that's the way that Parliament and / the government want to go, we don't have a in principle objection to it, other than making sure it works and what that involves to make it work is clarified and detailed.
Good. We obviously would not have introduced the bill if the government's bill had been finalised and passed. But as you may have heard some of the answers to questions this morning, there seems to be a lot of uncertainty in the ranks of those who are responsible for the government's legislation, exactly where it is, where it's up to, and so on. And it's a bit of a puzzle as to why it's so complicated to draft a bill, but obviously it's giving the government has got some problems in doing that, and that's what's caused a lot of the reaction now to the government's lack of action on their legislation, which we've tried to fill that gap, and probably you would too. The Mineral Council would like to fill that gap as well. So
is that a question? Is that because I have a view and a comment on that.
Good. Definitely, it's a question.
Look, both our submission and what I just said in the introductory statement, we agree. The sooner this is sorted out, the better. The only thing I'd say, let's sort it out properly, and that's why there'll be people that don't like our views, and we might have questions about some other people's views on what it does or doesn't entail. But let's sit down and sort it out. And so I did not see this morning's part of the presentations. I did read the transcript from 2 weeks ago. I think there's a healthy amount of frustration amongst a lot of stakeholders for various reasons, and I'd imagine the frustration's massive on the First Nations or Indigenous person's part. From our point of view, there's a regulatory certainty frustration. So if you're expressing frustration and bewilderment about why the government hasn't finalised reforms, I agree with you. And as I said, we urge the New South Wales government to complete these important reforms. Let's not waste any more time, but let's do it properly. Is my only real comment.
Yeah, good. Thank you.
Do you want to go, Ms. Jackson?
I might just ask one question at this stage. I wondered, Mr. Abbey, if you could just give us a little bit of an overview about what currently occurs. What the current kind of approach that members of the Minerals Council take to addressing, issues of Aboriginal cultural heritage when they're, managing their sites or proposing new sites.
Yep. So look, in the submission, there was a couple of pages where I banged on, for lack of better words, about the SSD process, and I know people will have views about the state significant development process, because technically it does switch off cultural heritage, or a number of requirements, including cultural heritage, but importantly, in our view, it doesn't mean you don't have to deal with those matters, and far from it. And I'll go to a bit of an example in that in a second. But there are comprehensive requirements outlined as part for any mining project, and I would strongly argue, and I've done a decent amount of analysis, that mining projects are more rigorously or thoroughly prosecuted in terms of impacts on cultural heritage than most other projects in the state. I've like no question I'm happy to be convinced otherwise. So getting to the point, firstly, mining companies, they're there for a long term in terms of the years and years and years, 30, 20, 30 plus years potentially. They value or realise the importance of establishing good relationships with local communities. So when they first go there for exploration activities, they will strike up conversations and relationships with relevant parties. When they're actually ready to go forward with a project, they have to go to the Department of Planning and get Secretary Environmental Assessment requirements. And in there, and I don't know what page number it is on my submission, but there's a list of all the environmental assessment requirements that are there. Those include the current requirements under the National Parks Wildlife Act, as well as all the guidance policy documents. They then get those from the Department of Planning, then go away and prepare the environmental impact statement. Those requirements include requirements to consult with registered Aboriginal parties. Now, depending on the project and the location, that could be dozens and dozens and dozens. And I've been directly involved in a project where there was over 80 to 100 individual registered Aboriginal parties. And as part of that process, there's engagement with them, correspondence, workshops. For those that are interested, there's actually walking over country to identify where actual cultural heritage, the cultural heritage impacts would be, what's there, archaeological investigations, broader cultural heritage or intangible culture investigations and the like. Once that's done, the applicant puts together their impact assessment documents. And once again, the objective is to look at, well, okay, what are the impacts? What are mitigation measures? There might be some opportunities to address people's concerns in terms of relocating things. There may be limited, in some circumstances, there may be limited opportunities. So those things are all identified and articulated as part of that SSD assessment process, the preparation of the EIS. It then is lodged with the Department of Planning, who undertakes its assessment. That's subject to public consultation and the like. After, typically, that is a year to a year and a half. And then it's typically referred to a body called the Independent Planning Commission, who is an independent decision maker, who looks at the full suite of issues that are on the table. And of course, Indigenous cultural heritage would be a very important one. It'll prosecute the issues before making a decision based on all of those issues. I know I've talked a lot. The only thing, I'll get to my point. I know things like the Shenhua project was identified in Reverend Niall's second reader speech about it was ultimately not going forward because of agricultural reasons, but what about the 3 grinding grooves, which were incredibly important to Indigenous persons and the like. The only thing, without offering a view on the outcome, because I know people would be, First Nations people who were opposed to the project would be aggrieved by it, but I would suggest respectfully that the process itself was incredibly thorough. And all of those matters, there was nothing hidden or not addressed, and the issues were actually looked at by the assessment bodies and by the decision-making bodies. In fact, they got permission to go out to the grinding grooves, which were in question for the Shenhua Watermark project, and they looked at it, and then there was a very fulsome report taken about the pros and cons and mitigation measures and whether or not the project should proceed. In that particular example, it was approved to proceed. And I'm sure there are people who strongly disagree with that approval, and I respect that and accept that. But it once again goes to that, well, how do you weigh up the competing interests, all of the competing interests, and what issue gets primacy over other issues? Now, that's a lot of words. Did that answer your question?
Yeah, it did. I mean, obviously it's useful for us to have a sense of what the current arrangements are. As we're, in the process of considering alternatives. Perhaps others might ask questions and then come back to me.
Could I just add to that, if that's okay?
Sure.
1 second.
Yeah, of course.
Sorry to interrupt, Chair. The only thing I'd say to that, when I talked about the environmental assessment requirements, outlining what all of the assessment requirements are, our view is that absolutely there should be standalone legislation and modernised strength and cultural heritage requirements, and they would be absorbed into that process. And the companies or mining companies would then be subject to those new requirements and have to address those requirements. Sorry to interrupt.
No, that's a good.
No,
understood.
thanks, Mr. Abbey. That actually goes really directly to what I was going to ask you. You know, the reason, the main reason that decisions are made in the framework that you presented, including the Shenhua decision, is because there is no greater legal protection afforded to cultural heritage. That's precisely what this bill is seeking to do, to try to elevate the protection of cultural heritage through a legal and regulatory framework in New South Wales for the first time ever. Do you think, am I hearing from you though, that you are actually suggesting that standalone cultural heritage laws should more or less present the existing framework, because you're suggesting that it is a good framework and that in your case, in relation to state significant development projects, namely mining, that you believe that you do get to the right outcome each time? Is that the evidence I'm hearing?
Well, the best way to answer that is a process answer in that so taking the Culture as Identity Bill and what I mentioned as a gateway thing, what the Cultural Identity Bill is doing is saying, look, come to this group first on this particular single issue, and we'll tell you if based on our view of it, without having the ability to consider all the broader issues, we'll let you know if you can then jump into the assessment process where you can deal with the broader issues. Our view is that the integrated and holistic assessment process, and once again, this is our view, and I appreciate others will have different views, and the objective of this is to elevate the importance and protection of Aboriginal cultural heritage. Our view is those requirements or the intent or objective of that can be absorbed readily into an integrated assessment decision-making process with modernised, strengthened or strengthened requirements, whatever they may be. And indeed, Aboriginal Cultural Heritage Council should, and as they do, registered Aboriginal parties currently do, should be able to express that they disagree with a project. Absolutely, they should be able to, no question. But then the question becomes, well, what if that position cuts or is in conflict with other interests in a particular project? Now, I'm not just talking about mining projects, mind you. We're talking about rezonings, bridges, Warragamba Dam upgrades, infrastructure projects, the whole lot. So how do you reconcile those competing interests? So our view is, yes, there needs to be strengthened requirements, standalone legislation, etc. Yeah, if the Aboriginal Cultural Heritage Council, whatever guys exist, absolutely they can express views and the like and have an important seat or be part of that decision-making process. But then ultimately, do you have a single issue, and I'm loath to use the word veto, but acting as a gateway in and of itself and dealing with single focus issues and not affording the opportunity to balance out the benefits and costs, the broader range of benefits and costs, whatever they may be.
So just on following that up, Mr. Abbey, was there not something similar in relation to gateway certificates when it came to other mineral or petroleum projects in relation to significant farmland? Have we been down this kind of path before where we've absolutely had gateway processes, and why do you think that it wouldn't be, that cultural heritage is not something that should be afforded a gateway of sorts process?
Look, that's actually a really good point. There is a gateway process that's administered by the Independent Planning Commission. And from my recollection, when it was first introduced, it actually proposed almost similar, a veto to say, okay, well, I think the words of the time were, we'll ring fence area or there'll be no-go areas. That was ultimately changed for similar reasons, to say, well, hang on, you're just cherry picking one issue out and not affording the opportunity to look at the broader suite of issues. That gateway process actually does exist, relating to strategic agriculture, where projects are located on strategic agricultural land. And you go to the IPC, you prepare, you get whatever the requirements are, and it goes through the Independent Planning Commission, where they set parameters about what the broader assessment needs to take into consideration as part of dealing with the impacts on strategic agricultural land. So it's not it is a gateway in the sense, but it's not a yes or no at that early point before the broader assessment's actually undertaken. But it's a very good comparison.
Thank you. Mr. Barrett?
When you are talking, the process you went to before, how do you determine who speaks for country? Do you have a hierarchy of who you go to?
So on that, we don't, or our mining companies don't. We are guided by advice from, as I understand it, the National Parks Wildlife Services, whoever local. So we don't. The mining companies, being clear, we do not. Who the right people are to deal with is the mining companies are given that information by the relevant government bodies or whoever. On that issue, and I noted that on the previous hearing, there's I don't want to say disagreement, but there's I guess challenges about who the right parties are to deal with and the like. That's not our business to deal with, and I'm confident that as part of this process, people will work out how the right people and the right people to speak for country with authority are identified. The only comment I will make, and we actually purposely stayed away from putting this in our thing, is we just want to know who the right party is with a reasonable degree of certainty. Going to my point, I think it was the Shenhua thing, the Shenhua project rather, that had something like 80-something registered Aboriginal parties as of October 2012, there were 144 separate registered Aboriginal parties involved in the engagement process. Now, from what I heard from the Friday session, I could understand a frustration with some people if some of those parties aren't necessarily the right parties in some people's views. But once again, that's not our business to deal with. We're confident that if this type of iteration or version of cultural heritage councils and the like gets through, we're confident that those groups will be able to identify who the right people are. We're just hoping that occurs so we can have confidence to make sure that we get it right straight away and we're dealing with the right people. But at the moment, it's an all-inclusive thing as a safety measure more than anything. So you just include everybody. And as I said, 144 for the Shenhua or Watermark project. Now, those numbers sort of drop off or wax and wane over a few years as you're going through the process. But you know, we're anything to improve the confidence about who it is and who has authority, we'd strongly support.
And how do you deal with 144 different organisations? Are you looking for consensus from all of them, or do you?
Well, look, I can't. I'll give you my view, my flavour, but that question's best put to a mining company who actually does it. But anecdotally, the feedback is it's challenging. You know, for a whole bunch of reasons. Sometimes some of the parties don't agree that other parties are involved and the like. Ultimately, you are looking for consensus. So the Shenhua proposal is actually a good example of that. At the front of the EIS, which, as I said, there was 3 volumes of attachments related, something like the better part of 1,000 pages. They actually had a letter signed from a particular group that said they supported the project and the mitigation measures and the like. So that's at one point in time with one particular group. And then ultimately there was another group who was strongly opposed to it. And ultimately that other group then took them to court, I think on the EPBC approval, the Commonwealth approval, and took them to court. So it's a challenging aspect of it. But look, that's the world we live in. We've got to get on and deal with the rules that are in front of us. But anything that can be done to give more confidence to that would be welcome. Did that answer that question in terms of? So look, ideally you're trying to seek consensus, of course. But you know, there will be things we do that some people might disagree with.
Ms. Sharp.
I've got another question for Mr. Abbey.
Reverend Nile.
Your submissions has a number of concerns about the reliability of decisions made by the Arts Council. How do you, or what decision would you make to replace the Arts Council? Would the independent Aboriginal State Council be a better authority than the Arts Council?
I'm sorry. If you could just, I don't think our submission referred to the Arts Council.
No.
I believe the Reverend is referring to the current Cultural Advisory Council that sits under National Parks and Wildlife. I believe that is the council that he is referring to.
So I didn't mention any decisions taken by that group in our submission. We didn't offer a view on that.
No, I didn't read that.
I apologise, but I don't really have a view, Reverend, on that we've expressed in our submission, or that I could add value in response to your question.
Right. Okay. Thank you.
Ms. Sharp.
Thank you.
Thank you. Thank you for coming along today. I've got a couple of questions. One is, what was the role of the Minerals Council in the government consultation processes to date? We talk a lot about 2018 and beyond. Have you been involved in any consultations in relation to this?
We were over a number of years. So when we say involved, it was dealing with, through work. It was prior to my time and involvement in the Minerals Council, but my understanding it was a number of submissions over various points in time from 2011 or 2012 or whenever it kicked off, up until 2018 or 17 was our last submission.
And did the Minerals, and sorry, can I just stop you there? Did the Minerals Council endorse the 2018 draft bill?
Yes. Now, I know the cynical view would be only endorsed it because SSD projects and SSI projects weren't included in it. So yes, we did endorse it. But once again, I'll go back to that other point that I raised previously about, well, how do mining companies deal with Aboriginal cultural heritage? Any new requirements that come into play, we have to abide by them effectively. It's just that there's not, a decision taken under the National Parks and Wildlife Act, but the requirements all have to be addressed. I just wanted to front foot that, so yes, the short answer to your question is absolutely we supported it. We want to just get on and put it to bed properly, in terms of updated and modernised cultural heritage regimes. I think from my submission, I got the big table with the crosses and the ticks and the like. Most other states have done this and sorted it out. Yeah, we'd like to see it sorted out as well.
And sorry, just to be clear, I'm not sure that I've quite understood your evidence. So you're arguing that despite state significant development and state significant infrastructure being not requiring Aboriginal heritage assessment, you're saying that is undertaken?
Absolutely, without any shadow of a doubt. In fact, I hand on heart, say that mining projects are more thoroughly assessed and deal with cultural heritage issues, including all the other issues, way more thoroughly and way more rigorously than any other project in the state. And part of that is because they're so heavily scrutinised. They are very, very heavily regulated.
But obviously not required in the law. So is your primary concern really that the assessment of this as a priority issue would lead to projects not being approved?
Well, first, if I could take a step back, when you say not required by law, there is a requirement to undertake an assessment in accordance with the Secretary Environmental Assessment requirements. Yep. And so those requirements actually are, they do lend weight to whether a proper and rigorous assessment is undertaken. The second part of your question was?
Well, I suppose my question is that, yes, that they're required through the EIS process and through the SEARS process, but they're not. But there's no. They're not a. There's no sort of veto in relation to the issues raised within that. That's correct, isn't it?
Yeah, as they currently stand, there's no. As a standalone single issue, if the council that Reverend Knoll was talking about said no, that doesn't that doesn't stop the project per se. It still ultimately can go towards a broader assessment.
So under the current process, there's, once these issues have been identified, there's then permits basically provided through the Aboriginal, through the heritage system. Have you ever had any refused?
No. Well, once, because of the integrated nature of the under the Environmental Planning and Assessment Act, the approval, you don't then have to go and get the separate approval because you're actually dealing with those cultural heritage requirements as part of that holistic and integrated process.
Okay. So my final, thank you for that. That's clear because it is quite complicated. In terms of what happened at Duke and Gorge, what guarantees do we have under the current system in New South Wales that that couldn't occur?
Well, firstly on Duke and Gorge, I don't think there's anybody. I'm getting a lot of feedback, which is a bit, I don't know where that's coming from. Sorry. On Duke and Gorge, I don't think anybody in the mining industry thinks that was would defend that outcome or thinks it was a good outcome. I can't sit here and say absolutely there's no guarantee that something like that would happen. What I can say is that the level of prosecution and the level of investigation undertaken is incredibly rigorous and incredibly thorough, and it has got better and better and better over a number of years, and rightly so, and so it should be, because the world has moved on from 20 years ago where there was a bit of a view that it was a sort of last-minute tick-a-box exercise to now it is one of the front and centre big issues. And I don't use the word risk as a negative. In terms of projects, it is right up there in terms of being, okay, well, if we want certainty about whether a project will proceed, you've got to do this stuff properly. And it's not just about looking at what's on the ground and saying, oh, that's okay on balance because there's 10 more jobs and that should compensate for that. It's about stakeholder engagement, relationships with your local communities, being a cultural sensitivity awareness, long-term relationships engagement, and working with them about and being very transparent up front about, well, what are the impacts? What does this mean to you from both a physical or tangible sense and intangible sense, recording that, and then ultimately going forward with or trying to go forward with the project. Sorry, that feedback's still there. It's a bit disconcerting.
Yes, I'm getting it too. I'm sorry. It is. Yeah, it's a problem.
Did that answer your question?
Oh, that's better. I think they've muted. That's better.
Sorry, I was hearing my voice twice, which is way too much.
No, I've got it too. So the stop and starters, I apologise as well.
That's all right. That's all right. I hope that answered your question. But I guess in short words, it's very, very rigorous. So, could I sit here and 100% guarantee it? No. But the risk of it occurring in New South Wales, I would argue, because of the level of prosecution and detailed consideration of the issue and long-term engagement with stakeholders, I think the risk is low.
Can I just ask one more question then?
Of course.
Are you able to tell us how many prosecutions there have been for destruction of Aboriginal cultural heritage?
In terms of New South Wales, I wouldn't have a clue. In terms of mining projects, I don't know off the top of my head, if any. But there are, as part of the approvals, there are cultural heritage management plans that have to be endorsed and agreed to, and that includes protocols about if when you're clearing sites or land or whatever, if something's found, protocols about how that's dealt with, and that includes, there's also cultural heritage stakeholder reference groups that are continuously over years. It's not a one-off engagement before the project gets approved and then see you later. There's long-term engagement with whoever the right parties are, which are oversighting clearance of areas and the like.
Thank you.
Okay, thank you.
Mr. Abbey, sorry, I think we've just got a couple more questions, but I think do you accept that the reason that there is an assessment process and that the Secretary's environmental assessment requirements require a management plan and lead up is because that essentially some of these projects we're talking about are ones that permanently disfigure landscapes and destroy cultural heritage forever? Like that's just by
Yes.
nature of some of the projects.
Yes, but if you dig a hole in the ground, there will be impacts. But then, of course, sorry, did you finish your question?
Well, no, what I was just sort of saying, trying to kind of put that out there as to that's why we engage in this process. It is actually, when we talk about this assessment process, generally speaking, the end result is that Aboriginal communities and stakeholders and custodians are actually engaging in a process to destroy their cultural heritage forever because of the nature of these projects.
So as a general, yes, but things like, for example, the Warragamba Dam wall raising, the Windsor Bridge, infrastructure projects, residential housing estates, where you're changing the landscape, by definition, there will be an impact on the landscape of some form or another. And we accept there's a profound connection to land with Aboriginal communities, and it's not just the tangible heritage, the stuff that's on the ground. There's also a broader cultural impact. This goes to my whole point, I guess, about, well, how do you work out respectfully, culturally sensitively, etc., what that scale and level of impact is to whom, and that's important. And then there's a whole bunch of other, like there's, the CSIP requirements cover 10, 12, 14 things. You look at all of those individual elements, what gets primacy over the other in terms of benefits and costs, and who is best placed, or what's the best vehicle, if you like, to decide where the benefits and costs are best prioritised.
Yeah, thank you. Does anybody have any other further questions? Ms. Jackson.
I might just ask one last question. I mean, one of the things, in a way leading on from what Ms. Higginson was saying, a lot of the understanding of the way that mining projects impact cultural heritage is their impact on the physical landscape. And that is important, and better ways to manage that are contemplated under this bill. But also contemplated under this bill are the impact of projects on intangible cultural heritage. And that might include things like whether rivers are running and healthy, and much more intangible things than just this particular site or this particular piece of art or this particular burial place or whatever it is. It's that more intangible understanding of Aboriginal cultural heritage. And so I guess I wondered what engagement so far have the Minerals Council or mining companies had with understanding those impacts of their projects, not just we will dig here and not dig there, but the broader consequence of mining activity on landscapes, and the changes that they can cause and the consequence of them for intangible spiritual stories.
Yeah. So I guess there's two ways I'd answer that. One is there's how we've been engaged in the government's reforms about the cultural heritage modernisation. But firstly, I'll answer from a project perspective. Each individual project is and does actually account for spiritual connection or the intangible impacts on cultural heritage, things like impacts on rivers downstream or what the valley means or whatever. That's best left for First Nations people with the right understanding of it to talk to. But there is a requirement that aspect of impacts is tried to be understood as best as it can. And addressed. And the Chenois proposal, and I'll keep going back to that because I looked into it because it was raised in the second reader, the Chenois proposal actually has one whole appendix on its own dealing with it where it's not us telling people or the mining company telling people what the intangible heritage is. It's actually talking to and engaging with the right parties, hopefully, for them to tell us what the impact and what their view and why, how would this have an impact on your view of what intangible heritage, or your spiritual connection to the land, if you like. So there's that aspect of it, which, as I said, I keep going back to, that is thoroughly dealt with. Now, I know the outcomes might not necessarily be agreed to by all parties, but in terms of it being dealt with through the assessment process, I'm confident or comfortable that individual projects, particularly mining projects, have to deal with it. In terms of our engagement with the reform process over 10 or so years, we know that intangible heritage will be in the legislation or regulatory in one form or another. That's consistent with the approach being taken in other jurisdictions, which is supported broadly. I guess the only thing, once again, it goes to that whole process and certainty about just what is it, how's it worked out? And I don't mean, give us the rules so a mining company could go and work it out. How's it worked out respectfully and in close engagement with the right First Nations parties and the like, but getting the process right and the reform right and the settings right, so it gives everybody, I guess, the guardrails on how to work through the new world order or the new order in terms of dealing with projects and making sure there's a appropriate level of assessment undertaken. Does that answer your question?
Yeah, it does.
Second part.
It does. I mean, it's useful.
A bit like,
yeah, I appreciate it's useful to know that you do support or at least accept that intangible cultural heritage would be contemplated as part of the standalone legislation, and you're just seeking clarity about how that operates in practice. I understand.
So on that, in terms of accepting it, there's no question Indigenous persons have a very, very different relationship to land than I have. There's no question. So that's 100% accepted, both in a physical sense and a intangible sense. And that necessarily means they have a very strong right or legitimate right to have a seat at the table as part of the assessment decision-making processes. So not only do we accept it, we strongly support it and agreed. But I guess our view is we think that can be worked through as part of a holistic, integrated assessment decision-making process.
Yep. Thank you. Mr. Abbey, just one final part with your evidence that you spoke of about, to introduce laws, government's best placed, that, it will roll out, and this notion of subordinate legislation, draft regs should normally be exhibited, and so on. Would you accept, though, that in the development of cultural heritage, standalone cultural heritage laws that are controlled and administered by Aboriginal people themselves, that this may be a case worthy of exception for that, and that we introduce the framework and then those matters are dealt with within the architecture of the new framework, because there's there's overwhelming acceptance that we need to get on with this job?
So well, that's a good question. So I think if I could answer it slightly differently, if we're going to do it, let's give it a red hot go of success, and I think to do that, this involves, whether we like it or not, money, resources and buy-in from people who've got money to support it. So the last thing it would be a so frustrating or disappointing, and I'd assume First Nations people would say this as well, if this all started with everybody patting each other on the back and then it didn't really work. So let's give it the best chance of success. And it's part of that self-interest from our industry, because we just want certainty of process. Look, so in that respect, from what's on the table right now, I don't see enough, or there doesn't appear to be enough to give the confidence that everybody's bought into this and this is going to go forward and be successful. But I'd love to be would love to be part of that conversation and be convinced, based on the evidence, if there's enough evidence and enough will and support and momentum behind this, that it's going to work. Prefacing that we obviously have our views about certain parts of it and the like, of course, and those being at least discussed or addressed. But you know, if there was that sort of buy-in and commitment to it, sure, why not? But at the moment, I don't. That's not evident to me based on what we've seen, or it's not clearly there that if this bill was made tomorrow, I think we'd all be scratching our head. Goes, well, what happens now?
Thank you. Okay.
I hope that answers your. I hope
Yes.
that answers your question.
Yep, thank you. That's very clear. Okay, I think that's it from the committee. Thank you very much for attending. I don't think there were any questions on notice. No. So thank you very much for attending, Mr.
Thank you.
Abbey. Thank you for your time.
Thank you.
Thank
Bye.
you. Thank you.
Well, thank you. Okay, welcome back everybody to the next part of the hearing today. I now welcome our next witnesses. I note that all the witnesses are appearing by WebEx this session, so could I please get each witness to state their name, their position title, and swear either an oath or an affirmation? And perhaps we could start with you, Mr. Clyde.
Thank you very much. Can the committee hear me okay?
Yes, thank you.
Fantastic. Thank you very much. So my name is Nick Clyde. I'm the New South Wales coordinator for Lock the Gate Alliance, and I will take the affirmations. So I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And is that Ms. Quintella? Yes, we'll go to you next. Thank you.
I'm Kara Kinchela, Gomeroi traditional custodian and Gomeroi native title claimant. I work for Lock the Gate community coordinator in Narrabri.
Thank you, Kara. And are you happy to take the affirmation there?
Yeah, I'll take the affirmation.
Thank you.
I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. All right, and we did have one other witness scheduled, Jane Delaney, who is not yet with us, so we'll just see how we go there. So, Mr. Clyde, did you want to begin with an opening statement?
Yes, thank you. So look, on behalf of Lock the Gate Alliance, and I believe Jane Delaney John, I did speak to her a moment ago, so I think she's just sorting out her IT at her end. But yes, I'm happy to make an opening statement on behalf of Lock the Gate Alliance. Firstly, look, thank you very much for the opportunity to appear today before your committee. We very much appreciate that opportunity to have a conversation with you about the protection of Aboriginal cultural heritage here in New South Wales. So I'd like to begin by acknowledging that I'm on Gadigal Wongal land here in Sydney in the inner west, and I'd also like to pay my respects to the leadership from traditional owners across Australia in the fight to protect country from destructive practices such as coal and gas mining. Our organisation has been working for more than a decade now with communities across the country who've been campaigning to protect their land, their water, their health and cultural heritage from really inappropriate coal and gas projects. So here in New South Wales, we've tried our best to support First Nations communities in their fight to protect heritage. That work has never been easy. Largely for the reason that NTS Corp noted in their submission to the committee. And I'd just like to quote one sentence from that submission, which we share, where they point out that the current system, rather than holistically operating to protect Aboriginal cultural heritage, instead creates permissible ways to damage or destroy Aboriginal cultural heritage for the benefit of third parties. And that's certainly been our experience in New South Wales. Our view is that the current system, the current regulatory system is not fit for purpose, and it's fundamentally disempowering for the Aboriginal communities that we've worked with. Our submission, as you know, just provides a small snapshot really of just a few of the mining projects that we've worked on over the years. Some of the important ones are not in our submission also today, and one of those Jane is going to cover in particular, talking about what happened at Maules Creek. My colleague Kara, joining us from her home in Narrabri, will share some of her experiences as a Gomeroi traditional owner and the impact of Santos's Narrabri gas project, but also can speak about Whitehaven's Narrabri underground expansion. Jane is going to introduce herself in a moment. And Jane and I have worked together over the years also on the Maules Creek project. But in summary, I'm a non-Aboriginal person, so I can't speak personally on behalf of any First Nations communities, but I can share my experience. And so whilst I'm not a policy expert or a legal expert about how the legal system does not work and is failing Aboriginal communities, I'm nonetheless feeling capable, basically, of pattern recognition. And what I clearly see time and time again here in New South Wales is that the economic value of coal resources in particular almost always trump all other values, including Aboriginal cultural heritage values. So I'm pleased that this committee has taken on this piece of work, and I guess this Parliament and the next Parliament has the power to change that, and we appreciate the opportunity to be here today to have a conversation about that. So that's all I'd like to say on behalf of Lock the Gate. And otherwise, I'd really just like to make space for Cara and Jane to share their experience as Indigenous people about how the system has been failing Aboriginal communities.
Thank you. And so, Cara, would you like to start by saying a few words as well?
Yep, thank you. Thank you for giving us the opportunity to speak today on the Cultural Heritage Bill. I said earlier, I'm Cara Kinchela. I'm Gomeroi traditional custodian living on my country in Narrabri, northwest New South Wales. Gomeroi people are also going through a native title claim, so I'm also a native title claimant. I'd like to pay my respect and acknowledge traditional owners and elders past, present and emerging. Firstly, I'd like to thank Fred Niles and others who wrote the Cultural Heritage Bill, drawing attention to some of the issues which traditional owners like myself, custodians, and knowledge holders face. It is an opportunity for us to begin to improve cultural heritage protection laws, which are seen to be inadequate and disproportionate. Personally, cultural heritage workers feel our artefacts are not safe. They feel the conditions we work in are not safe. The traditional culture and heritage is not being cared for appropriately and subject to mismanagement, with government favouring state development over the protection of sacred and cultural heritage sites. Cultural heritage belongs to traditional owners and must be managed and mapped by those with ancestral knowledge and connection to that particular area. A Cultural Heritage Council may be able to support safe cultural heritage work. Enacting the United Declarations of Indigenous Peoples promotes traditional owners a right to may promote a right to veto near or on a cultural heritage site. There's also the issues around cultural heritage being used as forms of social licensing, and that that traditional owners, that we have been sidelined in the development of the consultation process in New South Wales for far too long. It is our country, and we should be given the opportunity to decide how our sites are to be protected. And I think that's it. Sorry, I forgot my Santos, and obviously living in a mining community, we've got Santos and Whitehaven. Live in Narrabri, so we're just off the Pilliga Forest. So we've got a lot of cultural heritage sites, and we've got the Pilliga Forest is massive, an intangible site itself, and how that works and the protections of that, whether the laws can hold up, whether the laws can determine how important the cultural heritage site is itself as a whole, and the tangible cultural heritage artifacts aren't being in a safe position where they can be safe or they can be accessed by traditional owners. And with that, was just some of the issues that we have to deal with in regards to cultural heritage management on country. Yeah.
Thank you, Ms. Kinchela. I also note we have Ms. Delaney John. It's just we can't see you without your video, which is fine, but we can hear you. Ms. Delaney John, are you okay to introduce yourself and take the affirmation?
Yes, I do apologise about the video. For some reason, it's actually showing my thermos.
That's
And
okay. It's a very lovely thermos.
and I don't know how that has happened. So, just prior to taking the affirmation, I actually would just like to say a couple of things because our country's never been ceded, and I need to acknowledge that before taking an oath. Yama Yama Day, Yama Gumirai Narubanyai Gumori, Nakambu Dung Naru Garambu Naru Kamilare, Nale Da Bruna. I actually want to acknowledge the First Peoples of all nations across all our countries, and particularly the elders of the Gulmari traditional custodians, both past and present. I've been actually asked to present today as Yinabiram, which means female shield or protector or matriarchal protector of culture. I take the affirmation that I solemnly, sincerely and truly declare and confirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And would you like to commence with an opening statement as well?
Okay. My opening statement is difficult. To be honest, if the Gulmari traditional custodians hadn't asked me to speak today, I probably wouldn't. We've had a 15-year defence of country over some significant projects in New South Wales where we have an alliance with a number of parties, including Lockyer Gate. However, we had chosen in that entire process to undertake only lawful practices. I'm going to give the example of the Whitehaven Maules Creek and also the Shunwa Watermark project and what's actually happened in relation to those two aspects, and the fact that there is so much broken in the systems now, in the policy, the legislation, that when we first set about trying to get protections in place, we went with some optimism that there would be legislation to protect. Having gone through the processes of trying to go through state and federal, including a federal court case, of which even when we've proven the burden of proof in relation to cultural and heritage and its value, we still have been denied protection. So while we're hopeful about the Aboriginal Cultural Heritage Bill, we know from experience that the best of intentions actually fall apart when it actually comes to the execution and what it looks like on the ground, and how other legislation actually overrules, nullifies, or doesn't even allow for an appeal process in that for state significant projects. The other is that the assessments that are done are not done, they're done by what is proposed to be independent assessors. And even if they have flaws in those processes, even to actually get that heard is not heard. The state government use the Part 4 process for planning and assessment, and that switches off a number of obligations that were already in place if they had actually undertaken a Cultural Heritage Act. And then through that process, everything, even if you want to try and influence the way you walk country, you can't. The archaeological assessors determine that this is how you walk through an area, and you walk in these lines and you look like you're looking for forensic evidence for a murder. And there's no reading the landscape, there's no looking for directional stones, there's no linkage between night sky and day sky, there's nothing in relation to the intangible evidence as well as the historic and tangible artifactual material. Everything's mitigatable in relation to it. And so what happens then is you go through this process, you raise your concerns, and it's just this drawn out process where you actually don't get protection in place. Then it gets triggered with a independent commission, and then section 4 there's a clause 20 that actually then, if it goes to the Planning Assessment Commission, it actually switches off automatically any rights to appeal. And so people get together and they can have public statements, and they make all these sorts of statements that are not necessarily proven in court or not even judged in court. And you have no legal rights to even appeal the inadequacies of the reporting framework to gain the protections. So for us, we would love to see an Aboriginal cultural heritage bill that is truly going to protect and give veto for that to happen. However, given the landscape that we've actually walked, it's very hard to feel confident that it's not going to be undermined by other legislation, whether it be at a state or at a federal level. And so what I wanted to do is to try and bring forward the voices of our elders who have passed and who are present, who asked us to do all things possible to protect Aboriginal culture and heritage. And to be honest, if we hadn't made that promise to them, I probably wouldn't be talking today.
Here.
I apologise if I'm emotional, but it is an emotional matter. So elders have sought protest approvals, and for the Whitehaven Maules Creek example, the proof of legitimacy, that are they the ones that are allowed to have a say? Are they the ones that are actually allowed to say what the cultural heritage is? They get marginalised, and the burden of proof in relation to that. So if we're not part of the coin of management plan implementation and surveying, collection, etc., then they are excluded from the process, because there's others, and they actually have government, I see, set major developers against Aboriginal people. They want to progress with their leases. They've invested huge amounts of money to do so, and they want to do the assessments, and there's all these statements about, you know, we're going to make it more efficient, we're going to actually make the planning assessment process so that you actually have this much easier and all the rest of it. And it actually is in direct conflict in relation to Aboriginal culture and heritage, where some things are just not compatible to Aboriginal cultural heritage. Doesn't matter what they're going to try and mitigate, it is not compatible because of the specific area in which they're actually wanting to do damage, and it is irreversible. So what happens is you've got this trajectory to conflict, and we're gouged by the dragline in a lot of these coal companies. And so within that conflict, the state government kept wanting us to be legitimate and prove that, you know, the voices of the elders are the ones that, you know, should be listened to and all this sort of thing. And yet here we were, and 100 of us who had actually been law-abiding had been made persons of interest, and our images were put up in the Narrabri police station. We had not been part of any of the 350 people that had been arrested on lockups and lockdowns and or whatever they call them, with the locks and things in the protest. We had not one Gomeroi person was part of that. And yet here we were, under the policing process, we were actually persons of interest. Now, I went to the Human Rights Commission in relation to this, and I went from state to federal, and we couldn't get anything. And I had a meeting with our community, and we just basically said, right, win, lose or draw, we will go back to trying to fight this. And so I went to the Hansard, and the Hansard looked at the COP system, the computerised policing system, and what happened with that was they actually identified that people could be profiled and used inappropriately. So we went to the Ethics Committee. We also went to the Anti-Discrimination Committee in relation to the fact that we were actually being profiled and we had been lawful citizens. And so in one stretch, we're identified and, oh, we're legitimate enough to be profiled, but on the other side, we're actually not legitimate enough to be actually listened to in terms of the cultural heritage values. And so we've had to fight that ourselves to actually change the COP system and to take our images off and to say that we're actually defending country. We're actually lawfully defending country, and had only ever gone for a lawful protest and had never been part of anything that was actually against the law. So you get demonised because you stand up, and you get targeted in relation to that, and it increases lateral violence in our community. Poverty is actually used as a weapon for those that get and those that do not. The other is that with this, we actually exhausted all of the state government's processes and we couldn't get anything, so we had to go to try and get a Section 9 and 10. To be honest, we were bounced around like there's no tomorrow. The minister didn't have to make a declaration, so he didn't. And so therefore, Lawler's Well and a number of sites, including a women's site, was actually destroyed. We weren't given access to the areas so that we could actually take the GPS coordinates that they were saying that we needed. So we've got no access, and it was just like this bounce. You ask for the access, we can't have access. All these sorts of things go on. We couldn't even actually do ceremony until we'd actually taken that to the Anti-Discrimination Commission. And because they had employed Aboriginal people, what we did is we did it under religion, because it was the only avenue that we had available to us to try and actually even go out and do a ceremony before everything got destroyed. There were sacred crystals on that site, and we actually just asked, could you just scoop them up in one of your systems because you're going to blow it up, throw it over the fence, and we will collect it ourselves. And we weren't even given that as an approval. So this is how low it is in relation to getting respect for our elders and to have protections. Everything is a movable object, and anything is up for destruction in that approval process. With the Section 9 and 10, we learnt the hard way. The burden of proof for the ATSIC protection is unbelievable, to be quite frank. Then Shanwell was the next threat in relation to what's happening, and there were others that we just couldn't do all of them because there's no resources, and we're just trying to do what we could. And this time we actually had pro bono support, and we tried again to exhaust all of the avenues in relation to the assessment process. The commission again was put in, so what it did is it turned off all legal applications to appeal in a court in the state government, and so we only had the Section 9 and 10 as a process. We didn't just do one, we did two. We've got hundreds and hundreds of papers in relation to it. We had a special inquirer go out with us. We had sacred knowledge. We had over 600 people part of all of that. We had 13 other nations who actually all stated that this is actually incredibly important. We had a decision that was made by the minister, and even though we met all the criteria of that ATSIC application, all of the criteria and the significance of the area had all been proven and acknowledged, at the end of the day, we were denied on the basis that there would be a social and economic benefit to the broader community because mining companies make money. Now, everyone will go, oh, well, we had a relief because, the state government members of parliament came out and they met with some of our elders, and there was some funny wording. It's all about the funny wording that goes on in this process. And what happened is They came out and they said, oh, you know, you saved the area. The next minute we find that we're not given mapping, we're not allowed to go out, and we're not allowed to actually find out what is actually going on, because some of the area was actually going to be put under the state government's process and the rest of it was actually going to be sold for agriculture. Part of the problem that we've got in relation to that is that we couldn't actually get the information. They knew all the areas. There was so much information given to everyone in the state government in relation to this. Then the GTC, the Gomeroi traditional custodians, are not unknown by people, whether they're agents for the state government or ministers. They do know this group, and yet they divided up the land, and we've got some of the sacred sites are now in agricultural land where it's up to the goodwill or non-goodwill we've found in some, and some goodwill with others in terms of farmers in relation to what they might protect and what they might not protect. We actually sought an application to have some heritage protection for that area, and because apparently we missed a date of a meeting by the committee, they wouldn't make the decision. They were going to delay the decision. Meanwhile, back at the ranch, everyone else is moving forward in relation to lands and everything else. We hadn't been told in any of the interviews that we had, which we forced those interviews to happen. We weren't told that there was a time imperative in relation to the meeting at that time, and the next minute we find that we still have all this uncertainty. And so this is where it doesn't matter where we go or what we try to do, we don't get protection. And so I'm just really worried that this piece of legislation will again have the same issues of either environmental protections come in, environmental assessments and state significant projects, and they wipe out any other right to veto or appeal or to have our rights heard.
Thank you. Thank you very much. That's very compelling. And I also acknowledge the pain in telling the stories at the beginning there. So thank you. Can I just ask you, if it's okay now, the three of you, the committee will have some questions for you, and they'll field their questions, and please feel free to determine amongst yourselves who the questions are best answered by. Can I just ask a couple of things? So firstly, is it generally your experience that you will apply for Section 9 and 10 applications for protection because is that generally embarked on as a last resort because the state system is failing? Is that what I heard?
Yes.
Thank you.
That's absolutely true.
Thank you.
And you can't make the application unless you have exhausted everything.
Right. Thank you. So just getting to the bill and the intention of the bill at the moment, it's seeking to establish an Aboriginal controlled Aboriginal Heritage Council that then determines the local lands services, the cultural heritage local land services there, that would then work on, nominations for protection, but also in relation to determinations for harm. At the moment, there has been some concern around the constitution of that Aboriginal Cultural Heritage Council. Do any of you have views on that council and the constitution of that council?
Yeah, I had a really good look into it. Honestly, the first look I had into it, I turned off it because we have an issue about representation on country with traditional owners and coming from dispossessed people and a lot of things are happening and the Land Rights Act is actually based on economic development over native title being about native title, traditional rights and interests over an area. So there's a lot of conflict between them acts in themselves. And then so it's sort of the choice that you have to make between native title or land rights as well, and whether you profit from the destruction of country or not. Yeah, and look, just in general of the council, I reckon it'd be, I look at it and I think, look, this might be an area to sort of dissolve what's happening between land councils and native title at the moment, and that there will be proper management of who speaks for country, and whether the council can address that situation, which I believe it can, if the right people are in it, that I believe it can be managed for First Nations people to be able to have that voice. And you know, because what we have happening on country is we'll have certain individuals who will say, well, you know, the cultural heritage, we're not, we're within the land councils, but we're not connected to the artifacts or the sacred sites, and intangible sites as well. So yeah, and who manages that? So I think if we bring that up, get it away from land councils and put it into somewhere where we feel like First Nations people like myself who feel like that I'm being, that my voice isn't being heard over people who aren't technically from the area.
Thank you. So from that, I gather you think that the Aboriginal Cultural Heritage Council, Aboriginal controlled, is a good idea, but making sure that the Constitution is the right voices on that council. And from what I can gather, you were suggesting there that really the role of the land councils shouldn't be a kind of majority or monopoly role.
Yeah, that's right. Land councils build like in Narrabri. The land councils build up relationships with mining companies. Working in good faith for protection of country and and employment for people. But mainly protection for country and just being feeling comfortable that our land's being protected appropriately, and who's managing that. So and right now our people don't feel like we know exactly who's managing our cultural heritage in general. So if we have that, I think it'll comfort a lot of our people on country, knowing that our artifacts and our sites are being processed properly and being documented properly, and that's not being done by just one organization in one town.
Thank you. I've just got one question about the experience, and this may be Ms. Delaney John. Just going back to that experience, I think it was around Lawler's Well. Can you just explain how that situation happens? So where there are, as I understand it, registered Aboriginal parties that are perhaps suggesting that the mining company or the particular proponent is doing the right thing, and then there are traditional custodian voices that are saying, no, this is not the right thing. How does that situation actually come to play, and how does that play out?
What occurs is there is a program of works where people are earning around $650 a day. And then you've got those that are trying to protect. So, for example, in the Gomeroi traditional custodians in relation to Lawler's Well was named in relation to a bushranger. That bushranger was an Aboriginal person. That bushranger is actually a Gomeroi person. And his direct descendants and elders voiced those deep concerns and connection, and yet their voice was marginalised. And so what happened was, over time, that particular well, which is part of a dreaming story, which I won't go into, but it's part of a dreaming story and it was documented. And it was in the confidential section that went to Federal Minister for Environment. So what happened was Rio Tinto comes along and says, well, we actually dug and made a well out of there. And that's true. They did go and do an overlay and dig over the top of a sacred area. But they then marginalised the fact that, oh, well, this is desecrated, so therefore, you know, we deepened it, we made it look like this. And so therefore, is it still a sacred site or not? And so you have companies working with companies, and Rio Tinto came forward and did all this stuff. And so it doesn't change its value. And in fact, the fact that the cultural values and the traditions in relation to that area, and how even prior to it being called Lawless Well, it was actually part of a pathway where in a deep forest in drought that it would have water. And there were so many artifacts around it that showed the repeated visitation. So the other is that archaeologists tend to dominate the discussion over ancient, not in relation to continuum and the changing needs. So, for example, in the Maules Creek, in that area, there was a Goomeri woman run down. It's documented as being run down in Back Creek, and yet anything that's said or anything that's shared is just all marginalised. We had families that had a burial area there. One of the elders, their family member was buried there, and that area just gets destroyed, or they did an examination of an area and they couldn't prove that there wasn't a burial, and we couldn't prove there was a burial because of the way in which the evidence occurred. But they then proceeded to do a fence, and the fence actually went directly where you needed to go further out than that, and they actually fenced off on top of the burial. And then we're going down there to do ceremony, and they're making, this is even before it became a fully active mine, they're making us wear helmets and high-vis and boots and try and hand them out to the kids so that we can actually do a traditional ceremony, smoking ceremony in that gear, all this stuff. And so you've got these layers and layers of failures. Everywhere you turn, it's broken. So the contradiction in terms of what's verbally told to the community understood that Lawless Well would be safe, that they would have 30 years in which to actually have this big argument in relation to its protection. Then they find it's under threat immediately. So we tried to put a section 9 and 10 because we had absolutely no other avenue possible to protect. And then that still failed.
Thank you. And can I just finally on that point, so when you say there were, so were there, Aboriginal parties suggesting that what the company was doing was okay, and then there were voices that were suggesting otherwise? Is that ultimately what played out?
What happened is they brought in people that are from, they're Goomeri, but they're from outside of that direct area.
Right.
Of knowledge and connection. And then what happened was they acknowledged that it was of cultural heritage value, but if they took the artefacts that were surrounding the well, then they could blow it up, basically.
Thank you.
So when you actually ask that question in relation to the Heritage Council, one of the concerns that we have is that in any model that's actually going to be created, is actually going to be a non-traditional model. The cultural heritage will be formed in whatever form that's actually not necessarily in basis of the traditional way in which decisions are made. So there needs to be always the ability, and it needs to be reflected in any legislation, that those that actually do have traditional knowledge that actually can actually prove and have information and they want to have the right to appeal a decision should still have the right to go to court, should still have the right to actually put the evidence on the table, and they shouldn't be denied access to get that evidence. So if there's a failing in the Heritage Council because of corruption or other stresses, economic stresses, etc., we found that, you know, the Land Council is a statutory authority that's supposed to protect Aboriginal cultural heritage, and yet to actually have them try and do the protection of Aboriginal cultural heritage were very tardy and very late and very toothless in that process. They had investment issues. They wanted to get leases for coal seam gas at the time. Because they're needing to have economic sustainability to be able to provide support, because they're actually focusing also on the poverty levels of our community. And so this is where you've got this conflict and the lateral violence that occurs, and it just feeds into that lateral violence.
Thank you. I've taken a lot of question times. Reverend Nile, did you have some questions?
Yes.
Thank you. The Reverend Nile's just going to ask some questions.
Thank you very much for what you've been sharing with us. And like other members, we all grieve with you over the way the Narrabri group were treated and being treated as if they were criminals when they're doing the right thing. So we support all your endeavours. So just following up with some questions, I note that, as you know, that examples of state significance are supposed to have special protection, but they don't have any protection as far as I can see from mining and gas projects. How do you respond to that?
Cara, do you mind if I just make a comment on that? Absolutely. In our experience, there's been no protection whatsoever. Okay, it's just you just they're so big and they're so wealthy and there's so much at stake, and we are so under-resourced, and we just try to do what we do because it's about the fact that we have a saying that we'll never win in this system, and people say, well, why do we do it? And it's that we're not a campaign. We're defending country and we're defending culture, and we're actually, you know, there was the 3rd Regiment that went through, and there was war and violence, and people died, and it's not about whether we win. It's about being able to tell grandchildren and children that we actually stood up. Regardless, we don't win against mining companies. We just don't win against mining companies. And, you know, we requested even the interim heritage order for the lands associated with Watermark, and we haven't been able to even achieve that, even though the ATSIC Act and the decision and all the documentation prove how highly significant that area is. We're not even able to achieve that.
Good. Just following up that question, what are the key features you would want to see in any Aboriginal cultural heritage legislation?
The absolute right to veto.
And just following up that question, if you were Premier tomorrow, how would you unite all the Aboriginal cultural stakeholders to reach an agreement on the way features that should be seen in an Aboriginal cultural heritage bill, which is what we're talking about? Any of the witnesses can answer the question.
It's difficult with the legislation that we've got. Like I mentioned, the native title and land rights legislation conflict. So while our people are being forced to work within conflicting legislations, it will always cause conflict between groups. And just finding that balance of economic sustainability and development, as well as traditional rights and interests. It's a fine line for us Gomeroi people, especially with the excessive amount of mining and how we live within mining communities as well.
Thank you. Any other questions?
Well, just following up that question, what would be the way in getting other native stakeholders and Aboriginal others to see the merits of the Culture is Identity 2022 bill? That's the title of the bill we're discussing now.
Yeah.
Culture is Identity 2022.
Yeah, look, I'd be happy to have a crack at that one, Reverend Niall. For me, I think it's about storytelling and education in the community. I think as a community, when we start to understand more of the significance of these sites, of this, rich, living, dynamic Aboriginal cultural heritage and, oldest surviving culture on the planet, when we sort of start to hear more stories and of particular places and learn about those places, particularly in this moment of the Uluru Statement from the Heart and this national journey that we're on, led by Linda Burney, the new federal government, I think there is a immensely significant opportunity for us here in New South Wales to come together on a shared journey. And I think protecting cultural heritage and a process led by and co-designed by our First Nations people can get us on that pathway.
Thank you. Okay, we're running out of time, but Ms. Sharp, you can finish up with for us.
Thank you. Thank you very much for coming along today, and thank you for telling us in really stark terms why the current arrangements are failing. I really appreciate that, but I also know that takes a lot out of you every time you've got to do it. Ms. Kinchilla, I wanted to ask you particularly, you made a comment earlier on about getting the right people on the council. As non-Aboriginal legislators that are trying to wrestle with all of that, who do you consider to be the right people in terms of the makeup of the council?
In regards to cultural heritage and finding who belongs where or who comes from where, it would be native title. It would be that process through, at the moment, it would be processed through native title. I know there has been some there are issues with the Native Title Act as well, and our determination we don't have our determination yet, but through native title you have direct access to people from the area and who still live in the area. So to be able to to go to the traditional owners would be that way.
Thank you.
Oh, thank you.
Thank you. So thank you all of you for attending and for your evidence today. We're very grateful. Thank you.
Thank you.
Thanks.
Okay. All right. I now welcome our next witnesses. Thank you very much. I note that you're all there attending via WebEx. We're very grateful for your attendance. So could we please start with each witness, please state your name and position title and swear either an oath or affirmation. And you can go in whichever order you like. Thank you.
Hi, my name's Mavis Ahoy. I'm the chairperson of Wangan Traditional Owners of Armidale. I'll do oath. I swear that the evidence now that about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you.
I'll go next. I'm Reece Newmack. I'm the Aboriginal Community Engagement and Culture Officer at Armidale Community Corrections. I'll do your affirmation. So I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you.
Hi, I'm Dallas Ramage. I'm a director of One Connection Disability Services here in Armidale. I'm going to do the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by myself shall be the truth, the whole truth, and nothing but the truth.
Thank you. And is
Arnie Rose is just about
I was just about to say, is Rose going to join us?
Yes.
Thank you. Hello.
Hi.
If you're happy there, Mrs. Lovelock, to just state your name, your position, title, and then either take the oath or affirmation. Thank you.
Rose Lovelock, Director of the Aboriginal Culture Centre and Keeping Place in Armidale. And I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth.
Thank you. And so would any of you like to commence with making an opening statement?
Arnie Mavis?
I'll give you copies of that from last week.
So Arnie Mavis would like to do that. She's just giving it now.
Thank you.
Reading some of the bill over the weekend and speaking to some of the elders, getting their advice and that, so it's sort of half and half for it and against the changing of the bill. Now, it's been proven in the higher courts that Australia were inhabited by Aboriginal people when Captain Cook landed in 1788. That's already been proved in the High Courts with Marbo, and with saying that, with native title, it's need to be shaken up and some changes need to be done with native title about how long it takes for get a result from native title. With our understanding, it's 18 to 20 plus years to get a result. So if I'm fighting for native title now, and it does come my way, or if it doesn't, in that long, I won't be around to see it. Same as Marbo. He died 4 months before but his result was good. I don't want to do that, so I'm saying that he told me to be shaken up and changes there did shorten that span of given, which is the rightful owner of each country, nation. The other one is Land Council. It really needs shaken up. That's speaking on the experience with our local Land Council. We've the changes that's been done is in the last 4 or 5 elections, it's changed to the west towards the Aboriginal people, local people, especially making our state allow wider, our boundary wider, instead of keeping it smaller. We've only had about 7 local land council on our side. Now we've got about 20 or plus, and there's one man at the helm now is running that. I think we should bring back in the region land council. The local land councils should, and always should be, that if you're a member of the local land council, you should be the person from that country, that nation, not from Timbuktu, from other say, I'm the chairperson of this local land council, and they're not originally from here. They're giving our lands and selling our lands and that we fight for and sit and protest on years ago. For example, I sat and built my on just the outside of Armadale for 6 months with my 4-year-old son. We camped in this shack for 8 years. Then we ended up getting the land. Then 2 elections back, the chairperson of the Lout turned around and sold that land. So this is where land councils need to be changed, and the people from that area should be the only one on the land council. Everybody come from Timbuktu and selling our land. The other one was National Parks and Wildlife. Now that really needs shaken up. I've got a long story there, but I won't go into it. I'll just do the basic. The national parks are doing wrong by us. And they've always been doing wrong by us. They know that, for example, here in Humber, we've got 2 tribes fighting over what country this is. We've got Bumbanga, which is myself and my descendants where I come from, and you got the Hanum. I don't know where they come from, but this is the things that are going on in here with our local. And Parks and Wildlife is doing wrong by saying they've got people in these high places, and when you've got people in high places, they say yes, that's it. Then that's it. No one can do anything else about it. For example, Mount Yao, we know that's not Armadale, under part of our country, our nation. We know it's belonged to Kamilaroi and that. We were told by our past elders, my grandmothers and everybody, great-grandfather, they told us we're our boundary. We know that boundary. We know that's not ours. And Parks and Wildlife sent us a letter, written letter, to say that we had to sign a part of that mountain if we want to have a say over another mountain, which is in our boundary. We had to sign for Mount Yao to be part of that. And I don't think that's right. And things like that, what Parks and Wildlife is doing to our people and our artefacts. People find artefacts on their property, fence it off, protect it. Don't pick it up and move it somewhere. That's not the way you've done it. Look, it's put there. It's put there for a reason. Not to go out there and dig it up and move it and put it somewhere else. And if the farmers own the property, just fence it off. That's what we ask, to protect our past. We can't move forward without our past to our future. And heritage is our land, our country, our songs, our walking trails, our stories, and that's the way it should be. Not somebody writing down saying, oh, yes, Annan people, they work in native title, or they work in Parks and Wildlife, and that person's saying that, oh no, that's Annan because he works there. And Parks and Wildlife was believing them and cutting the other tribe out. What my suggestion is, I don't know that the other 3 here, is that some of it needs shaken up and some is good. And with the bill, I think they should take notice what Aboriginal people are saying and not just taken it from one person. Go into the community and find the truth. Now, I'm a 5th generation from King Bobby here of Armidale. Now, he's in the first white man come here to Australia. He helped build Armidale. This king, we've got proof, we've got photos, and yet they're all saying it's animal. What are we got to do to say that because Parks and Wildlife is saying no, they're an animal? There's one family that's saying it, and they're in these high places. They need to be checked. Same as the DAA, the registrar. They need to get out and come back to our community, to the ground, the grass people. Not us taking that as someone in the office and say, oh yeah, I did a report, I spoke to this person. Go out to our people and sit and talk to our elders. That's all I've got to say. The rest, thank you for me speak.
I think in a nutshell, just to wrap that up, sorry, it's Reece speaking, by the way. Just on behalf of Marty Mavis, it is a fractured community here. And to note that this was actually sprung on us last minute. The tableland wasn't put in consultation initially, which is very alarming considering the fractures that go on here. I'm actually tied in with all 3 mobs that are a part of that bit of a divide. And it does sort of stop us moving forward as people as well. So in relation to this bill, I think it's important to note that changes are okay, but you've got to fix the things in the past first before you can move forward with change. But yeah, I think we can move on into the questions if you like from there. Thank you.
Thank you. Thank you, all of you. Does anybody want to start and lead? I don't want to hog the time again.
Go, Penny.
Well, just
go on, Reverend Niall,
perhaps
you
just to get a
start.
summary for what they've been saying.
Yes.
What are the key features you want to see in any future Aboriginal cultural heritage bill, which is what we're discussing? It's your opportunity to shape the bill.
A holistic approach to community consultation. No, not just going out and nitpicking who they want to go in there, because there's more than a handful of people to one community. Like 1 to 5 people don't make up one community, and one nation doesn't make up the Aboriginal community of New South Wales. So it needs to be a holistic approach across all our mobs in order to get the best outcomes for moving forward. But you've got to be prepared that for us to move forward, like Reece said, there's a lot of fractured communities and there's a lot of broken promises from the past that need to be mended and need to be reconciled.
Thank you.
I might just ask a question.
Yeah, thanks.
It's Rose Jackson here. Thanks everyone for coming along, making some time to talk to us. It's incredibly important to hear from you. I think one of the things that has definitely been raised by you and by many other groups is just the importance of those local voices. This bill envisages a statewide council, I guess, advisory council, and the bill talks about them engaging with local groups, but maybe there's not a lot of detail about how that might happen. And I'm hearing from you that that's incredibly important. And so I guess I just wanted, to hear a little bit more from you about why you think a sort of statewide advisory council on its own, without those local voices, isn't going to work.
You're dealing with 60,000+ years worth of culture and of our Bible, of our beliefs. So I'm going to give some prime examples here of 240 years worth of history here in Australia, like colonisation. There's more protection around those sites than some of our sites that are 40, 50 2,000-year-old. And at the end of the day, like I could walk into a church, and this is an example, and deface the church, and I'm facing criminal charges. But a mining company that's going to go out to make billions of dollars out of destroying sacred sites for profit, and they get a slap on the wrist. So community consultation, but a holistic community consultation. When a mining company or someone that's going to make some form of economical value from our country, they need to come in and see what it actually does. How what they're doing is breaking and building on identity trauma. Because once you start breaking our identity by us losing our culture and our sites, and that's when we're going to start going backwards again. And it's like 3 steps forward, 10 steps back. We can't do these 10 steps backward.
And I would imagine in terms of the damage that you're talking about that can be done, it's not just damage to physical sites, it's damage to intangible things as well. We've heard quite a lot of evidence about that. It's not just physical places, although they're very important. It's some of those stories and those more intangible things that can be damaged as well.
Our rock art is no different to your Bible. Our rock art isn't rock art, it's our Bible. It's our story. It's what our ancestors tell us how to live and how to be and how to treat others. No different to the Holy Bible.
And I think in a different approach to coming from someone, so I sit in an authority figure with community corrections, and when you say consult on a bigger level rather than just like a sort of committee, so to speak, it's very important when it comes down to those broken promises. In order to get the right voices, you've got to win their trust. So you've got to come to them. And I guess to mention, for example, this meeting, the day after our Koori knockout, which is our heart and soul, that we haven't had for 3 years, I only had 8 days to try and get who's sitting here today, and because everyone had gone away. But a lot of people are scared to even approach these types of things because they're scared of, those broken promises or just facing the government, so to speak. I remember when I first come into my role and I actually asked people, what do we need with the change? And they were like, oh, you actually want to listen to me? And I was like, yeah, that's what I'm here for. So, yeah, I think consultation on a bigger scale is very important, and it's going to break down that stigma between us and them when you look at Aboriginal people in today's society.
Thank you. Yeah, go on.
Well, I was, for example, we've asked native title to come up and do a workshop with us. I've been involved with going down the Nambucca and that with native titles since day one. And that, if you're related to King Bobby, we was allowed to go down there amongst that. Big classed as that. We thought Armlay was part of that. It led to lie that we wasn't. Now, I've asked native title to come up here almost a year and a half ago, still waiting for them to come up. And just to come up and do a workshop with us so we know and understand what native title is all about and how do we do it. Digging pieces from the past and putting them somewhere, it's supposed to be safe, but they're going elsewhere and they're being sold to other people. This is some of the things that's happening in our community. Is this bill going to help us stop that? Or is this bill going to say, no, we don't care about what they say, get rid of it, trash it?
That's what we're trying to figure out.
Essentially, that's what this inquiry is trying to get to. But essentially, the bill as it's proposed has some pretty key features that we actually haven't seen proposed in a bill ever before, and that is, and of course, the bill features the ideas that have come directly from First Nations people from consultation over the last 20 years, really. So one of the things that's put forward is an Aboriginal controlled and an Aboriginal constituted council that then determines these local land cultural heritage services on the ground, which would be made up of people who have cultural authority and speak for country, and a process of trying to work out who that is. But I'm just wondering, there's two particular features of the bill, and I'd just love to hear your views. So one is the idea that if a proponent or a developer or a mining company or whoever the proponent is seeking to develop land upon which is very sacred, and I know that's controversial in and of itself, because we understand that all land has importance in some way or another. But if there was a project that is proposing to harm and perhaps destroy forever really significant tangible or intangible heritage, it gives the Aboriginal Cultural Heritage Council the right to say, no, you can't do that. And at the moment in New South Wales, there is no law that does that. What do you say to that part of this law?
That's why I think we need to stop that, because we've got people going on there buying land up here now, all the way around us, and buying land up there, got sites and everything on it, and they want to dig it up for gold. We don't want them to do that. And if they do it, what have we got then? Now, I'm going to say, do we get royalty, or we don't if they damage the sites? And which we don't want them to do, but if they do, what is it for us?
Compensation.
Yeah.
I think, so we've already got a site out at Urella when the solar farms come in play that they fenced off. But by doing so, we don't have access to that site anymore. It's all well and good that it's preserved, but we have no access to that. And a lot of people here in this community still have connection to that site. And it's very important that they have that connection out there to be able to go there. But because it's now on a solar farm site, you can't go there. So because of safety reasons and so on. So a lot of that bill and, that part of the bill needs to be taken into account, I guess, in sense to, obviously, if that's, that's great that they protected it, but how do they still get access to that?
This is what you call like sellout. They shouldn't sell about people selling our things out, let the rest of the community know. And that's why we've got nothing. We've got people selling out.
So can you just elaborate on that point, people selling out? Can you just elaborate on that, please?
Well, it's our home mob going out there and saying, showing them sites, and that now they can't get access to it, and they want to. That's their fault for selling it, giving them permission to walk on that land. They said, no, don't walk on there. They still have the access to these sites.
And do you think did that happen? So, and is it your understanding? Did that happen through the registered Aboriginal Party process, or is that because they're connected to the Land Council, or how did that happen? That particular example. Land Council. Thank you. Thanks. And sorry, I think I may have cut you off. I'm very sorry. I didn't mean to, Dallas. Sorry.
No, you're right. Another thing that I want, we need to make sure that is airtight, because for years and years and years, organisations and corporations pay lawyers big money to find loopholes. And, that's just the way of corporation. Let's find a loophole to get around it. We need to make sure that all this is airtight, because a loophole could destroy 50, 60, 70, 80,000 years worth of culture.
And I think that we're at a point in time where we know the flawed approaches that have occurred in the past. And yeah, we have to have some role in it where we are the people that are consulted, not directed. You can't have a successful outcome without it being shown to be that, yeah, I agree, national parks and wildlife shouldn't have that much of a say in our dealings on land and with culture. But I also believe that governments need to look a bit deeper as well, because I think there's a lot to be said in respect of how that's managed. And I think we're all looking for self-determination and self-management, but I think there's a need for us to be recognised as having a fair say in what's happening to us as communities.
And I know, like, we've been throwing national parks out there, but there's other government bodies out there like New South Wales Rural Fire Service. You know, they're quite blasé when it comes to getting the backbone in. They won't. Well, then I'm a captain of the local brigade here, and the cultural awareness training for the New South Wales Rural Fire Service is absolutely atrocious. And it's about burning paddocks or burning timber. You know, their new computer system that's going into the trucks doesn't even have the capabilities of having AIMs on there to see if there is any sacred sites or any site of significance nearby. But I can go on there and it'll tell me that there's a cattle farm up the road here. So, like, there's been a lot of money spent in building this tablet, this technology, and we've already got the technology there to lay that map over onto the tablet to let us know that there's a site that needs to be protected, but it's not even thought about, because preserve life, preserve property, you know, no preserve culture.
Thank you. Very compelling point. Mrs. McDonald.
Thank you for joining us. I wondered, like, with the bill, if you've had a chance, where it says the Aboriginal cultural heritage, the meaning, do you think that encompasses what you'd like to see as Aboriginal cultural heritage?
Myself, I say that let a committee mob do it with at local level, at ground level. Let them do a committee there, or take it to the community, and let the community decide on who's going to be on that committee, and who's going to speak for us. They're going to put their hands up for us. Us four can't make all this decision on our own without our people. I'm only here because I'm chairperson of the land council. The Gumbanga elders, descendants, I'm the chairperson there. And I've only got this here, I said 8 days ago, and I didn't get a chance to go through it. But I've got somebody to go through it and look at it, and they written down forms for me in that. And some of the elders, it's really up to the elders and some of the elders in that. It was good. So the thing is he's got all the power in the local land council, the registrar, Parks and Wildlife, I'm missing anyone, the State Land Council. We don't know where we are here with the the local land council, and they're the one that's making the decisions for these big companies go out there and destroy our our sites and that, it all falls back onto the local land council. Now, on this local land council, because half of them are all not from this area, yet they're making a decision on our sites and giving them the approval. This needs to stop. This need to go back to the members of the local lout and make a decision, not 4 or 5 that sit around the table and give them, say, do this and do that when they're not from here. Then when they do send somebody out on site, they're still not from this country. And they send white people, their son-in-laws are out there to do the sites. And that all give them all this big money and destroy our sites. This is where the CEO to get in there and change some act with the local land council. Same with all of them. They all need changes in that. And if you've got people up in high places working in government agent, and they know there's something going on in your own town, they should say, no, well, conflict of interest, I can't go there, that's my own town and country. No, but they sit up there in those government aids and say, oh no, do it, this is that country, just do it, I know it. This is where it needs to be changed. And those people in those government agents that make these decisions for the rest of the community should not be allowed.
Can I ask another question, and probably to Reese and Dallas? We heard from Jeffrey Winters, who's the CEO of Justice Reinvest, this morning, and he said if say we got this right, it would be empowering, or what was it? Something to do with, I guess, the trauma that and because I know you work in disability and you work in corrections, so it would empower the people that you work with?
Yeah, so in a nutshell, Dale and I help collaborate a program that we call Brothers in the Dale here in Armidale, which is a chance for the men to rekindle their identity and build on their strengths, separate the behaviour from the men, and create a stronger men in the community. And culture is identity, is what that is. That's what it does. Because too often, we've always focused on the negative rather than who they are as a person and their contribution to the town that they're in and who they are. So yeah, look, when it comes down to, I guess, to twist this a little bit, talking about that council, it comes down to a voice in that. When I got this handed to me 8 days ago, those same men that I speak of, the Brothers in the Dale, actually participated in the consultation process in us 4 sitting here today. We had men that are on orders that are looked upon too often by the justice system as, the too hard basket. They were sitting here talking culture with us, what needed to happen for their people. So those men had a voice in that. So yeah, it is very important and it is about change. My only concerns, Aileen, would be when looking through the bill, some of the repercussions of, breaking some of those laws. It is like Arnie Mavis said, it is sometimes our mob that do it to mob. Are we going to contribute to to actually furthering that gap from closing with some of those harsh punishments? Or are we working towards closing a gap, which is what we want in long term? So we really need to make sure that those punishments are, taken into account. For example, if it is mob that's breaking some of those things, are we looking at things like circle sentencing and so on and so forth, where mob is still in that say? Are we looking at programs like Brothers in the Dale in the community to keep mob out of custody? Because we know institutions don't work, like jails and so on. So yeah, that's things that furthermore I'd like to see down the track into what that bill's going to look like and what comes from that.
And furthermore, just to add to what Reece said, it's the youth that we need to start educating with now, and we need to have that access to all these sites, not some of them, all these sites, in order for, and I'm not going to sit here and talk out of protocol with law and whatnot, but there are laws of the land and laws of our ways that are being inhibited by not being able to gain access to these sites or not being able to go and practice our ways on these sites. So I'm not going to breach protocol around our ways, but you can get the gist of what I'm trying to say. And in order for us to start moving forward with these young ones, this is going to make Reese's job hopefully easier in the future with less people offending, because look, if you don't know your identity, you don't know who you are. And that's traumatic. And that leads to so many different avenues in life. Some people make the right choices, some don't know what their choices are because they don't know who they are. And I'll leave it at that.
And just to add to that, I think that some of our historical trauma, as they call it, we say the trauma is still living. We're still living with members of families that have been separated and are now looking back on communities and trying to find where they fit and what they should be doing. I think that we haven't paid enough attention. When I say we, I mean non-Aboriginal people, because it's been the case that that's been inflicted by non-Aboriginal people toward Aboriginal people. And my mother was taken at the age of 5 and brought back at 22. I'm a living person in a setting where I'm expected to be able to teach out culture, teach out history, teach out heritage. And from that, I don't think enough care has been given to allowing us to grow even further within our cultural and heritage and knowledge of the environment we're in. I think we're the best people placed to be able to give advice and ask for some sort of way of dealing with the neglect we've suffered for too long.
One more thing, going back to the local land council, because we this community is in Splitton too, and native title's taken forever to come meet with us all. My organisation got upon themselves to go out to all the surrounding nations around Armidale. So by saying that, we went over to Inverell and Tyndale, met with people over there. They took us on their special tracks, the old mission where they bush tucker they had back in the days, and what point they tuck out and what they stayed in and the environment and everything. It was a beautiful day to go over there to see all that. We've doing it in Walcom next month. We're going down there and speaking with them to do a treaty between all the neighbouring tribes around us to join and say that, yes, you are a neighbouring tribe, and sign some sort of paper, say the boundaries. We do the same back to them. The Dungutty elders down Kempsey, we've met with them. With the Ori people down in Bumbanga country in Coffs Harbour, we met with them. Ashfield and that, Lennox, we met with them. I've had, out of our own pockets, we put in our preschool hall, they've got a big hall there. We had a meeting in there, and we had about over 50 people turn up for the first meeting who come on board and sign this treaty, because the Land Council and Native Title has taken forever. They couldn't get up here and help us out. If we don't get recognised now, what is our future? And then what are we going to lose? we took this upon ourselves. This is where I'm saying I'm so upset with native title in land council. Now, I was speaking to some of you colleagues, ministers, and they're willing to help us. Ministers from where you thought are from down Canberra and that. I've got another meeting with them, some of them on Monday. Talk about our issue, and this is one of them, not this bill. So I hope that when you do make a decision what you're going to do with this bill, please let us come back to the community and let us all know, just in the community, that just us all. Yeah, I know there's funding out there to go out to the community and see and hold a meeting there, a community meeting. No, let people know and form a committee out of that for this area or for the whole region. I'll say no more on what I've got to say. I'm just happy to be here today to speak my mind, and I've come across some help with some changes with the bill and liking it.
Suppose I'd just like to also formally acknowledge Aileen McDonald for actually recognising that we weren't represented as a community. So thanks, Aileen, for that. That shows that there is change moving through the system in a positive way, because this consultation, I believe, needed to happen. The timing was pretty ordinary just because of the knockout and the time frame. Like we had when we formally met last Tuesday, I'm going to be honest, I've read about maybe a dozen pages from the bill so far out of the 119. So I do have some reading to do now. When it's over, I can put a bit more time into reading.
Thank you.
Thanks, Alan.
Thank you. Thanks so much for the candour as well. But look, it is, and if I can just say on behalf of the committee, we all are not particularly happy about the timing. It's been really challenging. If we had, Reverend Fred Nile introduce the bill, because basically we've been waiting now for the government to introduce a bill since 2018. And we haven't seen one. And I think Reverend Nile was getting more and more concerned that this term of Parliament was going to end and we would still not have standalone cultural heritage laws. So I think the pressure, recognising that the intention has been very, very good, time hasn't been on our side at all, but that the Parliament has asked us to undertake this inquiry, and that the committee secretariat has done everything it can to try and reach out in the short period of time. And really, we are just so grateful that you have participated and that you have appeared today and that you have given time to having a look. We are so helpful, so grateful for your help, and it's going to help inform the report that comes from this inquiry. And no matter what happens with this bill in this term of Parliament, all of your evidence will be now on the public record forevermore as we walk towards the journey of getting standalone cultural heritage laws. We know in New South Wales it's not a question of if, it's a question of when. So that's what we're working towards. So on that note, we are out of time. And on behalf of the committee, once again, thank you so much for your time and your effort and your evidence today. Thank you.
Thank you.
One more thing.
Yes.
Before you go. Sorry about this, but
No, don't be sorry, please.
this bill that we've got here, no. So when you decide to make your decision, will you go back and change things out of it, or do you send it back out to the community and let them know what the changes are, if there is going to be any changes?
So our role here is to make a report, to draft a report for the committee members to agree on the contents of that report, and that report will have findings and recommendations about the bill, and then our job is to present that to the Parliament. And absolutely, I'm sure that all the participants will be made aware of that report, but ultimately the bill, what the bill looks like and what happens to it will be up to all of your elected members of Parliament. They will be the people who make the decision whether this bill gets supported or whether this bill doesn't. We know that there is some real constraints about whether there will actually be time in this Parliament before the state election. This Parliament will finish and do its last sittings before the end of this year. And so then there'll be an election in March. So as I say, regardless of what actually happens to this bill in this term of Parliament, this report will be enduring and will be on the public record forevermore. Thank you. Thank you so much for your participation, your time, and your sharing all of your knowledge. Thank you.
Thank you.
Thank you.
Thanks.
We're online. Okay. Welcome back, everybody. I now welcome our next witnesses, and if you could please state your name, position, title, and swear either an oath or affirmation, we would be very grateful.
Shall I go first?
Yep, thank you. That would be great.
My name is Michael Young. I'm a traditional owner, a native title holder. I was also on the AAG in the Willandra area, Mungo National Park. And I'm a Parkinji Perenchi person under the Barkinji Nation.
Thank you, Mr. Young. And are you comfortable to say either the oath or affirmation there for the purposes of the record here?
Sure, I will say the affirmation.
Thank you, Mr. Young. I'll read that out, and then if you're happy to just confirm that. So the affirmation reads, I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Yep, you're content with that?
Yes.
Thank you, Mr. Young. Right. I also understand, Mr. Cyron, you're there too. Would you please start by stating your name, your position, title, and also to swear either an oath or affirmation? Can you hear us there, Mr. Cyron? I know we can't see you, which is fine if you haven't got your video on, but can you see if your sound is working?
I put the video on.
Aha. It's okay. I think he's coming. Hello there, Mr. Siren. We can't quite hear you. Perhaps there's a mute function or a button or a volume or something to press there. No, I still can't hear you there. Is there, perhaps it's the headset connected to the device that may be an issue? No? Okay, well, okay, so the alternative is, Mr. Siren, we can send you a phone number to call so you can participate by phone, if that would be helpful. Yep, okay. Thank you very much. Perhaps if you are content there, Mr. Young, would you like to, do you have an opening statement or some words you would like to talk to the committee about in relation to the bill?
Yes, just a short statement that I don't believe this bill is contemporary enough for what we envisage in New South Wales. And I think it will cause conflict, particularly with native title holders. There seems to be the pendulum has swung in an opposite direction, and native title in New South Wales has been relegated to a rather low level within the New South Wales. And I feel that that in itself is going to have flow-on effects within the communities, in particular also for lateral violence. That is my main concern at this stage. Due to the structure of it, the powers that are going to be handed over to, for example, Land Council, doesn't serve native title holders in any way. And it conflicts with it. We'd probably have to go back 200 years to the native police before we come across anything that is close to this sort of style of legislation. And I feel that it just does not serve any purpose except for maybe the property lobby. So I feel that native title holders are the ones that are going to be losing out mostly with this proposal if it ever gets put forward. And the destruction of that is also, I feel, we've taken 18 years during our native title to get to where we were, using proven methodology, anthropology, etc., to establish who the original families were in our area. And I'd just like to draw your attention to the Nellie Johnson paper that I sent through earlier. And that gives us a brief history of our family. And yet we still have no seat at the table. As a matter of fact, we've been, if we ever objected to any moves, particularly in Willandra, the Mungo area, we ascended a destruction in May of Mungo man and woman, and we feel that that was a travesty as well. We were not represented there, and we feel that the AAG is a body that was put in there by the New South Wales government, and in particular OEH and the Heritage Advisory Group, and it is non-representative of the native title holders of the areas. We had other plans for that, and the plans were for a future, for our future generations, storytelling and a continuation of contemporary storytelling for our people, education, scholarship, so on and so forth. All we got was a burial. Well, burial because also under this legislation, I believe it's number 7 in the legislation, that any stop orders shall be abided by. They were not abided by. The day before this action happened, we were told by New South Wales government and federal government that this was not going to go ahead, and yet it proceeded. So we feel that this legislation protects nothing. It is only for the lobby groups, and we feel left out again. And in actual fact, we feel it is backwards. And yeah, we cannot support it under its present circumstances.
Thank you. Mr. Siren, can we hear you now? Do you want to have a go and see if we can... Okay. All right, we'll wait for you to dial in. I understand you're dialing in. So sorry about this. Yeah. By phone, that's great. Yeah. Okay. Just while Mr. Siren is doing that, Mr. Young, do you...
access code. Have no access
have no
code.
access code. Yeah. While the committee staff are trying to sort that out with Mr. Siren, Mr. Young, do you think, and thank you for sharing the story about what has happened recently. I know how much pain that's caused for you and the elders and the people on the land there. Do you think that, so the bill at its very heart has the intention to introduce standalone cultural heritage laws in New South Wales, and it does seek to empower an Aboriginal controlled authority to administer the laws, and it seeks to provide a way of determining who the local land cultural heritage services are and who speaks for country. So if that is the native title holders or, you know, who that may be. The laws fundamentally are seeking to provide a way to protect cultural heritage, including giving those, assuming it gets it right, who have cultural authority to be able to have a right of veto in relation to developments or harm over cultural heritage, which of course is in the bill, described as both tangible and intangible heritage. So do you think if the bill gets right the cultural authority, do you think the bill itself is worthy of support?
I think the bill should be, if there was more negotiations, if there was more consultation. We haven't had that out here. A lot of people don't even know that this bill is even proposed. I've been asking in community, and a lot of people are unaware of it. So consultation really needs to be stepped up. And I do believe that native title should be the principal body. They should be looking after that. I don't think the Aboriginal Land Council, in its present structure, can represent native title holders in any way, shape or form. As I said in my submission, I've been a member of a land council in Sydney for over 30 years, and I have not seen a whole lot of benefits coming back to the members. There's been a lot of secret meetings, there's been a lot of takeovers, if you like, within some of those meetings. And the structure and historically, I don't think Land Council has the integrity and the proven, yes, I just don't think the Land Council is representative. I think it's very pro-development with all the land that it has got. So naturally they will veer towards that. What happens on the northern beaches cannot happen out the back of Bourke. That's just sheer arrogance to think that. Majority of people out this way, along the Darling River, the Barker River, are native title holders, not Land Council people. And that's where the conflict's going to come in. And if they find out that this has been passed without them even knowing about it, which has been the case out here, I think that is a precursor to lateral violence. And we have seen lateral violence come up in the community through decisions like this before. And I don't see that stopping.
Thank you. Have we got you now, Mr. Siren? Still trying to call in. Okay.
That's what we've done before. We just open a phone. Dial this one. They still can see the image, we just haven't talked into the phone. Yeah, that's what we've done that once before. So just ring. I have his voice on the phone and his image there.
Yep.
He goes on mute.
We can use my phone if you like. Okay. Yes, please
Mr.
do.
Young,
Mr.
sorry,
Barrett.
can I just touch, when you were talking earlier, you were saying we. So I don't have, who's we in that structure?
The we in that structure are the native title holders.
Okay, thank you.
My family group, who in 2015 were present when the determination happened. And also the year after that, in 2016, we put an application in, 30 people, representatives of Nellie, for the Part 4A full handback under the Aboriginal Land Rights Act 1983. And we've been promised for 6 years that this was going to progress. And while I was on the AAG, I've had other people come down, department heads, etc., telling us that it is progressing. We are still waiting 6 years down the track. The only empowerment that has happened is for the AAG to take control of the heritage and culture out there. And this in itself has been very upsetting because we've been promised for 6 years that the full handback would happen, and it has not happened. We feel that we've been again lied to. That's just being an Aboriginal person in Australia. So we understand that this is obviously now going to be part of what the future structure is going to look like, this new legislation. But it doesn't entail native title holders, and it doesn't even include the existing legislation under the Native Land Rights Act. That hasn't progressed. So if the existing legislature cannot even hold up to its own promise, then I don't see how the new one can.
Can I ask another question based on something you said before? The difference between how this act or a similar act, this bill or a similar bill would have an impact on the Northern Beaches versus back of Burke. You touched on that before. Why would it be different, and how would it be different?
There's a couple of things. Land title is Western land leases, which is a whole new set of regulations. The other thing is that we have native title over the area. So a lot of those will have to go through ILWAs, through the native title body. We've seen the Land Council selling off lots of land that have been given to them. That was part of the land trusts and Crown land. And yet we still have no say in that. So it's an affront to us to see that happen after all the time that was spent on native title. And like I said, it's taken us 18 years to get there. In 2015 was the determination. And yet now we see this coming in. It's just another stop-go situation. We don't know where we stand fully.
Thank you, Mr. Young. And we've heard a lot of evidence that, native title holders and registered parties are, recognised quite deeply as the sort of holders of cultural authority. Now, I understand we have got Mr. Siren, who is participating by phone only. So, Mr. Siren, are you there?
Yes, I'm here.
Oh, thank you so much. Thank you for persisting. It's very good of you. So could you please...
I'm sorry,
I'm
sorry, I did go through this yesterday.
Yeah, we apologise. On behalf of the committee, we apologise. Technology sometimes is great and sometimes it's a bit random. So would you mind, can we just commence by getting you to state your name, position, title, and either swearing the oath or an affirmation?
My name is Robert Siren. I'm a registered Aboriginal owner through the Office of the Register Aboriginal Land Rights Act 1986, native title holder, and an Australian Army Rwandan war veteran from the Katang language group, the language of the Worimi, Biripi and Guringai people north of the Hunter River, New South Wales. And I'd like to state the oath of the nation, please. If you could just read that for me, because I can't see it.
The affirmation, did you say?
The affirmation, sorry.
Yep. Okay, so that reads, I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Yes, ma'am.
Thank you. Now, Mr. Siren, would you like to start with an opening statement?
Yes. As I said, I'm a registered Aboriginal owner through the Office of the Register. I've gone through all the processes above and beyond proving my connection to country and my Aboriginal heritage. Sadly, I've also experienced a similar situation where I've had to battle with my own local Aboriginal Lands Council as a registered Aboriginal owner to simply hunt and gather on my own country, which I was completely denied as per my submission statement number 1. I understand that some people believe that land rights should supersede native title and registered owners. This creates division in our communities and undermines our cultural law, LORE. Native title recognises in common law First Nations peoples' rights and interests to the land and the water according to their traditional laws and customs. And I believe that land rights should never supersede native title, and those people who have legally gone through the processes of registering as an Aboriginal owner through the Office of the Register Aboriginal Land Rights Act 1986. I know from my past relations with local Aboriginal lands councils that other registered Aboriginals also support this approach under cultural law, spelled L-O-R-E again. There's been no community consultation or public notices have taken place with native title holders, registered Aboriginal owners, and New South Wales local Aboriginal lands councils from NTS Corp or New South Wales Aboriginal lands councils in regards to land rights superseding native title and registered owners over New South Wales. Am I okay to keep talking?
Yes, yes.
As an Australian war veteran descending from an Aboriginal family who has the highest number of family since World War I who served in the Australian Defence Forces, I continue to fight these cultural battles. Our mob, Baringai, have had to fight against the destruction of cultural heritage, setting a landmark ruling first in Australia to stop a coal mine at Gloucester. I've seen the destruction of our sites and have been at the forefront line of protecting our heritage. I've also seen people claiming cultural authority with no proof that they are entitled to it through law, L-O-R-E, or law, L-A-W, and at times not even providing that they are Aboriginal people. Only not so long ago, to my disbelief, I discovered you don't even have to provide proof of Aboriginality or even be an Aboriginal to register an Aboriginal corporation. You just tick the box. Current legislation and government don't protect our ancient cultural heritage. The authority ultimately sits with non-Indigenous people. And this needs to change so we don't have to fight and too often lose to protect Aboriginal cultural heritage. Aboriginal lands councils are not perfect, but in the absence of native title and registered Aboriginal owners, through the Office of the Register, Aboriginal Land Rights Act 1986, they're the next best thing as custodians of this country as legislated community-controlled entities. Aboriginal people for thousands of years have always only spoken on behalf of the country they are from, never to disrespect the land or language or laws of neighbours' country. It was never done. Only just recently, well, not just recently, we're dealing with a situation at the moment, 2015, a taxpayer-funded report called Filling a Void was published in the papers, and the heading was The Historical Fiction of the Word Guringai that has filled a void in our knowledge of the original inhabitants, and also published on the Aboriginal Heritage Office website as per table documents. Regardless of who the true Guringai are and being recorded in the 1820s north of the Hunter River, New South Wales, in the funded report, Filling the Void, to top it off, we have a group of people using and claiming a tribal name, the Guringai, on the Central Coast. Not one person from this group has applied or is legally registered as Aboriginal owners through the Office of the Register Aboriginal Land Rights Act 1986, as per table documents. And at the end of the day, when I have complained to many Aboriginal departments, including New South Wales Aboriginal Lands Council and the NTS Corp, in regards to these issues, only one has made any effort beyond a meeting or an email to correct these issues, and that was the Office of the Register. It's terrible.
Thank you.
That's all I have to say for now.
Thank you. Does anybody else have questions you'd like to ask? Reverend, do you have any questions for Mr. Young and Mr. Siren?
Yes. What will be the key to getting other native landholders and Aboriginal owners to see the merits of the Culture is Identity 2022 bill. That's the bill we're discussing now.
Do you have any views on that? So what do you think could be done to get more people on board?
Well, I think the consultation process is faulty. We could start there. As far as the view down here is from a number of the elders is that the native title holders should be the first in that process. Replacing us with Aboriginal Land Council and placing our heritage and culture. As you may note, Nellie Johnson's canoe is in the South Australian Museum. And I do feel a lot better that it is down in South Australian Museum and not in New South Wales. So we can continue to pass on our stories to our children and grandchildren. The stories that is embedded in our family is not your license to give away. That is our heritage, that is our culture, that is our stories, that is our history. It is not to be bartered off to the highest bidder. So you really need to come in with a reworked model that's going to give us real leadership and also incorporate that with the federal government's view of what may or may not happen with the voice to Parliament and the reform of the cultural heritage bills within the federal government as well. Really needs to be explored before it's even going to be acceptable in any way, shape or form by the native title holders of this area.
Thank you. Does anyone have any other questions for Ms. Sharp?
Thank you. Thank you for coming to talk to us this afternoon, and thank you for putting up with dodgy technology. It's quite frustrating. Look, I'm really, the committee is a group of non-Aboriginal people trying to wrestle with this. I think there's a great deal of agreement that we need standalone protection for Aboriginal cultural heritage, but as you have outlined, it's a complicated issue. I was very interested though, part of what this bill is trying to do is to put in place sort of a statewide council that then sort of would look at delegating to local levels, and where we seem to be coming, well, the greatest degree I think of disagreement is the hierarchy issues in terms of who's entitled to appoint. And native title holders such as yourselves have really made the point that you don't believe that really that's, native title is native title. You're recognised under law after a long and lengthy process to deal with that, and that should be the primary process. In terms of a statewide, that's a very long way of saying, in terms of a statewide Heritage Council, do you think it's possible to actually do that, given the number of native title holders versus Aboriginal land councils, or is there do we need to be more regional? Would a more regional approach operate better? I'm just trying to get some guidance about where you think we could. Is it fixable really?
I think it needs to be explored. We do need reforms. There's no doubt about that.
Yeah.
But as far as hierarchical goes, it seriously should be native title. They should be the forefront.
Absolutely, and I agree.
Areas have not got a native title or recognition by the registrar, which seems to be dysfunctional at this stage. I would like to then have the other local community groups included in that. I can understand that native title will not be happening in certain areas due to the historical events that have led up to 234 years of settler colonisation. that is impossible in some areas. But if there is native title, then that should be prioritised over and above. And that should be the primary representative body of that area.
And just to be clear within that, that would also, because obviously there's only a few, there's, you know, way too few areas that have actually had properly recognised native title, that where people are going through the process and are able to be registered, that claimants would also be incorporated somewhere into that system as well?
Yes, absolutely. Absolutely. If the process has already started and their application has been accepted, then we should be waiting for those outcomes and they should be given a seat at the table while that process is going forward.
Right. Thank you. Mr. Siren, did you want to add anything to that?
No, I agree 100%.
Can I just ask, Mr. Young, when you... sorry, Mr. Siren, carry on.
Yes. So not so long ago, we were in the process of trying to negotiate an ILUA with the Dungog Shire Council. And, you know, with all the evidence and history, they even recognise us on their own website, but they still won't acknowledge us as the traditional owners and simply have just gone and closed deals with the local Aboriginal Lands Council. And we were just completely excluded from that. But hopefully in the future we'll be pursuing our native title.
Thank you. Mr. Young, when you said, so in the absence of native title holders, so whether registered applicants or holders, you then said you would hope the local groups would be represented. What were you referring to in that sense?
Well, see, it's such a broad issue. A lot of the time, we go back to the basic law, which is you don't speak on other people's countries. That's a basic tenement within the Aboriginal laws. But they've been emboldened by legislation like this, not only to speak on other people's country, but to also take control of that. We have to be careful of the structure of the type of people that are going to be admitted onto these committees. I think that good people are hard to find, and we need to focus on those people that are going to deliver the best outcomes for us. And listening is one of those key principles. Negotiation, we really need to talk about that. Historicals, we have to look at the historicals as well. Settler colonisation is still happening today, whether you believe it or not. We still see the effects of that and the continuing battles that we have to come up to try and represent ourselves again and again and again. Yet we are still waiting for that is going to deliver. We just feel that this one is just, this legislation tends to favour developers as opposed to native title holders or Aboriginal people. And that's just being blunt. The reform needs to happen. We do agree with that. But this is not the right way to do it.
Thank you.
Can I just add something to that too, please?
Yes, please.
Yeah, so my family members, the elders in our group, 6-7 years ago, maybe longer, they had spent 7 years writing to the local council and requesting some sort of monument for the contribution that my great-great-grandfather, Malakat Lightning, contributed to the community. Not only as an Aboriginal man, an initiated Aboriginal man, but also to the local farmers. And eventually, we ended up getting a brass plaque in recognition of the Cook family from the Barrington. And I think it costs $1,200. And that took 10 years to get that. 10 years.
Yeah.
I might ask a question, Chair.
thanks, Mr.
It's Rose Jackson here. Thank you to both of you for coming along. Look, certainly, you know, the concerns that you have raised have been raised by others. We're definitely aware from all of the evidence that we've received that there are genuine concerns with the legislation as it's proposed now. It's been suggested that, you know, because this process has been taking a long time, there's been, you know, a lot of different sort of attempts at this over the years, that a better way to proceed might be to accept, yep, this is problematic, there are faults in it, there are things that will need to be addressed, but that can be done later through amendments or review of the legislation once it's in place. I wondered if you just sort of be willing to respond to that and perhaps, you know, outline some of the risks that you see with just proceeding with this legislation, going, yeah, we know that there are problems with it, but let's just kind of give it a go and we'll try and fix that up later, which is perhaps some of the tenor of some of the other evidence that we've received.
I think I outlined earlier that one of the negative responses for this legislation would be a lateral violence rise within the communities. And out here, I can understand that native title holders, if they do find out about this and the Land Council has suddenly gotten the authority over their culture, their heritage, their stories, there will be violence out there. I've personally been involved in some violence with Land Council members. I won't list them at the moment, obviously. But that is one of the things that is not a consideration within this legislation, because she's pitting two people against one another within the same community. The native title holders also, it took 18 years for us to get our determination in 2015. That should be upheld, state and federally. The other one is the Part 4A handback of Mungo. Murruwinji has gone through that process. Mungo is next. Should proceed. Why hasn't it proceeded? These are the questions. To progress this legislation and then say we'll fix it up as we go along, we have seen that before. And to tell you the truth, we don't trust that type of logic. So present it, tell it as it is. Come and see us, talk to us, and tell us straight exactly what is the reason behind, the mechanism behind this legislation. Then we may have a conversation. Thank you.
Thank you.
So do you think if the bill was amended to reflect the constitution of the state body, to make it better reflect a body that is closer to the voices of cultural authority, do you think that that would mean that this bill could be supported?
I think it could be modelled on a far better ideology. And like I said, I do believe that after 18 years of research, science, anthropology, all of that, to put together a determination after 18 years, the research has already been done in the area. Why reinvent it? So why not incorporate all of that work that has been done by the federal court into your own legislation, into your own state legislation? I still don't understand why this one needs to replace the other and replace others. There seems to be a drive for this, a determination for this, for other reasons other than. And believe me, we've been there before. We've seen it all before. So it's nothing new for us.
Thank you. I think that concludes this part. Do either of you have any final comments you would like to make?
Yeah, it's Robert.
Thank you.
Yes, I I strongly believe that native title should be number one, and then registered Aboriginal owners who have gone through the legal process of establishing their connection to the country that they claim they're from. That's pretty much it.
Thank you. We hear that loud and clear.
I concur, and I would like to also say that I would like to see the Part 4A full handback of Mungo progress and stop this meddling in our heritage culture that's been happening out here, which has adversely affected native title holders. And that really needs to progress. The existing structure needs to be progressed. We have not been given a reason why it hasn't progressed. And yet we see the destruction of our culture and for whatever means. The AAG was never a body that had the authority to go out and make these decisions. And yet we're still finding here we are sitting here waiting for someone to knock on the door to inform us, to let us know, to include us in the meetings, have a seat at the table. So it's been a mess. And the stop orders in the legislation, they had a stop order on that. It didn't stop them from doing what they wanted to. And that's abundantly plain to see that they don't respect native title holders. So if that's to be reflected in this new legislation, then I don't think there's going to be much progress under this present model. Thank you.
Thank you. Thank you both of you so much for your time and appearing at the hearing today. We really appreciate your time and thank you for your evidence and knowledge. Thank you.
Thank you. Thank you, Chair. Thank you, everyone.
Thank you, Chair.
Thank you.
Thank you.
Okay, I now welcome our next witnesses. Hello there to Ms. Robinson and Ms. Spencer from the Darawar Elders Group. Thank you so much.
Hello.
Hello there. Could I please get you, for the purposes of the hearing, could I please get you both to state your name, position, title, and then swear either the oath or affirmation?
Virginia Robinson, Secretary of the Darawar Elders Group. Affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
My name is Wendy Spencer. I'm the project manager of Darawar Elders Group. I'm a non-Aboriginal person working for a group of local Aboriginal elders. My affirmation is that I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Thank you both. And it's lovely to see you both virtually, if not in person. Would either of you or both of you like to start with an opening statement?
Virginia Robinson, opening statement for the inquiry into the Aboriginal Cultural Heritage Bill. Culture is identity. And I'm going to be using the DEG, which is the Dariwa Elders Group. DEG's inquiry submission mistakenly assumed the bill was prepared by the New South Wales government. We were surprised that it suddenly appeared and thought that the reason we hadn't heard anything about its development was an indication of the lack of respect by the New South Wales government for Aboriginal cultural heritage. A new system for managing and protecting Aboriginal cultural heritage must be designed by Aboriginal cultural heritage custodians and improved by reviews. There has been no contact between the Dariwa Elders Group with Fred Niles' office, the New South Wales Aboriginal Land Council, nor Heritage New South Wales regarding a standing-alone Aboriginal Cultural Heritage Bill. So no one has yet done the work to develop a system that would work in DEG's view. This bill makes a good start, but needs more work. Necessary changes couldn't be achieved by amendment now because Aboriginal cultural heritage custodians are not yet fully engaged. It won't be cheap, but a proper ACH system is required to support New South Wales Aboriginal families so their ACH and values flourish, and for the implementation of Australia's obligations under the United Nations Declaration on the Rights of Indigenous Peoples. DEG doesn't seek to represent anyone except its Walgett members and the views and values of founding members who were Gamilaroi, Uluru, Nimba, Walwyn and Ewan. And all these people came together to support those in the group they recognised could speak for places in country. The founding members named their group after Dariwa, a common meeting place, which is Narran Lakes, meaning it is not owned by any one species or tribe, but a place where all can meet together. No native title has been determined yet for DEG's area of interest, which covers portions of Uluru, Gamilaroi, Walwyn and Nimba countries. In fact, NTS Corp anthropologists are working today to consider boundaries, and we know Walgett is a border town. Many in Walgett have not yet traced their native title. There are constant threats to ACH from knowledge holder death and development. DEG is what you have when no support for living ACH in local communities like Walgett is funded. Maybe this support will come in future from native title body corporates. DEG will find out. First heading, decision making and primary work of the new ACH system at the local level. DEG's core offering to this inquiry is the conviction that ACH custodianship and management must be held at the local level by properly resourced, non-profit Aboriginal cultural companies that support cultural knowledge holders, usually elders for that area, including knowledgeable elders who have bloodline connections to this country but may live elsewhere. These local companies must be supported to manage and transmit their knowledge and control their own IP and information databases. It is ridiculous to locate knowledge in one state-held repository. DEG proposes that the ACH services described in the bill would be delivered by these local Aboriginal companies, supported by contractor or staff professionals and registered training organisations. These local services would hold the local knowledge and protect and promote living ACH. Each community is unique, and the knowledge holders for each local place would ideally be supported to control an independent ACCO, because ACH maintenance is a daily and constant activity. The activity of these local companies cannot be undertaken by regional or nationwide companies with branch offices, because the knowledge resides locally and with a diaspora that would need to return to country to manage these matters, not a local Aboriginal land council or a native title body corporate, where they could be outnumbered by others not prioritising ACH. Prioritising ACH, sorry. Next heading, the New South Wales ACH Council would support, resource and enforce local decisions. DEG proposes that the state bodies supporting these local companies must be representatives elected by the local companies. They could meet in native title nationally, regionally and state groupings and work in a distributed network from their home communities. This would ensure the cultural authority of the New South Wales body, and that the New South Wales body, if called the ACH Council, would be acting according to local ACH custodians' instructions. There are many useful functions and roles for a New South Wales ACH state representative body or council. Next heading, the right of veto is essential. Singular and cumulative ACH destruction is not accepted by DEG. What is the point of legislation to protect ACH when theoretically protection determinations of each ACH custodian can be overruled? Should there be appeal rights for developers against local ACH decisions? We need legal advice. Aboriginal groups and individuals currently don't even have standing in matters relating to ancestral remains. DEG requires that Aboriginal representatives have standing in any court proceedings regarding ACH protections, including any appeals against protections. Next heading, State Significant Development, or SSD. Proposals must provide the same ACH protections as non-state significant developments. We would like time to discuss the implications and different scenarios of SSD with legal advisors. Aboriginal custodians of country should have standing in the decision to categorise a proposal as an SSD. For example, DEG believes that SSD status given to Santos CSG operations in the Pilliga Forest is wrong for many reasons and unlawful in a climate emergency. SSD projects are typically referred to IPC. The IPC didn't listen to us, Santoses in the Pilliga. DEG was completely ignored by the IPC, so that process will not protect ACH. All development would need to be negotiated and processes we could respect undertaken. That is not the world we are currently in. Living heritage, there won't be any ACH in a few generations if you don't actively support knowledge transmission and access to places on country for Aboriginal people now. The biggest outrage for the Walgett Aboriginal community is not being able to walk country and access waterways wherever and whenever we want to. Intellectual property protections and data management are important, but importantly, knowledge must be directly connected and used by knowledge holders for knowledge transmission activities so it is kept alive. What is intangible heritage? what we do, family ties, memories, storage, language, ways of thinking, values, also the knowledge that makes places and things significant. It will be a big task to support living Aboriginal cultural heritage. It is possible and a process to draft a new ACH management system in a respectful, thorough way with all the New South Wales Aboriginal voices that could be heard in this process is the opportunity. Thank you.
Thank you.
That statement was emailed to the one of your committee workers.
Thank you. And can I just start by saying at the outset that your submission is really, really appreciated. It was such a incredibly well written submission, and just the sharing of your perspective and how your approach to the matters of cultural heritage and helping the committee understand the definitions behind things has just been so valuable, and I just thank you greatly from the outset. Because we know that the timing has not been generous, it's actually been harsh and undesirable, and we've made that point. It's been a little bit out of our hands in that sense, so we just recognise, and as I say, thank you so much for the effort given such short timing. Can I just start by asking one part, and then we'll hand over, there's other members of the committee that will have questions. One of the things that you have put forward, which has been put forward in a novel way, is this idea that the Cultural Heritage Council actually gets constituted the other way round. So from local groups and the local cultural authority holders suggesting who should be on that state body, that council. Is that something you can just elaborate on a little bit?
I'm deferring to Virginia to answer that question.
Well, I just think it makes sense, at the local level, rather than someone that doesn't know us and we don't know them. And they don't know how our cultural heritage.
Yeah, thank you. It was just, it was something that was quite unique in terms of the submissions that had been written, and it was, really valuable input. Thank you. Reverend Nile, did you?
Makes sense, I think.
Yes.
I think it makes a lot of sense, don't you?
Yes, absolutely. Reverend Nile, did you have some questions?
Yes.
Yes.
Dealing with the submission by Virginia Hanson and Wendy Spencer. In your submission, you mention Aboriginal cultural heritage, at best, of the area is stated to be valued by the New South Wales government for its cultural potential. Division 5, Section 50 of the Bill recognises the rights of Aboriginal persons to use Aboriginal cultural heritage for commercial benefit. This section of the bill is something your community would support or not support?
So we had a response to that in our submission. I'm just trying to find it now. Were you reading from a particular page in our submission, Mr. Nile, that we could just go to now? I think we said that, didn't the group say, Virginia, that they didn't think that non-Aboriginal people should be making commercial benefit from Aboriginal cultural heritage.
Well, yeah, that's right. That's what we decided as a group.
But I'm just trying to find the statement in the submission now.
Yeah, from memory, I think it was the discussion about it seems to be a new opportunity that people are potentially capitalising on. Was it the sort of cultural heritage tourism and I think?
Oh, yes. We talked a bit about that in the beginning bit, I think. But are you asking us whether we think it's all good and fine for anyone to be exploiting Aboriginal cultural heritage, or specifically Aboriginal people, and which Aboriginal people? Sorry, just not quite sure what we're being asked. I'll look for the spot where we've mentioned.
That's all right.
that in
Reverend, perhaps you
well.
could elaborate a bit more on what you're actually asking of the witnesses there. What they're asking is, are you asking if the prospect of non-Aboriginal people capitalising on cultural heritage, whether that's appropriate or not? Is that what you're asking?
I was referring to your submission.
Yeah,
The submission
which page,
from these
please? Which page?
members. They made that point.
Yes,
I was commenting on it.
somewhere.
And what were you asking about that? They've made it fairly clear that it's the view of the Dharawal Elders Group is that that's not appropriate.
I think he was
Yes,
just
but
asking
that's
for an
not
elaboration.
what's in their submission.
Yes, yes.
Their submission says it is.
Right.
Have you got a page that you're reading that from?
Is there a reference there, Reverend?
Yes, on page 2, if I could just...
Division 5, Section 50 of the bill recognises the rights of all Aboriginal persons to use Aboriginal cultural heritage for commercial benefit.
Yeah, so we commented on that in page 8. Just want to have a look on page 8. Down here, we said it needs to be Part 5, Division 373, must be altered to create an offence for any person recklessly using and or commercially benefiting from tangible or intangible Aboriginal cultural heritage if they have not been authorised by the Council, which has commissioned advice from the relevant local Aboriginal cultural heritage ACCHO supported by the local Aboriginal Cultural Heritage Service. So that's what we said there, I think. And there were some quotes from our workshop that we did, Virginia, in fact. You said that. Destroying every one bit of ACH is not okay. Even one bit of ACH is not okay. And they also said that Aboriginal people are experts in their own cultural knowledge and should be supported to appear in court if necessary to defend protected areas and Aboriginal cultural heritage from harm. The DG is unsure that individuals or local ACH ACCHOs would delegate that right to others. For example, the ACH Council delegates for this role. The local voice must be preferenced and heard when ACH is being defended. That's a quote from our workshop as well.
Thank you. That makes it very clear. Thank you. Is that clear to you, Reverend Nile?
Yes.
Yeah.
And the other point of confusion is that in this submission, you state that the members of the board can be sacked by the minister. The board is independent and cannot be sacked by the minister in the bill we're debating, Culturist Identity 2022 bill. Cannot be sacked by the minister.
What are you asking?
I think Reverend Nile is clearing up that point and trying to assure you that the way the bill is drafted, the minister doesn't have control to sack the council members. So perhaps that's...
Yep, that's correct.
Thank you. Ms. Jackson, did you have a question? I saw you jumping there.
Yes. Just wanted to, one of the points that I thought that you made in your opening statement, in your submission, that was really important is just the resource intensity, in a way, of the sort of the cultural, the protection of cultural heritage, both in terms of the time. I think you described it as a daily occurrence. So that was the first time, in a way, I've heard that articulation of just the amount of time that, you know, you as elders have to put into playing that role as holders of cultural knowledge, and also presumably in terms of the support that's needed in resource terms to ensure that that's done properly. So I just wanted you to elaborate a little bit on that, because I thought it was a really important point that you made, both in terms of time and in terms of resources, that this isn't something that we can just legislate and then just kind of leave, that actually there needs to be an understanding of the time and the resources that are required to get this right.
Sorry, what was that last?
I just wanted you to elaborate on the time and the resources that you thought were required to get this right.
I'll just take an example that we're currently involved with. It's a place called Dungalia, a station, a property. Back in the days of a protection area, that property was chosen by the Aboriginal Protection Board. So they put the Aboriginal people there, they lived there, they worked there for years and years and years. So naturally there was going to be, you know, remnants left of their culture where they lived on this station. We've spent weeks going through trying to find out who destroyed the remnants of those camps where Aboriginal people camped and lived on this property. There's nothing to be seen now. It's all been destroyed. It's all been cleared. So we are spending a lot of time, especially with the EDO, the Environmental Defenders Office, to get our legal issues correct as to what we want to do about the destruction of what took place on Dungalia Station. It's time consuming. There's not a lot of staff. There's not a lot of days where elders one day might be sick and one day they aren't. We can get together as a group always. We do things by consensus. So it all takes time. It all takes money. It all takes, you know, people power to get these things going.
Thank you.
Thank you.
If you don't mind, I just wouldn't mind, it was something that came up a bit earlier. I wonder what the different approaches to Aboriginal cultural heritage might be in regional to metro areas. So how might this bill sort of have impacts on you at Walgett that might be different to people in Wallara?
Well, it's a bit different, very different. You've got concrete everywhere. God knows what's buried underneath whatever's in Sydney. Here, we can see, we know through our stories and knowledge that's been passed down, we know where our cultural sites are, we know our stories, we know the land. But in Sydney, that's a different matter. I don't know how people can say, well, yes, over there on that corner is, you know, a burial ground. It's all under concrete, roads. There must be millions and millions of cultural heritage aspects in Sydney, in a metropolitan area. So I don't know. I've no idea how you could compare both. Out here in the bush or out in the middle of the metropolitan area.
Can I also add that we don't know about what happens in the city? We're a little local group in Walgett, so that's our knowledge and expertise. So, yeah, we don't know how they do things there. We'd love to be able to network with the city groups and the groups all around New South Wales, and
We've started doing that in our peak body, the Aboriginal Cultural Heritage and Arts Association, and they get a few resources to bring us all together, usually once every 2 years. But apart from that, we don't really know.
Thank you.
We've had quite a lot of evidence presented to the inquiry so far that, native title holders and native title applicants, registered applicants, are very, very sort of high up, if there was such a term. I don't think there's a hierarchy here, but for the sake of convenience of terms, that they have been through a very long process of proving that their connection to country and their cultural authority. Would you agree with that? Is that something that you recognise as the Darawal Elders Group?
Yes, we do. We don't criticise national native title bodies or native title claimants. We're for native title.
And from where you are in the that Walgett area, do you see that? Where do you place the local Aboriginal Land Council's authority to speak for cultural heritage and country?
As a member of the Darawal Elders Group, personally, I don't find the Walgett Local Aboriginal Council to be a functional Aboriginal Land Council. So there's not a lot I can point to.
No, that's very helpful.
And could I just add another clarification?
Of course.
In the submission from this group, you state that members of the board can now be sacked by the minister. The board is independent and cannot be sacked by the minister. And the culture is identity bill, the one we're debating. They cannot be sacked.
Thank you, Reverend. That point's very clear. Thank you very much.
I think the Land Council, though, possibly can be.
Yeah,
as in the local services, the local land services?
No. I think the point that we made was that the Land Council network is governed by an act.
Yes, I see.
Well, going by this Land Council, they seem to prioritise housing and that's about it.
Yeah, and look, that's consistent with some of the evidence that we've heard that, there are possibly those conflicting objectives, that it's no particular fault of any organisation, but it's conflicting legislation and objectives, and that, we just heard some evidence that, there is an imperative on the local Aboriginal land councils to pursue the economic development of their organisation and members. And that often may well be in conflict with the protection of cultural heritage on site. So,
certainly.
Yeah. Is there any other questions that members may have? You made it very clear about there is the need to have what's been referred to as a right of veto. I prefer to sort of say it as a right to prioritise the protection of cultural heritage when it's faced with a prospect of destruction. Do you have anything, in particular around how you see that working? We've heard some evidence that the earlier that engagement happens, the better. Is that something that you can visualise about how that could be operationalised?
Did you want me?
Yeah. I'll get Wendy to speak to that point, please.
Thank you, Virginia.
I think the group said that they wanted more legal advice and discussion about that at first off. Also that there's no level playing field, and so you'd need to set up a layer of professionals between the knowledge holders and the developers. We do have direct experience of trying to work with opal miners and their representatives here, and also with landholders, and it's not a great experience. There are some that are friends, but it's very difficult, and particularly for elders, to be engaging with those people who have little education or understanding about the Aboriginal community that live in their place, or the other way around. They have little understanding of the Aboriginal community that's around them. And so there'd need to be a way for the knowledge custodians to be able to be in a level playing field when those negotiations are occurring, I guess, with their legal representatives.
Bit of education.
But do you think if the framework provided that that right, or that would level the playing field out a little bit?
Yeah, I think what I'm thinking is we need to stop landowners, miners, need to stop their thinking that Aboriginal culture is a joke. I've heard it many times. Oh, we've got some rocks on our property. Wonder if what they are, this kind of thing. So you often get some very negative comments about Aboriginal culture situated in sites on their land. And I think there needs to be a lot more education. I don't know, put a sign up at their front gate and saying, I have such and such on my property, and I'll never touch it. I don't know. It's a constant battle, as Wendy said. We do have good relations with some landowners, but most we don't.
And I'm certainly familiar with some of the work with the opal miners. I've certainly seen some of that firsthand.
Yes. Yeah. These landowners, people that own the properties around Walgett, they know what's on their country. They know. And those ones that we've developed good relationships with can take us straight to where they know that what's on their property. We already know some of them, some places, some sites, but landowners certainly know what's on their land.
And so just finally, do you think that, given the Darawah Elders Group, and I can tell from your submission, you're engaged in so many matters of the wellness of your community and your group, do you think that if cultural heritage laws were centralised and focused more so on the mechanisms that seek to proactively protect, rather than the mechanisms at the back where we're trying to protect once they're threatened by harm?
Absolutely, absolutely.
And do you think that would be something good for the community broadly and widely?
Yes. Yes, absolutely. You're quite correct.
It's an opportunity, as we said in the last paragraph there of our statement, but it's going to be hard.
Yeah.
Yes.
I know we've said that it won't be easy, but at least that opportunity is there.
And doesn't the group think, Virginia, that the Elders Group wants a system where, that's different to the one that's currently in place, which is just about providing permits for destruction and very rarely about any prosecution?
Oh, yeah. Oh, yes.
Or protection.
Yeah.
There's not enough staff on the ground to protect, or
Yeah.
there's not enough resourcing for enforcing the current act.
That's correct, yeah.
Thank you. I think we've got one last question from Ms. Jackson.
I just wanted to, I mean, it was...
Just one other thing,
yes,
Madam. Because the bill deals with archaeology only and the intangible knowledge that gives it cultural significance, the reference to culture is identity must be taken from the title. It is blackwashing. Culture is more than identity. Culture is about more than archaeology and history. It's living memories and practices, the wellspring of Aboriginal people, and it makes us feel good. Culture is much bigger than this bill and much bigger than identity. Thank you.
Thank you.
I mean, that was essentially similar to what I was going to ask about. I'm just, noting the reference in the submission to the sort of current way that the New South Wales government deals with Aboriginal cultural heritage, which you describe as sort of, cultural tourism at best. This sense that it is just these dead and historic physical things. And the importance that you mentioned in your submission, and actually in that comment just then about the idea that it's also living, it's intangible. It's not just sort of dead sites that people can go and have a look at. So actually that's what I was going to ask you about. Perhaps you felt as though, Ms. Robinson, as though you addressed that in that comment, but if there was anything else you wanted to add, I think that would be great.
No, I just would like that culture is identity taken out of the title of that bill. I mean, really, the Dariwa Elders Group, we have a separate system for identifying and approving, confirming identity. And we don't use culture or cultural sites to determine people's identities. Aboriginal kinship system is a very complicated, very important system, and it has nothing to do with culture, scarred trees or artefacts or whatever. It's a very complicated system, and only Aboriginal people can defer to who are Aboriginal and where they come from and who they are. So I find that a bit insulting.
Yeah, thank you. And you made that point really well in your submission, and you've made it well again. Thank you so much. Are there any further questions from anyone on the committee? Is there anything finally you would like to say? Please feel free.
I'd like to invite the committee to Walgett.
Wonderful. Well, I would certainly like to come. So look, just in terms of that, this committee is, as I said at the outset, we're very, very constrained. We literally have to report to Parliament in the second week of November, and Parliament, this term of Parliament will sit for the final time before the end of this year, and then there is a state election in March next year. So what your evidence now will form part of this inquiry. It will be on the public record forever, and whatever happens with this bill, as we walk towards the development of standalone cultural heritage laws, this will feed into that process. And we thank you very much for your invitation. And as I said at the outset, we thank you so much for the time and effort and knowledge that you have put into your submission. It's incredibly valuable to the committee. We have had a very short time, so your engagement assists us greatly. So thank you very much and thank you for appearing today as well, and your time and your effort. We're very, very grateful. Thank you.
Thank you.
Thank you. And the elders who take part in all these conversations and groups and subgroups when we get together will be pleased to know that you've heard our submission and seen us and heard us. Thank you.
Thank you both. Thank you both so much. And please thank all the elders on behalf of the committee.
Will do.
Thank you.
Thank you.
Yeah.
Thank you. So I now welcome to the public forum. I welcome everybody to the public forum for the inquiry into the Aboriginal Cultural Heritage Culture is Identity Bill 2022. Before I commence, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we're meeting today. I pay my respects to elders, past, present and emerging, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the land and waters of New South Wales. I also acknowledge and pay my respects to Aboriginal and Torres Strait Islander people joining us today. The Parliament has asked this committee to do an inquiry into a private member's bill called the Aboriginal Cultural Heritage Culture is Identity Bill 2022. This bill is separate from the cultural heritage reforms that the government has been working on over a period of time. I acknowledge the short amount of time the committee has to examine the bill and get the community's views on it. I acknowledge that this is not desirable. The Parliament has told the committee it must publish its report by the 8th of November 2022, and the reason for this deadline is the New South Wales Parliament will meet for the last time in mid-November before the state election in early 2023. Before we commence, I would make some brief comments about the procedures for today's forum. The speakers were asked to register in advance for the forum. Those of you who have registered to speak will be speaking. What you say today is being transcribed and streamed live to the Parliament's website and will be included as evidence to the inquiry. It's also important that I note that while all participants are covered by parliamentary privilege, committee hearings and public forums are not intended to provide a forum for people to make adverse reflections about others under the protection of privilege. In that regard, it is important that participants focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. Finally, can I sincerely thank those of you who have come along today to share your views. I now welcome the forum participants, and if we could start by just taking your name, if you could state your name and the either oath or affirmation. Thank you. Yes, thank you very much.
Gregory Bondar, and I'll take the oath, Madam Chair. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Bondar. And we'll just swear in now, if that's okay, and then we'll head back to you. Mr. Duncan.
Yes, Kevin Duncan. I swear that the evidence now about to be given by me shall be the truth, the whole truth, nothing but the truth. So help me God, my army.
Thank you. Mr. Owen.
Tim Owen. Happy to take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. So, Mr. Bondar, would you like to make your openings? Would you like to make a statement and a presentation? Thank you.
Thank you, Madam Chair. If I may, and for the record, I'd like to declare that I do have possibly a past conflict of interest, having known the Reverend Honourable Fred Nile for quite some time. I was the State and Federal Director for the Christian Democratic Party at one time, so I've worked closely with the proposer of the bill, but I come here not as a proponent of Reverend Nile, but as a proponent of the bill, Madam Chair. So if I could just have that recorded, please. Thank you.
Thank you.
Madam Chair, Committee, thank you very much for the opportunity. I represent an organisation called Christian Voice Australia. We're a national non-denominational organisation, and we actually advocate on issues of cultural, social, economic and religious issues of concern. I think it's important, Madam Chair, that I outline my particular background for both the relevancy of this particular bill and for my own credibility. I was Chief Executive of the Tharawal Local Aboriginal Land Council, the Dharawal people, who are actually the peaceful sector of the land councils. And so I come here in a way in peace, because having been Chief Executive of this particular land council, I can tell you that I got involved, very much involved in all sorts of areas of Aboriginal management, including the Aboriginal Land Rights Act. I was a member of the Sydney-Newcastle Alliance for Cultural and Rights and Economic Development. I was on the committee of the Wollondilly Aboriginal Advisory Committee, and the list goes on, Madam Chair. So I just want to make sure that I have a very close connection with the people of Tharawal Aboriginal Local Land Council. Whilst at the Land Council, Madam Chair, I was very much responsible for the protection and conservation of Aboriginal cultural and heritage environment within the boundaries. And if you look at a map, and if you haven't already done so, may I urge you to look at the extent of the Tharawal Land Council region, because it's quite extensive, down to Nowra, right up to Sutherland area. So it's quite extensive. And it gave me the opportunity to work closely with National Parks, the Minister for Aboriginal Affairs, and of course the Minister for Environment at the time. But more importantly, I guess, and for the committee's benefit, I actually undertook a week course called Certificate in Aboriginal Site Awareness, held by the New South Wales Office of Environment and Heritage. Now that was fascinating because I actually got the opportunity to be taken out and right under your noses, really, within a few kilometres of various built-up areas, places of concern to those elders that lived within this area. So I managed to look at rock carvings, areas of sacred sites, and these areas, of course, are not for mentioning, but they are there. And it gave me a really good insight into the management of cultural and heritage aspects of the Indigenous population. Madam Chair, if the object of the bill is to provide a modern framework for the recognition, protection, conservation and preservation of Aboriginal cultural heritage and recognise the fundamental importance of Aboriginal cultural heritage to Aboriginal people, then this bill is a must. It's a must, if that's the intention of the bill, and I suspect it is. Madam Chair, without holding up too much of your valuable time in the committees, let me make three key points, if I may. My own experience as the Chief Executive of the Aboriginal Land Council, where I had 17 Indigenous staff report to me, and I got involved in all sorts of cultural, artistic, and in particular, we went out and we developed our own economic sort of enterprises, including market gardening and what have you. It really gave me, as a CEO, the opportunity to work with these people and to value their cultural heritage from a different perspective. Now, I know there are land councils, and I worked with them. When I arrived at the Land Council, we had a rating out of 100 at that time of around about 52. When I left, we were 98. That's how much we improved that Land Council through working with the local community, through enterprises, through governments and what have you. Now, not all land councils are going to agree, but cultural heritage is critical to the people, to the Indigenous people of Australia. I had on-site meetings with major developers, and I know I can't mention particular names, but let me tell you, a very large Sydney property developer, where they wanted to build a block of estate, of units. We went out there with some elders. And for the life of me, I didn't realise how much heritage there actually was to be observed if one opened one's eyes. And they were told, the developer was told, you are not to build here. There's no way you can build here without upsetting the cultural heritage of this place. And I was blind to that before. So one of the key points is that through my experience, and I'm talking retrospectively, Madam Chair, this has opened up my eyes to the need for such a bill. Secondly, I think the bill also awards custodianship of Aboriginal cultural heritage to the Aboriginal community rather than the minister. Now look, dare I say, you'll look at my background, I've worked for a minister. Ministers are not perfect. And in point of fact, governments inherently are bad managers of cultural and heritage aspects. That's why you have outside organisations and you should be divesting yourselves from trying to manage cultural heritage aspects. So while I agree that there is a role for government, I think we have to appreciate that there are opportunities for partnerships as well. But I caution the committee, if government wants to form partnership with Aboriginal communities, then it is done with a lot of caution. The third point I want to make, Madam Chair, is that we totally support the idea of the state significant development and state significant infrastructure veto powers in the bill, but it protects the Aboriginal cultural heritage from being continually, and I pardon the pun, bulldozed. And that's critical. The beauty of Reverend Fred Nile, and Reverend, I know we're old colleagues, but the beauty of this particular bill is that it is aimed at preventing the destruction of Aboriginal heritage by awarding true custodianship of sites, objects, remains to the newly created state agency, the Aboriginal Cultural Heritage Council. So I recommend the spirit of this bill. I know there will be disagreements, but Madam Chair, I highly support, through the people I've spoken to some Indigenous colleagues, I've spoken to other organisations, and I recommend the spirit of this bill to be put to the appropriate process in Parliament. So thank you very much, Madam Chair and Committee.
Hear, hear.
Thank you, Mr. Ponder. Would you like to go next, Mr. Duncan?
Yes. I'd like to acknowledge the committee and all parties involved in the committee. And I'd also like to acknowledge the Eora peoples, the Gadigal peoples of this land, in which I'm here on their country. And I am of the Gomeroi people and the Awabba people. I was born in Moree in northwestern New South Wales. That is also my mum and dad's side, and also my mum's side in the Awabba people, which is the Newcastle, Central Coast regions and Lake Macquarie. I put my hand up to speak on behalf of not just my people, but my family, my grandchildren, that I come here with my voice. I am the voice of my ancestors that I come here to speak to this committee. This Heritage Bill, which is, I think, one of the most important bills since the Land Rights Act itself, and I honour Mr. Fred Nile for being part of that, and Mr. Neville Wran, who was way ahead of his time in regards to the Land Rights Act, and to given some form of compensation back to New South Wales Aboriginal people. Our people, naturally, in the regards to colonisation and the effect that it's had on our people, which has affected us right up to here in 2022, where we sit right now, in regards to talking about full autonomy of our heritage. We're the only Indigenous people on this earth that don't have full autonomy of their own heritage. And I think, right here, right now in 2022, it's, I guess you can say it's about time, and that this would be acknowledged. Australia became signatories to the World Indigenous Peoples' Rights by Mr. Kevin Rudd when he signed that agreement. I'm not sure how much. I mean, they're not, they're not required to implement those articles, I suppose, of the World Indigenous Peoples' Rights into their governments. But I hope that they could take those articles to heart and to mind and introduce and look at a lot of those articles that are found within the World Indigenous Peoples' Rights, which would affect a lot in regards to the changes that we're talking about here with this new Heritage Bill. And I'm not sure how far the New South Wales government would go in regards to implementing some of those articles of the World Indigenous Peoples' Rights. I know there's in depth a lot of articles there that, touches on every aspect of what we're all talking about here in regards to how a body or a form and how this may come about in representing our people here to have a voice. I guess, it's a voice of respect, a voice of dignity, a voice of righteousness. And that's what I think, this voice would be in regards to establishing such an Aboriginal heritage body, that we can have some form of control and autonomy of our heritage. We had been incarcerated for well over 100 years in Australia. My mother was incarcerated, my father was incarcerated, I too was incarcerated until I turned around 15 years old. So it wasn't that long ago that we had some form of say, of voice with our culture itself. It desecrated our people, our language, our customs, our traditions, all these things that we as human beings in this world have the right to be who we are and to practice who we are. I guess in regards to the body, and I'd like to know how the structure of the body would be formed, who would make these decisions in regards to who sits on that body and who represents who. I know there's native title peoples as such, and there's also traditional owners, and there's also land councils. I think even though the New South Wales Land Rights Act is one of the most amazing acts in Australia, but it doesn't, we actually operate under a minister at the moment. It doesn't give us full autonomy as a land council. We still are guided or controlled by an act of parliament. And also in the way that the council operates, that only members can benefit from the land councils. If you're not a member, then of course I'm a member myself of a land council, but it's, the majority that are not represented. The majority. I mean, there's a whole lot of social, economic and problems as such with our people, and yet the majority of us are not represented by land councils under that current setup of membership of a land council. And so culture heritage naturally is one of those important issues that is covered within the Land Rights Act. So if you're not a member, then you have no say in regards to your own heritage. And that's wrong, totally wrong, I say. And I suppose also it creates divisions amongst our people. And in regards to the New South Wales current plan and laws and how they operate under National Parks and Wildlife, under OEH, under Forest New South Wales, all these current acts in relation to the plan and laws and the destruction of Aboriginal culture too. They call it, or they used to call it, a consent to destroy. I worked as a heritage officer for many years trying to preserve and protect our heritage. I've worked with Forest New South Wales, so I've seen the damage, I've witnessed the damage in regards to our heritage and culture, even including national parks and conservation laws, national heritage laws, native title laws. I don't know how all these, the body would work with all these acts of law in regards to that concerns Aboriginal culture too. I'm not sure how that would work with all these bodies. And removing our heritage out of National Parks and Wildlife Act in this body would give us full autonomy in regards to us spiritually and physically and our connections, and to revive some of those things that we have been, held back into identifying properly as who we are and who we have the human right to be as Aboriginal people. Our laws, our customs, our traditions, our beliefs and these should be respected properly and taken into account. And our self-determination should be respected too. This was something that was really big in New South Wales Land Rights Act. Self-determination was at that time one of the big statements, but I don't see that in 2022 since the Land Rights Acts, because I don't see that self-determination in our communities. All I see is the death and destruction of our people, and especially our young people. We are a proud Aboriginal people. We had sovereignty. We enjoyed these lands before European contact for tens of thousands of years. We had systems and laws in place. The kingship structure, which was mentioned earlier, the kingship structure is a law unto itself. It shows us how we treat one another, how we treat our wider family, the environment. It gives us that responsibility, and that is one of the most important words here, is responsibility, that we have as Aboriginal people to our lands and to our culture. I guess as a sovereign people, that we were at the peril of early Europeans when they arrived here. We were, at the peril right now, because after we were incarcerated for that over 100 years, that we then had to fight for our freedoms and our justice, and that's something that really hurts us deeply too as Aboriginal people. And it's something that, I've seen it in my mother's eyes, I've seen it in my father's, my grandparents, I've seen it in their eyes, and just their fight for us to survive and to get through this colonisation, as it affected us pretty badly. And to be the right to be who we are. I guess in regards to how the bill might work and what rights it might give us in regards to, a voice, I say they talk about a national voice now in Canberra, but what is our voice here right now in New South Wales in regards to our culture and heritage? And what voice do we have in the New South Wales Parliament? And I, some history of my family on my mum's side. It comes from the Awaba people, which is now called Lake Macquarie. I am a descendant of William Byrd, my grandfather, and Birrabin, who were well written about and well known. It was the first Aboriginal mission that it was established in 1826, when the Reverend Threckeld established that mission up on Lake Macquarie. My grandfather represented our people in the New South Wales court system, trying to fight for the survival of our people, from our people being arrested and sent to Cockatoo Island and Norfolk Island, eventually to Tasmania, for virtually fighting for their livelihood here. Naturally, we being close to where colonisation happened, and it affected our people immensely. The massacres, the smallpox, the destruction, Reverend Threkel recorded that in 1847, when the mission was near its ending, and he said that, you know, from thousands of Aboriginal people, there remained less than 70 people left of my people, which is pretty amazing. And I'm glad that I'm happy that I sit here as one of those 70 people of ancestors who survived, and that I survived. It almost wiped my family off the face of this earth, off the map of this earth. And yet I can now sit here and express my grandfather's and my people's voices in person. The state at that time was called New South Wales, the whole east coast of Australia. The colonial secretary recognised my grandfather's work and presented him with a breastplate, which naturally our people had. He threw the breastplate aside because he said that, you know, he wouldn't be seen walking around with a breastplate around his neck. They called him Master William, King of Sugarloaf Mountain, yet he was only 17 years old. And his older brother, Uncle Birrabin, also received that breastplate. They both sit in the Powerhouse Museum to this day, those breastplates. But what they did there was pretty amazing. And the colonial secretary of New South Wales at that time gave back what is known as what I believe to be the first land handback to Aboriginal people, which our family still have that document to this day, as the first Aboriginal land grant of 800 to 1,000 hectares on the western side of Lake Macquarie. But then coal was discovered and the land was taken. So the regions of our area of Sydney, Central Coast and Newcastle and Lake Macquarie, we see land councils there. But then these are made up of people who have, I guess, migrated from other Aboriginal nations into our traditional lands in those places. So under the current Land Rights Act, that these groups were formed as such in that way, but they always don't represent the true voice of traditional custodians of those lands. And I think when people might say or have the audacity to say, well, Europeans are the invaders, when I believe that some of these other peoples or Aboriginal people who have come from other areas to, especially in the Sydney, Newcastle, Central Coast and Lake Macquarie regions, they too are invaders of our lands.
Thank you.
And I truly believe that. And because we too are fighting for our identity against our own people, which is pretty amazing. And because, I guess, of money, greed, selfishness, there's a lot of this now that creeps into it because the land has become a commodity and not a spiritual and cultural connection of that land. And I guess, you know, under the Act too, that it gives the right for those to make decisions against people who have true blood and connections to those places. When we look at our birthright and our inheritance right as such, it's very hard to prove under the native title, and you almost have to be in a lap living in a cave to actually even prove your connection in that way. It's very, very hard for an Aboriginal person to prove native title today. It's Aboriginal law versus Westminster law. And how do those two laws work in with each other? And that's something in New South Wales that we have to think about too. So
Thank you.
Thank you.
Thank you, Ms. Duncan.
Thank
Mr.
you.
Owen, did you want to say a few things? Thank you.
Thank you. I acknowledge the Gadigal people on whose land we meet and pay my respects to all First Nations people of New South Wales. My words spoken today derive from long-term collaboration and discussions with First Nation elders across the state. I'd also like to acknowledge the words spoken by Mr. Duncan and Mr. Bondar and agree with all of them. My name is Tim Owen. I hold a PhD in Aboriginal archaeology. I'm a principal at Sydney-based consulting company GML Heritage. I'm an academic associated with both Sydney University and Flinders University in South Australia. I've worked professionally in the First Nations heritage field for the last 19 years, and I've appeared several times in front of the New South Wales Land and Environment Court and in front of numerous planning and assessment committees. I work with Aboriginal communities across New South Wales and in South Australia on a range of cultural, academic, conservation, and Aboriginal cultural heritage impact projects. I intend to highlight three aspects associated with ACH reform in New South Wales. The current ACH position, that reform is required now, and comment on the proposed ACH bill. ACH, or Aboriginal Cultural Heritage, is a very limited resource. It is progressively dwindling. This is exacerbated by the current MPW Act. Under this legislation, the definition of Aboriginal objects excludes all aspects of intangible ACH and does not recognise the rights of Aboriginal people as the owners of their culture and heritage. The MPW Act's objectives are to conserve Aboriginal objects, places, features and social values. However, practical function of this Act does not prevent impact to these aspects. The worst offending impacts are New South Wales' major SSD and SSI projects, which are able to circumvent the MPW Act, often disempowering local Aboriginal people through the process. I highlight the Shenhua Watermark coal mine project in the Liverpool Plains as an example of how Aboriginal people and their ACH can be sidelined and impacted. This project disempowered the native title applicant through the consultation process and clearly demonstrated the failings and manipulation of current government policy by both the proponent and Aboriginal people from out of area. When the MPW Act fails, the only recourse for Aboriginal people to prevent ACH impact is either the Federal IACHIP Act or the New South Wales LEC. However, I'm sure as you're all aware, going to the LEC costs millions of dollars. This is beyond the practical means of most Aboriginal people and groups. The IACHIP Act seldom results in a positive outcome for Aboriginal people. For instance, the case I just noted, the outcome was that the former Federal Environment Minister, in her findings on the Shenhua mine, found, and I quote, that the federal government was satisfied that the Gomeroi peoples, they were the native or are the native title applicant, specified areas were under direct threat of injury or desecration for the purposes of the IACHIP Act. Still quoting, the protections offered by New South Wales state law were not sufficient to protect the specified areas. However, the expected social and economic benefits of the Shenhua Watermark coal mine outweighed the impacts of the mine on the applicants, that's the Aboriginal community, and outweighed the loss of heritage value as well as the potential adverse social impacts on the community, including Indigenous people. It is an absolute classic case of demonstrating how legislation at every level is failing. I would therefore state that Aboriginal cultural heritage reform is needed. Aboriginal people have been promised ACH reform since 2010 or thereabouts. However, the Aboriginal community holds major concerns, especially an absence of government buy-in to the particular and current bill. At the New South Wales Aboriginal Archaeology Future Forum, which was hosted on the 26th of August this year by the Australian Minister, New South Wales Aboriginal Affairs presented on an update on Aboriginal cultural heritage legislative reforms. However, their presentation contained no mention of this bill. I asked the representatives specifically to outline their inputs into the bill and received a response that as a private member's bill, Aboriginal Affairs had no input, but rather was undertaking their own process, which would be reported to Parliament. We inquired about the timeframes for that and were told that there were no timeframes. The proposed ACH bill obviously aims to address some of the main issues in New South Wales. However, implementation will require a fundamental shift in everyone's mindset and significant changes to New South Wales land use planning, not to mention significant capital investment by this government in its implementation. I support the new ACH definition. It represents a seismic shift in thinking and better aligns with Aboriginal people's concepts of ACH. The Part 4 of the bill ideals the conservation and protection and should lead to some significant places being protected. However, it fails to understand that many places for which protection will be sought are not currently identified or known. Most matters I represent through the New South Wales legal system have arisen because of identification ensuant of an impact assessment. It can be foreseen that applications for protected areas will be seen by many as land loss. The government should therefore foresee the considerable pressures this process will place on the Aboriginal people and communities. Part 6 through Part 8 of the bill, management of activities which would harm ACH, hold levels of complexity which could take years to understand and implement. Most of the legal matters I have presented would never reach agreements through the proposed methodology, notably because the Aboriginal communities I work for have viewed the proposed impacts of the projects as entirely incompatible with their ACH values and therefore simply unmitigatable. Even at a simple level, the Part 6 management plans are asking Aboriginal people to now authorise destruction of their own heritage. Finally, the proposal for local ACH services is already causing friction, fractions and issues within Aboriginal communities. Many see the designation of areas as simply a way for local Aboriginal land councils to formalise power. Whilst in many instances it would be appropriate for a land council to become the ACH service, in many places such as Western Sydney, due to the long history of politics, disempowerment and local land rights issues, it would not. The Bill Part 6 Section 80 still requires consultation with local Aboriginal people, which does not resolve the perennial issue for Aboriginal traditional owners, as just outlined by Mr. Duncan. It does not empower the rightful owners of the ACH to speak and make decisions for their ACH. It needs to be thoroughly reviewed, in my opinion. In summary, the bill takes a giant step in the correct direction, but in my opinion, and the opinion of many Aboriginal groups and people, does not resolve some of the fundamental issues which currently exist. We understand the urgency of this long-term reform and support the momentum behind this bill, provided that it brings the Aboriginal community along and seeks to resolve some of the more complex matters that directly impact the health and mental well-being of New South Wales First Nations peoples today. Thank you.
Here.
Thank you. Thank you. So if it's okay, we might have a couple of questions. We don't have a whole lot of time, but I'm sure there are some questions from the committee. I would like to start with one, if I can. If anyone wants to go first, go for it. Jump.
Yeah.
Okay. Sure. Mr. Owen, Dr. Owen, can I just ask, have you been involved with the government's reform process at any point in the lead up to the 2018 and subsequent to that?
Yes, I've attended public forums, but also I've been the representative for ICOMOS. Hopefully you understand who ICOMOS are, you know who ICOMOS are. So I was their formal representative to the prior 2018 bill, being asked to input and provide cultural comment to what is now become Heritage New South Wales.
Yep. Thank you.
I'll go.
Yep, sure. Thanks, Mr. Barrett.
Mr. Duncan, I just want to make some statements and assumptions and then get you to comment on it because I might be well off the mark. But I'm guessing there's lots of Indigenous people that actually don't have a direct link or a direct contact with heritage sites. However, what impact does it have on those people? And I'm from Orange, I'm thinking some people in town there. What impact does it have on those people when Aboriginal heritage is damaged, even if they don't have a connection to it? And conversely, what impact would it have to enshrine this protection into legislation?
Are you talking about Aboriginal people
Yes.
who don't have any...
that direct... I'm guessing there's people around that I'd know in Orange that would never have visited a cultural site.
Yeah, I know Aboriginal people tend to just take it as it is, I suppose, in regards to having a voice or an opinion, and usually the ones that are in land councils would have all those opinions and voices, because they don't usually would take it to a public forum, but only to the members who are members of the land council of that area as such. But people who are not members wouldn't have no voice at all.
I guess what I'm thinking, like, even those people that don't have the direct contact, when they see or hear of Aboriginal sites getting damaged or whatever,
it impacts on them
and
very.
it still think, oh, here we go again.
Yes.
They're kicking the blackfellas.
Yeah, it does impact on all Aboriginal people, because these sites are like family, and that's the way we treat it as family, and because it's embedded in our social laws as such in the kingship structures. They're not just trees and sites and animals and plants, but they are actual family. And so it's that religious and spiritual connections to those things.
And so conversely, to enshrine protection into a standalone legislation, would that have a positive impact on these people?
Oh, yes, definitely. It would have a positive impact on them.
Thank you.
Yes.
Go for it.
Thank you, Madam Chair. Mr. Bondar, thank you for your submission. I don't know if you've read the transcripts and submissions over the last 2 days of hearings, and this is the last few minutes of the hearings, but clearly there's a division between land councils and land title type representation that's emerged. We've had some pretty strong criticism of land councils. We've had them called pro-development. We've had them called real estate agents. We've had accusations about people not being Aboriginal, being on the land, claiming to be Aboriginal, being on the land councils, developer influencers, outsiders, and earlier today we heard that they had a objective of economic advancement for Aboriginal people. Since you were ex-CEO of a land council, you've been involved in this bill. Do you think land councils are the appropriate body to administer that council that's proposed by Mr. Niles' bill, and 1 and 2? How do you respond to those accusations, criticisms that we've heard for the last 2 days of hearings?
Yeah, that's a great question, because I've been through all of that. I have to tell you, as chief executive, I've been through negotiations with developers. I've been through accusations of, doing something for economic benefit rather than for cultural or pastoral care. Let me tell you that land councils have to look after their own welfare, their own economic well-being. Without economic and entrepreneurial activities, they would be penniless in a lot of ways. So I can understand why a lot of land councils have been accused of being all of those things you've mentioned. The critical issue is, though, at the end of the day, and I remember I said to you that the bill ought to be accepted in the spirit of what it's intended. I recall, and just to my friend here, Kevin Duncan, when I was at the Land Council, we took about 30 Indigenous children to the sites that we inspected to show them the significance of passing down culture and heritage learning. Now, doesn't matter what you call a land council, they are not the panacea. But it's the only avenue you have at the moment, apart from what's being proposed in the bill. So land councils can be, and you've got to look at the regulations that will come out of the bill, because that's where it'll dictate how this will all work. But look, I accept the criticisms that people have done, but there are reasons for those criticisms. My understanding is that land councils have the ability, they do have the structure, but they'll need to be guided in managing a bill of this nature.
Would it be right to say to you that your view would be land councils still have to be involved in this bill? I mean, we're hearing clear evidence that there needs to be a broader base of engagement. I'm accepting that myself. But not at the exclusion of land council members. And I mean, Mr. Duncan, you're a member of a land council, and you've come here very passionately.
Yeah.
So, and you're not clearly looking to pillage the cultural heritage of our wonderful Aboriginal people. So they have to be at the table, have to be part of the discussion.
Correct.
Part of the process.
Correct.
Thank you. Dr. Owen, what's your experience with in your statement and evidence you gave the Shenhua example, how the registered native title claimants, their voice when they went to speak for country was completely alienated and other voices were listened to. How did that play out? Were those other voices land councils? Were they registered Aboriginal parties? How did that happen?
I speak with my understanding of the matter, so hopefully it's correct. The current process for consultation invites a proponent to require Aboriginal people to register when you undertake a project. It doesn't matter whether the project is very, very small or is very, very big. It is the same process. Under that registration process, the Heritage New South Wales currently hold a list of who you should invite. The issue exists is who is on that list, and there's another matter of how you get on the list. But then with that list, there is nothing to stop a party that is on that list and is then sent a registration invitation to then pass it on. And so we have seen examples, this is not the case study I was saying, we've seen examples where the list or an invitation to register is just passed from person to person to person to person. So then as a non-Aboriginal heritage practitioner, I have no right to then question who is registering. I have no ability to say, please tell me how you're connected. So in the example you were saying, or I cited, there are around about 80 registered parties.
We heard earlier, I think there was 114 or something at one point.
And so then you have to remember that a registered party could just be one individual, or it could be in this instance a land council, and the land council could have a membership of 400 people. Or it could be in this instance the registered native title applicant who has a membership of several hundred people. But then a proponent, let's not pick on example, a proponent is allowed to weight opinion however they want to across those registered parties currently. So a proponent might call a public meeting and 10 people might turn up out of 100, and then 9 people might agree to a particular action, and then the 10th, who's representing say 500 people, might disagree, but then the proponents say, well, 9 of you agreed and 1 of you disagreed. There's no requirement for weighting there, and they can then just table, well, the majority of people at the meeting agreed with action X.
That clears a few questions I've had in terms of where the actual breakdown or the alienation commences, because clearly we've heard many voices where they have been thrown out of the process at some point and had to find re-entry points. And as you said, the LEC is so difficult and the ATSIC Act is almost impossible thresholds to reach in terms of protection. So just in terms of the bill, and I know we are literally running over time now, so I'm very grateful. Last question from me is to you, Dr. Owen, just about this bill. If there is a state body that, such as the Aboriginal Cultural Heritage Council, that is an Aboriginal controlled, Aboriginal constituted state body that then works with the localised cultural heritage service bodies, do you think that it could be functional if there was representation from native title holders and or native title land councils and other voices? How do you see the constitution of that body? What should it look like?
To not answer your question first, I see it operating in the same way as the New South Wales Heritage Council under the Heritage Act. So everyone I've taught, all the Aboriginal community I've talked to would see it as Aboriginal people having responsibility for their own heritage. The composition of it, which is your question, under the Act, it specifically says that it should be a variety of people. It shouldn't just be formed by members of land council. So it actually says, I think there's 7 bodies and 3 of the positions can go to land councils, or 4 positions can only go to land councils. As long as the people on it are acting honestly and are able to check and balance each other, then a range of people from across the state with different levels of experience should create a functioning council of Aboriginal people who are able to speak for Aboriginal heritage. To answer another question you haven't asked, what happens when the ACH service says no? It gets referred up to the council and the council says no. What happens next? That would be my question to everyone. What happens next? Because the only then recourse for a proponent is to go straight to Land and Environment Court.
Do you mean says no?
No, so a proponent comes along and
Yeah, it
puts
says
up an
no
idea.
to the destruction of cultural heritage.
Yes.
Then
So-
it gets protected, doesn't it, under the Act? Isn't that the answer or not?
Yes, but then what happens? The act is then silent on what happens next. So
Yes.
then if it goes to Land and Environment Court, which presumably a lot of Aboriginal people will say we don't want to give permits or permission to impact ACH, I can imagine the Land and Environment Court will come very, very busy. And the question was who's funding then the ACH Council on all their visits to the Land and Environment Court? I think we have to sit back and look at the practical realities of implementation and the consequences of Aboriginal people actually saying no.
Thank you. Yes, thank you very much. Are there any final things that you would like to say? Because we are over time, and I apologise for running over time.
I'd just like to ask one question, just in relation to the Act or the bill. In regards to what has happened in the past and acknowledging those things in the past of Aboriginal people, and where or does or will compensation ever be considered?
For previous destruction you're talking about?
Yes.
I don't think that this committee is able to answer that right here and right now, but thank you. I think that that's a question, a very good question, perhaps, to close this session on, and thank you. Thank you all for coming today, for your time and your knowledge and your evidence. The committee's very grateful to all of you.
Thank you.
And that concludes our inquiry for the public hearings session for this inquiry. Thank you to everybody.
Thank you.